Yes. Call kar. Tumi call kar.
Said mentioning original say daily list to be mentioned item number 1.
Yes. Written notes of arguments were to be filed. Yes. Done. File kuruk.
No problem. My lord, apart from the written note,
Yes.
my lord, this Saturday we've received a notice, but admittedly under the instructions of Mr. Sengupta. My lord, kindly, if your lordship will take, well, of course, he is rightly advised them. Well, kindly have a look at this notice.
There's a scope of resolution, or
Possibly they've accepted their mistakes, which was complained of in the writ petition.
100% in the interview.
Yeah, of course, he's rightly.
100%.
Now that 15 days notice have now come.
So the matter then becomes infructuous.
Effectively. So, my lord, their actions then has in any event has to be set aside, which was under challenge. So then this
I do not know.
you do not know.
No, please check, Mr. Shen.
This
So that notice has been taken care of. So I'll record that and you can file your written.
I have to. আমাদের written note টা দিয়ে দাও। ও,
Petition is
great.
the written notes of arguments filed by the petitioner and respondent 1 today be kept on record. Full stop, next para. However, comma, in view of the subsequent developments, comma, such notes may have lost relevance. Full stop, next para. Learned senior counsel appearing for the petitioner hands over a communication by the Calcutta Stock Exchange to the petitioner dated May 17, 2024, comma, whereby it has been given out by the Calcutta Stock Exchange that in spite of a further notice and a last opportunity to appear before the stock exchange, comma, within 15 days from the date of the letter, comma, for adherence of compliances as applicable for listed companies as per CAPSE SEBI ACBI space diye LODR has been given to the petitioner. Full stop, next para. It has also been indicated in the letter that once again reasonable opportunity is being given to the petitioner for compliance of CAPSE listing regulation and CAPSE listing agreement as per principles of national justice. Natural justice. Full stop, next para. Since the plinth of the arguments of the petitioner were assailing the non-service of such notice before freezing the demat accounts of the petitioner, comma, in view of the said communication, a copy of which is kept on record, comma, the writ petition has become infructuous in a sense. Full stop, next para. Since the stock exchange now seeks to give another opportunity to the petitioner, comma, the previous notice which was assailed in the writ petition by necessary implication stands by necessary implication loses its force. Full stop. Accordingly, WPO 364 of 2024 is disposed of by setting aside the freezing of the demat accounts of the petitioner and directing the Calcutta Stock Exchange to comply with its communication dated May 17, 2024 by giving a fresh opportunity to the petitioner to comply with the listing regulation and listing agreement in terms thereof. Full stop, next para. No rest to cause urgency.
If your lordship is pleased to include one more thing, that in the event of non-compliance, the stock exchange will be at liberty.
Needless to say, comma, in the event of non-compliance, comma, the stock exchange will be at liberty to proceed in accordance with law.
In accordance
Great.
with law. Great. Copy দেবো?
Court application item number 2, Deep Chakraborty versus State of West Bengal.
The petitioner
Yes.
is an advocate, applied for the VC link virtual hearing in the Srirampur court, junior division and fast track court,
Yes.
second court. That has not been entertained and virtually refused. There is no some mechanism. Whereas there is a system, government has installed everything. I do not know why they are refusing it. let the response be taken up. Why they are actually.
Mr. Kalip, can you take take instruction on this? I mean, whether that system is in place. If it is in place,
Lordship, then I have to, I'll be considered
take an
judicial
instruction.
secretary,
Take,
Lordship.
take instruction from through your channels. I mean,
Lordship.
Mr. Dotto, these should be taken before the zonal judges who are in charge of these districts. I mean,
If your lordship desire to refer the matter, I have no problem.
that has to
Registrar
be in
General?
administrative capacity.
Yes.
Registrar General, Lordship.
I'll give you that liberty. I'll give you that liberty, Mr. Dotto. He's right. Mr. Galib is right. I'll give you that liberty to uh, approach the Registrar General. In my order, I'll give that. Approach the Registrar General who is to take up the matter with the learned zonal judge of the concerned district. This
Yes,
is
yes.
Hooghly.
Hooghly, Hooghly.
Hooghly, Lordship.
Hooghly থেকে charge আছে।
Wait. The writ petition has been filed by a learned advocate of the Srirampur court with the allegation that when the petitioner sought a video conferencing link for appearance before the said court, comma, the same was not provided, comma, despite due infrastructure being available in the said court. Full stop. Next para. Since certain concerns have been raised by the petitioner, even as to the availability of proper facilities in the said court for video conferencing, and as to certain perceived irregularities in providing the links to litigants and advocates, comma, it would only be appropriate if the matter is taken up by the by this court in its administrative side and be channelized to the learned zonal judge having charge of the district Hooghly. Full stop. Next para. Accordingly, WPO 490 of 2024 is disposed of with liberty to the petitioner to make a representation before the Registrar General of this court with the issues as raised in the present writ petition. Full stop. If such a representation is given to the Registrar General, comma, the Registrar General shall forward the same through the Honorable the Chief Justice to the Honorable Zonal Judge in charge of District Hooghly for looking into the matter in the administrative side of this court and take a decision in accordance with the discretion of the said Honorable Judge. No or less to cause certificate.
Decision be communicated, otherwise I will be in the, again.
This order, serve a copy of this order you annex with your
No,
representation.
the decision be communicated, otherwise Registrar General after taking, what steps he is taking?
You communicate
No,
with
I will communicate, but what decision has been taken from the administrative side?
Oh, after this?
Yes, yes. If there is no time frame, then I will again have
No,
to come.
take up the matter with the zonal judge.
I have to file again writ petition.
If you
Kindly,
file and
kindly,
reject
kindly,
this,
kindly consider it,
no,
the issue.
no, I will not direct the registration. Yes.
Item number 3, Deep
Lord-
Chakraborty and
Yes,
Mr.
my lord, in this matter, I have raised the issue.
Some other court?
No, in the same very court. Issue is the civil rules and order in our high court sides. There is a prescribed procedure for court hours. Court hours is 10:30 a.m. to 4:30 p.m. and
Yes.
half an hour is the interval. The allegation is this: the civil judge, first court, Srirampur, completely disobeying this system.
No, you have
as-
to approach the district judge. I'll dismiss this matter.
I have already made the party district judge. I have made a complaint
Have you written a complaint to the district judge?
to that effect.
Have you? Yes. Have you complained to the district judge? You have to go. District judge is the administrative head of the district.
I have already made in this writ petition. my lord. That
District judge cannot be made a party unnecessarily. I'll reject this writ
So
petition.
one prayer is this: that
Definitely not.
let the matter be listed after
Everything
vacation.
can.
After vacation, then
No, no. The petitioner alleges
Even the
that
concerned civil judge also is by name, she is a party, Lord.
yes. Otherwise, there is a allegation against him.
And several allegations have
Yes,
been laid in different
that has to be
paragraphs, Lord.
adjudicated.
Kindly cease para.
That
the
has
writ petition has been preferred with allegation that the respondent number 6, comma, a judge of the Srirampur court, comma, has not been adhering to court hours. Full stop. Next para. However, comma, there is no scope of interference in the writ jurisdiction, comma, since nothing transpires from the record to indicate that any complaint in that regard has been made before the learned district judge Hooghly in that regard by the petitioner at any point of time. Full stop. It is well settled that the district judge is the administrative head of the concerned court, and having not approached the district judge, comma, the present writ petition cannot be entertained by this court. Full stop. Next para. it is further recorded that the practice of impleading a particular judge by name is strictly deprecated by this court. Full stop, it is expected that the petitioner, being himself an advocate, should desist from doing so on future occasions. Full stop. WPO 491 of 2024 is accordingly disposed of with liberty to the petitioner to approach the learned district judge Hooghly with the grievance as raised in the present writ petition. No address to cause urgency report.
Lord, the name is concerned, the Supreme Court says
No.
that,
Whatever Supreme Court says, don't name the judge like this.
if there is specific allegation, then otherwise, because I am not the
Mr. Dotto, this is not an allegation of such a nature that you have to name the judge. Definitely not. She is not sitting in time. There may be several reasons. You are breaking the decorum of the court. Is there any allegation of fraud or forgery against her? Why are you naming the person? They require our protection from us also, Mr. Dotto. This is absolutely malpractice. Don't do this. Don't do this. I'm telling you specifically. This was intended to the petitioner, but it also applies to the learned advocate for the petitioner in this court. You have to be more careful. This is not an occasion to name the judge. Definitely not. I'll take up audience side matter হয়ে গেছে তো আমি একবার উঠে আবার 5 মিনিট বাদে আচ্ছা ঠিক আছে I'll continue. Appellate side. Yes.
বলতে যাও আমার আগে বলতে দাও কি বলবি
I have a mentioning, my lord.
বাচ্চা নেই
দাঁড়াও মেনশনটা বলুক আগে ডাকুক
আচ্ছা ঠিক আছে Yes ma'am, from Port Blair. Yes, what do you say?
Yes, my lord. I am Lavanya Sundari from Port Blair. My
Yes.
case has been assigned to you, sir, on 16th of this month, May.
Yes.
A review has been filed during March of 2023 and submitted before the Honorable Justice
Ma'am, I'll be sitting in the Port Blair circuit from 10th of June. So please just mention it there and I'll consider. I'll consider.
Actually, I want. Actually, it's a long delay, my lord.
I
Not yet given.
I appreciate, ma'am, but we have only one more day before vacation.
Yes.
So immediately after the vacation, I'll be sitting there. Please mention it there. I'll definitely take up.
No, I want to do hearing in the VC only, if possible,
Yes,
my
yes.
lord.
This is also available in Andaman. Please mention when the matter is taken up in Port Blair.
Under
Thank
the
you.
compelling circumstances, my lord,
Yes.
I have filed one writ application. I have also prayed, my lord, to leave to file, my lord, on the last day. Lordship directed me to file in, my lord, in the, my lord, department and to mention, my lord. Here what happened, my
No, I
lord.
did not direct you to mention.
But your lordship, my lord,
Definitely not.
very well, my lord. Now, my lord, thing is this.
File it will appear in due
My
course.
lord, I have filed, my lord, to
No application. No.
no, matter has not been listed as yet, my lord. If you
When
lordship
did you
file,
file?
my lord, on Monday, my lord.
Monday list আসেনি কেন? Give the number.
My lord, kindly, my lord, take it to my lord.
Monday when? Second half.
Second number, my lord. But if you lordship
Then
kindly
how
take
will it appear? It
my lord,
appears after
Friday
48 hours.
because I may be, my lord, disposed from
Maybe,
my lord
maybe.
property at
দেখে
any
নাও
point
কেন
of
আসেনি
time, my
দেখে
lord.
নিন।
Matter will
Yes.
be taken up, my lord, on
It's
Friday.
called on the list now.
For judgment.
No.
Another thing is that
No.
today morning, what happened, I have filed a writ petition challenging the order of termination of my lease. And what happened, they have not taken. I filed the writ petition.
No.
They will be disposed, my lord. My
No,
goods are lying there, my lord. I cannot-
Yes, call on the list, please.
For judgment, item number 1.
I said no further mentioning. What is this for? Rectification handover, always I think. Item number 1, yes. Accordingly, WPA 8243 of 2024 is allowed on contest, thereby setting aside the results of the election dated March 10th, 2024, held for the Siddha Town Rajarhat Residents Association of Apartment Owners and all consequential actions taken in pursuance thereof. The EC which conducted the elections shall recount the results of the election by including the votes cast by the residents of the Magnolia block in respect of both the regular ballot box and the home collection ballot box, since the disputed voter Veena Singh did not vote at all. For such limited purpose, the designation of the EC, including its presiding officer, shall stand suspended till the process of counting and the declaration of the results and the communication of the same to the competent authority is over. The said committee members, including the presiding officer, shall, for the limited purpose as indicated above, act as an ad hoc body appointed by the court to complete the said elections. Upon such recounting being done, The said ad hoc body comprised of the presiding officer and the members of the election commission shall declare the results and duly communicate the same to the CA competent authority, who in turn shall do the needful in terms of the 1972 Act and the bylaws to give the stamp of validity to the same. It is expected that the entire process shall be concluded within June 30, 2024. There will be no orders to cause urgent certified copy.
Yes, sir.
Grateful, my lord. Grateful.
Item number 2 for judgment.
Happiness or sorrow, Mr. Sorry to the petitioner. I mean, in such view of the matter, WPA 12929 of 2024 is dismissed on contest without any orders to cause. It will be on the website soon. আগেরটা সই করলাম, আগেরটা
To be mentioned, item number 3.
এতগুলো to be mentioned.
Well, Lordship's last order, my lord, Lordship had directed, my lord, inspection to be done. That has been done, my lord. And that was the contempt, my lord, act of contempt which was alleged, my lord. Therefore, my lord, this application, my lord, may be disposed of, my lord, by leaving the authority.
You offer the alleged contempt? No?
Yes, it was done yesterday pursuant to your lordship's direction.
Thank you.
But since my officer has inspected the, I have requested.
No, that has to be kept on.
Hand over the, my lord, inspection report. Although we have not party to these proceedings.
Acha. Learned counsel for the petitioner submits, as corroborated by learned counsel for the other parties, comma, that an inspection has been done pursuant to the order of this court, comma, thereby rendering the contempt application infructuous. Whose of a copy of the handwritten report is handed over by learned counsel for the WBSCDCL, for the WBSCDCL, which is kept on record. Full in view of the above, comma, CPN 1161 of 2022 is disposed of as infructuous. Thank you.
Grateful to your lord.
Thank you.
Item number 4.
For the petition in this matter,
Yes.
kindly peruse my lord's order dated 20.
Kindly,
It did not trouble your lordship.
kindly,
On 20th, your lordship desired that PPO should be issued.
kindly issue
I
short
sent an email.
passover.
On 20th itself, PPO has been issued.
My lord, kindly short passover.
Refused. I'm refusing it. Yes.
No, kindly see this.
একটা কপি দাও দাদা আমাদের একটু দেখে নিন।
Mr. Chakravarti, can a copy be given to Mr. Mr. Mana? I will not keep it pending further. Thank you very much for the intervention.
It has been distributed.
Mr. Bhattacharya was absent.
No,
So I had to.
no, I address both of you. Thank you very much. Learned ASG appearing for the alleged contemner hands over a copy of the PPO issued in favor of the petitioner. Full stop. As such, comma, no further purpose would be served in keeping the contempt application pending, as the order of this court has been complied with fully. Full stop. Hence, the CPN 17 of 2024 is disposed of as infructuous, keeping on record the copies of the documents handed over in court today. Thank you.
কি বলে?
Yes.
Item number 5.
Preparing for the petition.
Yes.
My lord, at the outset, I would want to tender my unconditional apologies.
Why? What happened?
Lordship, the problem which is,
No special messenger cost by you.
Lordship, I was under the impression that steps have been taken, Lordship, on part of the petitioner by my clerk, Lordship. I'm apologizing for that. Lordship, it was taken on the 20th. Lordship, nonetheless, Lordship, the contender, Pradut Kumar Ghosh, Lordship, he is no more the finance officer. And this transfer happened during the pendency of the contempt application, Lordship. So, Lordship, that's why I had prayed for an amendment, Lordship. I had mentioned.
So then I'll recall the rule. I'll recall the
Lordship.
learned counsel for the it transpires from the report dated May 21, 2024, given by the office, that the rule could not be served as no special messenger cost has been deposited as yet by the petitioner. Full stop. Next para. Learned counsel for the petitioner further submits that the learned counsel for the petitioner apologizes for such default on the part of the petitioner and further submits that in the meantime, the alleged contemner named in the contempt application has demitted office stroke been transferred from the office, and now a new incumbent has come in who has to be implemented in the contempt application. Full stop. Next para. In view of such submission, comma, the rule bearing WPCRC 83 of 2024 is recalled and discharged. Full stop. Leave is granted to the learned advocate on record for the petitioner in the contempt application to amend the cause title of the said application, impleading the new incumbent in the concerned office, and to serve copies of the contempt application on the said added alleged contemner, indicating that the matter shall be listed in the monthly list of July 2024. Full stop. On the next date of hearing, comma, an affidavit of service shall be filed by the petitioner.
Obliged.
Please carry out the amendment immediately and serve
Hello.
quickly.
Fine.
Yes.
Item number 6.
My lord, I beg to appear on behalf of the petitioner.
My lord, I am for the state, my lord.
Yes. What?
The
What
last
is?
order, my
Yeah. Last order. What did they do?
my lord, order dated my lord,
10th April, my lord.
10th April 2024, my lord, where your lordship.
Oh, you are seeking a correction in this.
My lord.
Yes.
My
What
lord,
is the
two
correction?
corrections, my lord. One correction is, my lord, the deed number is 1413 of 2000.
What is this?
My lord, the report of there is a
We are ready to hand over the deed, but the difficulty is, my lord, the year in the order mentioned.
It was already delivered.
my lord, the year is wrong, my lord.
Could be 2006,
It
my
could
lord.
be my lord 2006 instead of
Very well.
My lord, another
Which paragraph? Tell me the paragraphs.
my lord, paragraph number 6, my lord.
6 paragraph.
Para 6. The number will be the
2000
date.
My lord, year should be 2006 instead of 2005, my lord.
2006. What else?
Another, my lord, para number 4, my lord, where we have the additional district sub-registrar Guma has requested respondent number 1, my lord. It was just
The reverse.
reverse, my lord.
Requested respond number 1.
Respondent number 1, his higher authorities. Only these two corrections, my lord. We will hand over, my lord, the deed.
Not the respond number 3.
My lord, respondent number 3 requested respondent number 1. The ADSR Guma requested his higher officials, my lord.
Hands over report and submits to the IGR. The Inspector General of Registration has already written repeatedly to respond number 3.
This will be just the reverse.
He has written to IGR.
Instruction also says, my lord, there is already.
No, it's
recorded,
already.
my
Yes.
lord.
Very well. 2 mistakes in the order dated April 10, 2024 are pointed out by learned counsel for the parties, which are clerical in nature. Push up in paragraph number 4 of the said order, comma, it was recorded that the IGR has already written repeatedly to the respondent number 3, that is the additional district sub-registrar Guma, to send the document in question, whereas in reality, comma, it is just the reverse, comma, that is, comma, the respondent number 3 had written repeatedly to the IGR within bracket Inspector General of Registration. Full stop. Next para, in paragraph number 6 of the order, comma, in the 4th line, comma, the year 2006 has been erroneously mentioned as 2005. Full stop. Next para. Accordingly, let the order dated April 10, 2024 be deemed to stand corrected to the effect that in paragraph number 4, comma, it would be understood that the respondent number 3 had written repeatedly to the IGR, and in paragraph number 6, comma, the year shall be 2006 instead of 2005. Full stop. This much. What is, you can keep this document, ma'am. I'm not referring to this. You can keep it. You are saying that is sufficient. Both of you are saying. Yes.
Item number 7 for correction.
My lord, there is the advocate on record's name is not recorded in the
Not a ground.
order sheet.
No order need to be passed. Next.
Item number 8 and 9.
My lord, I appear for the petition. I'm led by Mr. Roy Chaudhary, but may I make one submission on fact as to what has transpired since I was there physically present on the last occasion.
Right.
My lord, when the matter was taken up, the contemner appeared and tendered unconditional apology, accepted the contempt, tendered unconditional apology. Mr. Thakkar made a categorical submission. Then the appeal from your lordship's judgment had been withdrawn before the honorable division bench. In light of that unconditional apology, my lord, what happened thereafter, lordship has recorded that in the order on the last day. The contemner stepped outside the court after the hearing and filed a recalling against the withdrawal. The matter was listed before the division bench on Monday, when submissions were made that your lordship's order is completely wrong, the judgment is completely wrong, and therefore the appeal which had been withdrawn, that order should be recalled. Well, this, and we've asked for a copy of the application before the hearing, during the hearing, after the hearing, not provided to us. But from the submissions which were made, we can gather that the ground in the application is that the judgment is wrong. Malad, this has all of this has happened after that unconditional apology was tendered. That is all that I wanted to point out to my lord. May I leave it to Mr. Roy Chaudhary, my lord? Because he's leading.
Unconditional apology, my lord, it has to have some sense, my lord. It can't be an empty formality.
The withdrawal application, you haven't got a copy of the
recalling application, my lord. We've written to them. They've not provided us the copy as yet.
Right.
My lord, your lordship can call for the record and your lordship can have a look at
No,
it.
need not. Let me hear Mr. Bose first.
My lord, Mr. Thakkar was present on the last occasion.
Yes.
My lord, possibly this is a factual correction. What my
Mr. Bose, your client is present in court today?
Yes, he's absolutely present here.
My lord, may I have your lordship's leave?
Yes.
Lord, this is
Yes,
the
Mr.
affidavit.
Thakkar.
My
Who
lord,
wants
since
to ask Mr. Bose or Mr. Thakkar? I can hear
My lord,
only.
kindly permit me, my lord. I'm sorry because
Also
this
arguing, you're also arguing. I'll hear only one of you.
Yes, absolutely.
Whom?
My lord, I was just indicating, but since Mr. Thakkar
No, you cannot
was
indicate
present,
together, Mr. Bose. Either I'll hear you or Mr.
I'm sorry, my lord. I'm sorry, my lord. I'm sorry. I'm not in Calcutta today, my lord.
Yes, Mr. Bose.
I'll just indicate, my lord.
Right.
My lord, this is a submission which is completely
What is the
confined
current
to an act of,
position?
this is completely prejudicial.
What is that affidavit,
My-
Mr. The affidavit of unconditional apology. That was to be
The
filed.
first one is 58 and the other one is 59.
Yes. Let me see that. What is the apology? Which paragraph,
My
Mr.
lord,
Bose?
paragraph 2, 3 and 4, my lord. 2, 3 effectively, my lord. Para 2, my lord.
Yes.
Now, my lord, I'll just indicate.
Yes.
My lord, your lordship issued a rule. Well, against that, there is an appeal.
Definitely.
My lord, that appeal, my lord, has been released on personal ground by 2 of the division benches. Now it has been assigned to another division bench. So that is what was mentioned. I'll tell your lordship what had happened. My lord, your lordship recalls, my lord, from your lordship's order, which is in contempt, the order against which contempt has been alleged, against that order, there was an appeal. My lord, that appeal was withdrawn long time back, my lord, when the matter was before the Bar Council of India, and there was an indication in the order of the Bar Council of 18th December that, my lord, the complainant before the Bar Council of India should take steps to withdraw the pending appeal before the High Court. So, my lord, based on that, it has been withdrawn. And, my lord, that order of the Bar Council of India is under challenge before your lordship in a separate petition altogether. So, my lord, so that appeal which has been withdrawn, my lord, against that withdrawal application, there is a recalling application which has been filed before the division bench to recall that order of withdrawal. So this is possibly what they are pointing out. Well, it is not that after this or after what had happened on the last occasion in court apology. Well, so the unconditional apology is completely, well, it was tendered then, it has been tendered now as well. So all we've said, well, there has been no deliberate.
This is not an unconditional apology, Mr. Bose.
My
Your
lord.
client should be behind the bars. I'll
If
send
your
him
lordship
right
will
from
kindly
here.
see.
Read out, please.
My lord.
Please read out. Paratun. Your,
At
advocate is
the
your
outset-
client is an advocate.
Yes, my lord. At the outset, I tender my unqualified apology for any act or omission.
Please come to I humbly and sincerely pray for forgiveness. Para 2, page 5.
Yes, my lord. I humbly and sincerely pray for forgiveness if any unintentional and inadvertent act of or omission.
If there's an if, Mr. Bose, it cannot be unconditional. Your apology has to be in a single sentence. It has to be unconditional. This is a play of words, Mr. Bose. All of us can play with words.
Yes, absolutely.
And some of the words may be very ominous also.
But the intention is
the
clear, my lord.
outset, you tender your unqualified apology for any act or omission, which
Absolutely.
may be constituted as violation of the order dated such and such,
My lord.
and you humbly say that you have the highest regard, very well lip service,
My lord.
and never deliberately or willfully committed. This is a denial that there is any contempt. This is not an unconditional apology. This is not called an unconditional apology. An unconditional apology has to be unconditional, Mr. Bose.
Absolutely, absolutely.
I humbly and sincerely pray for forgiveness if any unconditional, if any
unintentional,
inadvertent.
inadvertent. My lord, that is, my lord, unintentional. My lord, we are saying that, well, if your lordship will kindly.
Anyway, since you have preferred an appeal against the rule, Mr. Bose, I would not form any preconceived notion. Let the appeal court decide. We have to be fair on that also.
Well, he
but I'll
admittedly
keep it after the vacation. I'll keep this on record. I'll decide on whether this is an unconditional apology later on. So has the appellate court, in the appeal, Mr. Bose, against the rule,
my lord,
has there been any stay of personal
Lord,
appearance?
it's not been listed. The honorable division bench
You have
did not
filed it?
sit. It is listed, but it did not
Ye-
sit
ye-
on the yesterday because it's in the appellate side.
Okay, then the personal appearance remains on the next date also. Two affidavits have been filed by the alleged contemner. First up, although the alleged contemner has stated in paragraph number 2 of the said affidavits that the alleged contemner tenders his unqualified apology within double inverted, comma, the same is in fact qualified by the subsequent expression that he humbly and sincerely prays for forgiveness within double inverted if any unintentional and inadvertent act or omission on his part has resulted in violation of the order dated December 13, 2023. Double inverted close, full stop. As such, there is some doubt as to whether the apology is actually unconditional or merely a lip service. Full stop. Next para. Be that as it may, comma, before taking a final call on the acceptance of the said affidavits, comma, judicial propriety demands that this court should await the outcome of the appeals preferred against the rule issued by this court. First up, next para, learned senior counsel appearing for the alleged contemner submits that the said appeal has been released by 2 division benches and has not yet been listed before the 3rd bench. Pushed up, hence, comma.
It has been listed. But
Has,
the bench
has not yet been, has just been listed before the 3rd bench.
not been taken up for consideration.
Pushed up, since the matter has not yet been taken up as yet, comma, to await the outcome of the same and or whether any interim order is passed therein, comma, let the contempt application stand adjourned till June 14, 2024, when it will be listed under the same heading, full stop. The alleged contemner shall be personally present on the said date as well. At 10:30 করে দিও ওটা।
But I know, my lord, I do not deserve any further indulgence, my lord.
Yes.
Instead of 14 June, my lord, could it be the first week of July?
No.
It's traveling, but that's only.
I'll cut short your travel.
No, but I entirely leave it to your lordship.
Cut short your travel.
At
Rest
least,
assured, Mr. Bose, I'll cut short your travel if there is no order by that date. Next one.
New motion.
Lord, in fact, my lord, 14th, if you
Mr. Bose, I'm not bothered with whoever is standing behind you.
no, that
Advocate,
well, your
doctor,
lordship, well,
judge, my own relative, me.
well, I would be the
Doesn't
last
matter.
person, my lord, I would be the last
You know
person
that,
at least
Mr. Bose,
before
all of
this
you know
court.
that. All of you know that, Mr. Bose.
Absolutely. We
When I
all know
sit
that, not
here,
before this court.
I leave my emotions regarding my
Completely.
advocates being my brothers or sisters
Completely.
or whoever. I leave that outside the courtroom. So, and
But
this is a
since-
contempt application.
Well, since the affidavits have already been filed, my lord, your lordship will completely decide
Not
this
yet
issue.
accepted those affidavits.
No, of course, I don't say that.
Yes, you have filed.
Correct. All I seek
Those
a
are
few more weeks. That's all. Nothing more than that. Nothing more than your
I'll give
lordship
you
will finally
I'll give
decide.
you one more week, Mr. Bose.
I leave it to your
21st,
lordship. my lord.
I can
leave
keep it
to
on
your-
21st.
I leave it to your
তাহলে
lordship.
14th না করে 21st করে দাও। It will appear on 21st.
But in the meantime,
নাম্বারগুলো
I
ভুল আছে?
request my learned friend to make over a copy of the can.
Line add করে দাও, leave is granted to the learned advocate on record for the alleged contemner to rectify the captions of the affidavits filed today. Mr. Bose, please instruct your learned advocate in record to rectify the numbers. The contempt numbers have been given incorrectly.
6869. Oh, 5859.
Do that immediately and
We
hand
will
over.
do it right.
Yes.
Right.
Call on
It
it.
has followed.
My lord, that
New
application
motion.
should be made over, my lord, in the meantime. That can.
I'll not pass any order on that.
Grateful.
You can take that point before whenever it's.
Grateful.
New motion, item number 10.
Yes.
Sign code. Sign code.
There's a short.
Petitioner, my lord, Lordship has already pronounced judgment last week, my lord. On 16th May 2024, this is also a writ petition directed against the Learned Commission. Well, this is also an order passed relying on advisory 14, which Lordship had set aside because it had been set aside previously by a coordinate bench of this.
Have you got the copy of that order?
Lordship, we have, Lordship.
Please
May I hand over?
Lord, may I put my hands up and say I did not appear?
Mr. Kollul Bose yesterday submitted that he had won a matter before me and that the appeal, he lost in the appeal. And immediately he put in the sentence that he was led by Mr. Probal Mukherjee in the appeal. So he faced the wrath of court after that in a very...
No, I faced the wrath of my client, the chairman of the commission. No, I could not come. I could not reach.
It's very difficult to match your wit, Mr. Chen. Very difficult. And I don't try to even.
No, very difficult, expert.
Completely got off my mind and I'll just... Oh, there was a previous direction by another court. The striking down that advice.
Lordship, there was a judgment striking down these advisories as being without the authority of law because the Act provides.
So I relied on that striking out and I struck out this.
Lordship.
Yes, Mr. Chen, what do you have to say?
Well, may I just show the page of that impugned order in this case? It's page, the order starts at, my lord, page 142. And if Lordship kindly...
142.
42, Lordship, that's the impugned order.
Yes, 142.
Impugned order.
Impugned order. 5th March 2024, Lordship will kindly turn to page 143. The third paragraph, the CA has billed such and such. We have examined the bill. We find the medical and consumables have been charged at MRP. They have not given any discount as per our advisory 14. And thereafter, Lordship, similar to what was stated in the previous impugned order, which was struck down by a Lordship, Lordship will see page 144, is it the same observation. We have examined the judgment. The matter is sub judice before the division bench. In any event, advisory 14 has not been touched upon. We thus direct the CE to adhere to the direction of payment of discount.
It was not touched upon, it was thrown out. That is what they meant. By the other bench, obviously, not by... Anyway, well, so this is all. Let me hear Mr. Chen. Yes.
Lord, may I take your lordship a little back to the judgment which your lordship relied on?
Absolutely, yes.
Well, your lordship will ask me why should I go behind my own order of 16th of May? Lord, I can only quote, Lord.
Because that was the premise of my order also. Yes.
Lord, I can only quote an anecdote which my revered late senior Mr. Pratap Chairji told me before his lordship, Honorable Justice Ajoy Nath Rai.
Yes.
Lawyer handed over a judgment of Justice Roy, late Justice Roy, to his lordship. His lordship said, yes, I was waiting for this. I was waiting for an opportunity to say I was wrong.
That happened to me, but regarding a different judge. I mean, I had cited, yes, I was waiting for this. I'll distinguish this.
Now, so far as your lordship has given a construction to the judgment of my Lord Justice Moushami Bhattacharya.
Yes.
But my respectful submission is that judgment which is at page number match 123
of the
page 123 of your lordship's brief. Now, the challenge was to the advisories which related to fixation of rates and charges.
Yes.
Now, if I may just show a bit of this judgment, your lordship please comes to page 124, the fourth line. The petitioners pray for a declaration as well as for mandamus with regard to certain advisories and an order dated 2nd July 2021 issued by the respondent, the commission. Now, my lord, if your lordship please takes paragraph 3. According to learned counsel appearing for the petitioners, the impugned advisories and order were made without jurisdiction and are contrary to section 38(1)(4) of the Act. Counsel submits that the power to issue advisories is circumscribed by the Act and specifically section 38(1)(4) thereunder. Counsel relies on the specific provisions of section 38(1)(4) giving power to the Commission to fix rates and charges and urges that the Commission cannot hence exercise those powers under residuary provisions of the Act to fix rates and charges for the clinical establishments in the state. This is the subject matter, Lord, of the writ petition. Now, Lord, if your lordship please comes to the operative portion, Lord, one other paragraph, Lord, page 127, paragraph 8.
Yes.
The advisories which are of concern to the petitioner are related both to fixation of rates and charges by the clinical establishments and include charges levied by pathological laboratories, including home collection for conducting COVID tests, advance payment, charges at the time of admission of a patient, providing daily updates regarding billing modes of payment, all relating to charges. Now, Lord, please come to the operative portion at page 141, paragraph 41.
Yes.
The advisories and the order are unconstitutional and are not binding on the petitioners. But my respectful submission is the advisories means those advisories which relate to capping of rates and charges. And I'll tell you, Lordship, why not the very next sentence makes it clear. The West Bengal Clinical Establishment Regulatory Commission shall therefore recall and rescind the impugned advisories and are prohibited from giving any effect to the impugned advisories and order to the extent of fixation of rates and charges for clinical establishments, including the petition number 1, in a manner which is contrary to 38(1)(4). So, it's restricted to those advisories which require approval and regulation by approval of the state government in terms of 38(1)(4) and are relatable to fixation of rates and charges. But for a moment, may I show you, Lordship, 38(1)(4.
এই তো ক্লিনিক্যাল স্টেজ আচ্ছা ওই যে দিচ্ছেন উনি
Lord, if your lordship please comes to section 38.
আছে দাও এটা লেটেস্ট এটা থাক
Lord, section 38 sets out various powers of the commission. They run from 1 to 10. Lord, please first come to 38(4), 38(1)(4).
Yes.
Make regulations with regard to fixing of rates or charges of indoor patient department and outdoor patient department treatment, including diagnostics, and also to ensure compliance with fixed rates and charges by clinical establishments. Now, Lord, this has been held, the advisories which have been issued, which are really administrative instructions, they have been held to be ultra vires the statute, not in consonance with the statute, because it required the state government to give approval in terms of section 52. I'll just show that for your lordship's convenience.
So the advisories here were by the commission itself?
Without approval.
Yes.
It says with the previous approval of the state government. So the advisories which related to 38(1)(4) have been set aside. And this commission has been asked to rescind them. But what about advisories which are not in terms of 38(1)(4)? Does the commission have such power? If your lordship comes back to 38 for a moment. If your lordship please takes the beginning. The commission shall, 1, monitor the functioning of clinical establishments. 2, regulate and supervise functions of clinical establishments as prescribed. As prescribed means as prescribed by the rules. So I'm not relying on this because there are rules which do not relate to this.
Yes.
I'm on 38(1), 38(2). Examine and consider complaints filed manually or electronically through an online system in matters related to patient care services, deviations from declared fees and charges,
refusal of supply of copy of medical records and allied matters. Please note the next motion. Alleged irrational and unethical trade practices alleged before the commission by aggrieved patient parties against clinical establishments. Issue notice, hear both parties, adjudicate, compensate, pass such other orders as are deemed appropriate.
Yes.
Now, not unethical trade practices. Lordship will please come to section 2Z.
Yes.
Trade practice. Trade practice in relation to a clinical establishment means any practice relating to the provision of services by a clinical establishment and includes anything done by the clinical establishment which controls or affects the price charged for services rendered by the clinical establishment or the method of providing services by the clinical establishment. So, Lord, and Lord, one other provision, please come back to 38. Please see 5. 4, I do not have the power. The High Court has said so. It's in appeal, but there is no stay. So I ignore 4 for the time being. Please come to 5. Enforce transparency in dealing with patients by the clinical establishments. So these are powers which have been conferred on the commission, which the commission is duty bound to perform under the statute, monitoring the functioning of clinical establishments, examining complaints, including relating to charges levied, and enforce transparency. Now, what your Lordship will see today is whether these advisories, here there are 3 advisories which are included in this order, which is 7, 8, and 14. Whether 7, 8, and 14 relate to fixation of rates and charges for inpatient and outpatient departments and diagnostics.
So in your order, Mr. Sen, you have relied on 14 only?
No, even 7, 8, and 8, 7 and 8 are
7 and 8 are also
yes, there. So Lordship, please comes to page 145.
Yes.
The Lordship will find the top paragraph. On his assertion, we do not issue any further direction on the same. We hope and trust they would continue to follow advisory 7 and 8. It's not a direction, but it's
High Court language. Yes, Mr. Sen, right.
Similar,
but this is an expression of hope and trust. But
yes,
this is general in nature. But 14 has been specifically.
Now, may I come back to these advisories to show your Lordship whether they're covered by the judgment of the coordinate bench.
But here 14.4 is 38.1
specific.
4 is very specific on rates, and that has been
fixation of rates and charges, and for what your Lordship will find.
Yes.
Of
to ensure
fixation of rates and charges for indoor patient department, outdoor patient department treatment, including diagnostics. So we are related to indoor patient department treatments, outdoor patient department treatments, and diagnostics.
Apart from the canteen, everything is covered.
May not be the pharmacy.
Very good.
Now, please come to 14. What does 14 say, Lord? If this is at page 45 of your Lordship's brief.
Yes.
It is common knowledge to all. It is common knowledge of all. The medicines are now readily available of any brand in the state at a discounted price. Some of the traders would also offer discount to the extent of 20%. However, clinical establishments are charging the in-house patients on MRP for the medicines supplied by them either on their own or through the pharmacy operating in their premises. The Commission thus feels the clinical establishments must give at least 10% discount on all medicines and 20% discount in case of consumables supplied directly by them or through the pharmacy situated within their premises and or tied up with the said clinical establishment. You are requested to comply with it. Now, for example, there is a medicine. It may cost 1,000 rupees. It may cost 2,000 rupees. Commission is not fixing the rates and charges. Commission is not capping the rate. Commission is saying in the open market, every person knows now one gets discount. You are compelling patients to take medicines from the in-house pharmacy. Whatever be what the price you are charging, I can't fix that. And it can't because of the coordinate bench's judgment. But you ought to give a discount on that.
Mr. Sen, actually, I have not on the validity or the need for this This may be the need of the hour. We have no qualms on that. Definitely, you have a case there. But here we are only concerned with this fixation. Two things. One, whether through pharmacy or of their own, charging is being done by this clinical establishment. So this is a fixation on the charge levied by the clinical establishment. Regulation advisory 14 pertains to charging the in-house which comes within indoor on MRP for the medicines supplied by them. So the medicines are supplied by them, the clinical establishment, either on their own or through pharmacy. But the charging is done by the clinical establishment and they are providing it. So this squarely pertains to fixing of rates charged by the clinical establishment.
I am not trying to make a fine distinction between it being required. Or not.
Believe me, I would love to enforce this advisory, but my love cannot override the law. I mean, there is no, and the coordinate bench clearly dealt with this fixing of rates and charges by clinical establishment. This squarely comes on under that.
Submission is the fixation is within the absolute and complete discretion of the clinical establishment.
3814 is squarely applicable.
It is. 3814 applies to fixation. I tell you, Lordship.
So you restrict fixation to capping only.
I'll give you, Lordship, one example. Please come to advisory 7, which is also subject matter. The example will be, the illustration will be clear from it. This is at page 35, Lord. 7 and 8 are also involved, but they relate. So, Lord, I'll be able to explain this further.
Yes,
Lord.
yes. 7.
It is common knowledge of all working in health sector, high-end antibiotics, for example, meropenem, is commonly used in critical care management in ICU or ITUs. The said medicine is available in the market in different brands having different price tags. Henceforth, the pharmacy attached to all the clinical establishments must ensure adequate stock of these medicines, at least in 3 or 4 brands. Unless specifically prescribed by the concerned doctor of a particular brand, the pharmacy must supply meropenem available at a stock having price tags comparatively lower than other brands available therein. This would reduce a substantial burden of a patient being treated in ICU or ITU.
Purpose behind these advisories is a laudable,
but now I tell you, Lordship, meropenem, I have no idea of medical science, but I just checked up the net. There's a site called medindia.net. From there, it appeared there are 142 brands available of this generic drug, meropenem, which is used as a high-end antibiotic, very strong, used in critical patients where they are having infections. Almost every patient is advised meropenem in different brands. There are 142 brands of different price ranges, from the highest to the lowest, including going up to as much as maybe 2,000 a gram, coming down to few hundreds. Now, what the advisory says is that a patient is advised meropenem by the doctor. If the doctor says, give this brand, you have to give that brand. But if the doctor says, does not prescribe the brand, just says, gives the generic name of meropenem, give the offer to the patient's family to choose the brand that he wants to take amongst the various price tags. Now, please see the next page, 36. This is in connection with that.
But how does this help you?
Yes.
I mean, can I? Is it open for me to interpret because there is already a judgment?
No.
Striking down the fixation of charges advisories.
This does not fix the price.
This does not. But 14 does.
Now, Lord, 14,
we are bothered with 14
yes,
here.
Now, Lord, so far as this is concerned, this gives an illustration that there are medicines of the same generic name available at different prices.
Yes.
The hospital, the clinical establishment can charge what it feels, whether 100 rupees or 1,000 rupees or 1 lakh. That is the fixation, which I can't enter into. That fixation I have no power to enter into unless the division bench interferes with the order of the coordinate bench.
Yes.
Once that fixation is done, the advisory says on whatever you fix, now you've offered the patient's family 4 or 5 brands of meropenem of different prices, which are fixed by you irrespective of the MRP. Now on that, I am asking you to give a discount. Fixation I'm not touching, but give a discount on whatever price you have fixed.
No, discount pertains directly to price.
The price.
If you have to give a 20% discount, Mr. Shen, it directly affects the price. It's a discount of the price, not something else.
It is like, Lord, the solicitor saying you increase your fee You
Yes,
charge more in the bill so that I can take a cut from there.
right.
Fixation of fee is left to the council. The solicitor says, you please increase your fee by X amount. That X amount will go into my coffer.
Yes.
It'll not be
Or a
received by
better example would be the council is asked to give a discount on his fees.
not,
That would hurt, but that would be a better example. Apt.
No, apt is the first example because that's how the solicitor, that's how I run
Because
my office.
20%, this to the extent of 20%, you are saying that you give
10%
discount
on
of 20%.
10% on medicines and 20% on consumables. We are not concerned with consumables here, we're concerned with
Yes,
medicine.
yes.
Now, whether the rationality, the human feeling
Not
behind it,
that is in your favor.
yes, Lordship has made
But
that clear
Mr. Shen,
also.
yes, I'm with you on that. I mean, but this advisory having been, this is squarely two things are important. The learned single judge had struck down advisories which pertain to fixation of price
Yes, sir.
of consumables and medicines probably. Now, advisory 14, there is no doubt that it directly touches the fixation of price. Because I'm telling you this, I appreciate the distinction you are trying to make. This is not fixation of the price, but saying whatever is the price, you give this discount.
This is giving a concession on the fixation.
That would be a
this is giving a concession. Lordship, kindly, my lord, my respect.
too subtle for
Lord, kindly give a human face to the advisory.
human face I could have given if I was the.
In construing the order of the coordinate bench, because your lordship has the discretion to give a meaning to the coordinate bench's order. So long
Mr.
as
Chen, there is no scope of interpretation there. Any regular advisory which touches the fixation of price has been set aside. Unless that is set aside in appellate court, that remains.
Sir, my respectful submission is
I cannot recall that order.
the fixation is not touched. It is, let me give an example. 100 rupee medicine.
The price remains same, but give a discount.
100 rupee, the nursing home says 100 rupees.
Yes.
Commission says give 10% of discount, it becomes 90 rupees. The same medicine, the nursing home can charge 200 rupees. I cannot say 200 rupees is wrong because I do not have the power to fix the price. But I can say on that 200, please give 10 rupees or 10% discount.
Rather, if you said, Mr. Shen, that whatever is the price actually charged, I'm sorry, charged by the person, the pharmacy or whoever, you have to charge at that rate only. You cannot go above that. I mean, there was some scope of interpretation. You are not fixing the price. You are saying charge at the rate at which you buy it. That is not a fixation of the price. But the moment you say give 1 rupee discount even, that reduces the price. So you are fixing the whatever in a blanket fashion. This is more than fixation of a particular product's price. This is blanket fixation of price. I mean, reduce it by 20%, which is fine enough. I mean, I have no qualms on this in principle, but I don't have the leeway to do that. I'll record your submission, Mr. Sen, but turn down your argument.
May I give just one
No,
clarification?
if Mr. Sen adds something, I'll hear him and probably reply may not be.
I would be repeating myself. I
think
wanted
this is
to
what
show some judgments on what Supreme Court has said about clinical establishments having becoming more commercial, exploitative institutions.
Mr. Sen, that is besides the point.
I don't want
That
to
is
cover it
besides the
with
point.
that.
I'll record your argument that you wanted to cite those judgments, but those are besides the point.
The exploitative method in which patients are made to run in these.
Even Mr. Shortcut does not doubt that, but
yes, I know Mr. Shortcut has relatives who are ailing. I have relatives.
everybody has relatives who are ailing and are overcharged by us.
We face this situation every day.
Right.
And perhaps the commission is trying to give a human face to
Take an approval from the state government. Take an approval from the state government and do this. Your law says it. The law says this. I have not formulated the law. I have not framed the
Your
law.
lordship has put an end to my argument.
No, why I don't. I suppose you have got other remedies even if the state does not give that approval, but I won't comment on that because that has not been challenged. I should not. I'll be going beyond my. Thank you. Yes, Mr. Sharka, what do you want to add?
One small clarification, my lord. The case sought to be made out by Mr. Sen is contrary to the case of the commission on affidavit. May I just point out to two statements made in their affidavit in opposition before the trial court. My lord, it starts at page 67.
What do they say? Tell me just.
My lord, they say that advisory 7, advisory 8, and advisory 14 are all advisories which squarely relate to fixation of charges, nothing else. May I just read out the paragraph?
Uninformed and ill-advised.
May I read out the paragraph? And this case has not been.
Problem is with the advisory. I mean, at the council level also.
My lord, may I read the paragraph E at page 71? It says advisory. This is the affidavit of the commission. Advisory 7 and
Is it
advisory.
annexed to the writ petition?
It's annexed to the writ petition,
Which
page
page?
71, Lord.
Oh, page 71 the writ petition.
Yes, Lord. It starts at page 67.
Yes,
Lordship may satisfy Lordship's conscience that it's affidavit in opposition filed on behalf of the respondent.
Yes, yes. Need
Then
not satisfy the conscience so much. Eh? You are
Lord,
saying
page
that is
71.
Yes, 17. Which part?
Advisory 7 and advisory 8 dated such and such have effectively fixed the charges of medicine which can be levied by pharmacies attached to CE by directing CEs to keep stock and supply of medicines of a such and such. I'm not reading anything more, Lordship. Then Lordship kindly comes to K at 72.
Yes, K.
Advisory 14 has regulated CEs and have directed CEs to give at least such
Read
and
the
such
next
discount.
sentence.
The said advisory has in effect fixed the charges of medicine and consumables by fixing the minimum quantum of discount to be given. My lord, what remains after this? My lord, you will see each of those impugned advisories. It was the commission's case that it's a
This
fixation.
is not our affidavit. This is
Not your affidavit. Whose affidavit is this?
Government's affidavit. We are not, I'm not the government.
No, Lordship.
Oh, no. Come to
Lordship,
page 67.
67.
My lord, we'll see the respondent. My lord, see there's only one respondent.
Page
to the release.
67.
Maybe, but they are filed. It's not the commission's affidavit. Please see the affirmation. It's deputy ex officio deputy secretary law. I don't know how he has come in, although I was there in the writ petition. But it's
My lord,
not,
that is there.
You are the special law officer and ex
of
officio
the
deputy secretary of the
respondent above
respondent.
named, my lord.
Your
the
deputy
commission.
secretary, not the state's deputy secretary.
hey, look, commission look. Oh, I'm sorry. I told he's the commission's person.
My lord, this is being relied on in the appeal. How can it be said that it's not there?
Absolutely.
How little this gentleman knows is, I don't mean my learned friend. I mean, this gentleman who's affirmed the affidavit appears from paragraph 6, where he says the state government has issued the following advisories. That would have been the end of the
Yes,
matter.
no, he says that the state government. Oh, he says
He says the state government has issued the following advisories, page 7.
your affidavit, you are paying him, you are instructing him. He may not be the architect. He may be only a signing person. We don't know who is the architect of this. We never know.
And this case, Lordship, is supported in the grounds of appeal.
Might have been settled by the established the regulatory commission itself. How do you know? I have that hunch. I should not comment further. I'll pass my orders.
Grateful.
Mr. Shen, please take your seat, Mr. Sharkar.
Yes.
The petitioner challenges an order passed by the West Bengal Clinical Establishment.
Your Lordship, only once. Only once.
Yes, this one.
Lord, this is my this is at a
Yes.
personal level.
Yes.
Lord, please come to page 4 of your Lordship's earlier order. This has nothing to do with the merits of, because your Lordship has heard me enough.
Page 4, yes.
Page 4, top portion, Lord, second last line. Lord, the expression, Lord, on the second last line, Lord, please kindly, Lord, and the rest is that expression, Lord, please consider, Lord.
That's the distinction, that line.
No,
That, which para?
in the top portion, page 4 of the earlier order, thus
Yes.
the discretion sought to be made by the commission in its impugned order between advisory 14 and the rest is that portion, Lord. Now, please consider.
This is the softest possible term.
Please.
I can remove palpably here. But it's irrational. Mr. Shen, no, I'm sorry, I beg to differ with you because the commission said that advisory 14 has not been touched upon by the single judge. This is palpably irrational. I could not find out any better word. That's why I use irrational. No, regarding that, as I said in the previous matter to Mr. Bose,
Of course.
the petitioner challenges an order passed by the West Bengal Clinical the West Bengal Clinical Establishment Regulatory Commission, whereby the commission directed the petitioner stroke clinical establishment within bracket CE to give a discount in terms of advisory 14 issued by the said commission. Full stop, next para. The apparent premise of the said order was that a judgment of a learned coordinate bench, comma, which was cited before the commission, comma, did not touch advisory number 14. Full stop. Next para. Learned counsel for the petitioner, comma, by placing reliance on the said judgment of the learned coordinate bench, comma, argues that the advisory 14 as well as other advisories issued, comma, which touched the fixation of rates of medicines and consumables, comma, was not only touched but set aside by the said order of the coordinate bench. Full stop. As such, comma, it is argued that the very premise of the said order is bad in law, and as such, the order ought to be set aside. Full stop. Next para. Learned senior counsel appearing for the commission contends that there is a distinction between putting a cap on the discount to be provided on a price, on the price of medicines and consumables, and fixation of such price. Full stop. Next para. By placing reliance on the various provisions and clauses of section 38 within bracket 1 of the West Bengal Clinical Establishment Regulation, clinical establishments within bracket registration, comma, regulation and transparency bracket close act, comma, 2017, comma, learned senior counsel argues that the said provision empowers the commission to have various to exercise various functions, comma, including the regulation and supervising of clinical establishments, comma, examination and consideration of complaints regarding patient care service, comma, deviations from declared fees and charges, comma, alleged irrational and unethical trade practice alleged before the commission, etc. Full stop. Next para. Learned senior counsel relies on the definition of within double inverted trade practice as provided in section 2 within bracket small z of the 2017 Act in arguing that overcharging patients for medicines, comma, which are procurable at different rates depending on the company which manufactures such medicine, comma, amounts to trade practice and might not directly pertain to fixation of rates only. Full stop. Next para. Learned senior counsel seeks to draw a distinction between a fetter being put by advisory 14 on the clinical establishments having to give a discount on the prices of medicines and consumables on the one hand, and fixation of prices on the other. Full stop. Next para. Upon hearing learned counsel for the parties, comma, the issue which is germane for the present consideration boils down to the interpretation of the order passed by the coordinate bench in its coordinates on June 14, 2023 in WPA 3858/2022. Full stop. Next para. As rightly pointed out by learned senior counsel for the commission, comma, the advisories under consideration there had been issued by the commission without prior approval of the state government as required under section 52 of the 2017 Act. Full stop. Next para. Inter alia, comma, the power of the commission to issue such advisories and orders under section 38 within bracket 1 within bracket small iv of the Act fell for adjudication. Full stop. Section 38 within bracket 1 within bracket small iv pertains to making regulations with regard to fixing of rates or charges for indoor patient department and outdoor patient department treatment, including diagnostics, and also to ensure compliance with fixed rates and charges by clinical establishments. Full stop. Next para. While deciding the issue, comma, the learned single judge, comma, in no uncertain terms, comma, held that the advisories and the order within bracket including regulation, including advisory 14 bracket closed, were unconstitutional and not binding on the petitioners. Full stop. The commission was directed to recall and rescind the said advisories and were prohibited from giving any effect to the impugned advisories and order to the extent of fixation of rates and charges for clinical establishments in a manner which is contrary to section 38 within bracket 1 within bracket small iv of the 2017 act. Full stop. Next para. In the present case, comma, advisory 14 states that it is common knowledge of all that medicines are now readily available of any brand in the state at a discounted price. Which of some of the traders would also offer discount to the extent of 20%. Full stop. However, comma, the clinical establishments are charging the in-house patients on MRP for the medicines supplied by them either on their own or through the pharmacy operating in their premises. Full stop. The commission accordingly felt that the clinical establishments must give at least 10% discount to all medicines and 20% discount in case of consumables supplied directly by them or through the pharmacy situated within their premises and stroke or tied up with the said clinical establishment. Full stop. Next para. Thus, comma, the meat of the matter, MEAT, meat of the matter dealt with by such adversary directly pertain to charging by clinical establishments of the in-house patients on the maximum retail price for medicines, তারপর italic say, supplied by them, এইটুকুন italic say, comma, either on their own or through the pharmacy, as well as regarding consumables, আবার italic say, supplied directly by them or through the pharmacy, এটা italic say, situated within their premises and or tied up with the said clinical establishment. Full stop. Hence, comma, the subject matter of advisory 14 was clearly charging of in-house patients, which comes within the purview of indoor patient department within the contemplation of clause small iv of section 38 within bracket 1 of the 2017 act and related to and relates to medicines and consumables supplied by the clinical establishment, comma, which also comes squarely within the purview of clause small iv, comma, which states that the regulations would be with regard to within double inverted fixing of rates or charges double inverted clause for indoor and outdoor patient department treatment, including diagnostics, and to ensure compliance with fixed rates and charges by clinical establishments. Full stop. Next para. Thus, comma, there cannot be any manner of doubt that advisory 14 squarely relates to charging to fixation of rates or charges for indoor patient departments. Full stop. Next para. In fact, comma, as rightly pointed out by learned counsel for the petitioner, comma, in paragraph 6 within bracket small e and paragraph 6 within bracket small k, comma, the commission itself, comma, before the division bench, no, before the writ court, comma, had taken a stand that the said advisory within bracket advisory 14, advisory সব জায়গায় A capital হয়, has, comma, in effect, comma, fixed the charges of medicine and consumables by fixing the minimum quantum of discount to be given. Full stop. Next para. Hence, comma, even apart from the interpretation of advisory 14 as indicated above, comma, the commission itself admittedly itself admitted that the advisory touches the fixation of charges of medicine and thus came within the ambit of the advisories which were clearly set aside, and the commission directed to recall and rescind such advisories by the order of the coordinate bench. Full stop. Hence, the approach of the commission in the impugned order to the effect that advisory number 14 has not been touched upon by the said order, is perverse, being palpably contrary to the letter and spirit of the said order of the coordinate bench. Full stop. Next para, as such, the very premise of the impugned order is untenable in the eye of law. Full stop. The learned single judge of the coordinate bench, having clearly set aside advisory 14, which was the very basis of the direction given to the petitioner clinical establishment to give the discounts as enumerated therein, the same is required to be set aside, being not tenable in the eye of law. Accordingly, WPA 12069 of 2024 is allowed on contest, thereby setting aside the impugned order dated March 5, 2024, passed by the West Bengal Clinical Establishment Regulatory Commission. To the extent that it directs the petitioner
to adhere to the direction. So adherence to page 144, middle portion.
The directs the petitioner to
adhere to advisory 14, I think would cover it up. Subject to what your lordship means.
To give discount in terms of advisory 14 issued by the commission. No rest to cause.
The order is 142. The commission has observed that my grievance is out of the domain, but they have made certain observations which might adversely affect us, and even I approach before the West Bengal Medical.
I'm not dealing with that. It's not your writ petition.
Grateful, Lordship.
Thank you.
Deeply obliged.
Thank you.
For Apollo, I will have to approach Mr. Deepan Sarkar to get discounts.
Provided he is given the discount.
So I don't have to fund it.
Yes.
Item number 11.
Next, yes.
My lord, I am petitioner.
Yes.
যে অ্যাডভোকেটের মাধ্যমে এই রিট পিটিশন ফাইল করেছিলাম, তিনি আমার সঙ্গে কোনো রকম সহযোগিতা করছেন না।
নো অবজেকশন ফাইল করেছেন?
নো অবজেকশন আমি পেয়েছি সবে। আমি অন্য একজন অ্যাডভোকেট নিয়োগ করতে চাই। আপনি যদি অ্যানাদার হিয়ারিং ডেট দেন সেম, তাহলে আমি
ডেফিনেটলি দেব।
অ্যাডভোকেটের মাধ্যমে সুবিচার পাই।
তাহলে আমি ছুটি ঠিক পরেই রাখছি এটা।
হ্যাঁ, পরে লাস্ট উইকে, জুন মাসের লাস্ট উইকে দিলে খুব ভালো হয় স্যার।
ঠিক আছে।
হ্যাঁ।
The petitioner appears in court and submits that he has some grievance regarding his erstwhile learned advocate and has just obtained a no objection certificate. First of the petitioner seeks to engage a different learned advocate for which he seeks some time. Full stop. In view of such prayer being made by the petitioner in person, let the matter stand adjourned till at a date din কবে রাখবো?
মানে জুন মাসের লাস্ট উইকে দিলে খুব ভালো হয়।
Adjourned till June 25, 2024.
হ্যাঁ, ঠিক আছে।
Thank you. Next.
Item number 12.
Lord, I am appearing for the private respondents one.
Well, I am appearing on behalf of the petitioner. The matter relates to police in action, my lord. The matter has been wrongly filed, my lord.
Lord counsel for the petitioner submits that the matter relates to police in action. Full stop. Accordingly, let the matter stand released from my list due to lack of determination, with liberty to the parties to mention for enlistment before the appropriate bench having determined.
Grateful, my lord.
Grateful, man. Grateful.
Item number 13.
I am for WBSC.
I am for the petitioner.
Yes. What is the matter?
This is the affidavit of service.
All have been served?
The private respondent has refused to accept.
Refused?
Refused.
It has come back as refused.
There are two private respondents, they have refused.
It's shown in the postal track
Postal
report
track
that
report, they have
refused. Yes, that is good service. Where is the refusal? এক মিনিট দাঁড়ান। Refusal.
Standing on the way for giving the connection.
That is why I'm looking for that service on the private. Two private respondents. It says refused or service served delivered. Oh, this delivery is back to you. Acha, yes. So due to their who are they? The private respondent, who are
They
they?
are actually the landlord.
You are the
I-
tenant.
I am the tenant. I am in.
You have held inspection.
No, we couldn't because we have received the two things, Lordship.
Yes.
One, the letter has been given by the private respondent. May I hand it over? But this
Yes.
is the one letter from where they said that admittedly he is the tenant. She is the tenant, Lordship. It appears from the content she is the tenant. And on that basis, say that not to give the connection, they have raised the objection. But subsequently after that, we have gone there for making an inspection, but we have been registered. On that basis, we couldn't do that. So at this juncture, Your Lordship, I am praying before Your Lordship that the police help be given for making an inspection so that we can make an inspection.
Both.
Your Lordship.
Leonard, the affidavit of service filed today be kept on record. Since the private respondents have refused service, comma, the same is deemed to be proper service and the writ petition is taken up for hearing in the absence of the private respondents. The petitioner contends that the petitioner being a tenant in respect of the subject property, Madhababu subject property hyphen hobe na. Subject property, comma, sought an electricity connection in the petitioner's name, which could not be given by the WBSCDCL due to obstruction raised by the landlord stroke private respondent numbers 5 and 6. Next para. Learned counsel for the WBSCDCL submits that the said licensee could not even hold inspection for the purpose of ascertaining feasibility due to obstruction raised physically by the private respondents and their main agents. Two objections. The objection given in writing by the private respondents is also handed over in court today and kept on record, which indicates that the private respondents admit that the petitioner is a tenant in respect of the property, but merely state that the private respondents were not consulted before taking such connection. Next para. Lack of consultation with the owner is not a valid ground for preventing a person to get electricity connection within the contemplation of section 43 of the Electricity Act 2003. Since the petitioner has a right to get electricity connection independently, irrespective of the permission of the landlords, and in view of the petitioner being admittedly a tenant and in occupation of the property, comma, there cannot be any impediment in the WBSCDCL giving connection to the petitioner subject to compliance of formalities. Next para. Accordingly, WPA 13702 of 2024 is allowed, comma, thereby directing the WBSCDCL to hold an inspection within a week from date at the subject premises to ascertain the feasibility of giving a new electricity connection to the petitioner. Upon such feasibility being ascertained, comma, the WBSCDCL shall raise an offer letter to the petitioner. Upon compliance of all formalities by the petitioner, comma, the WBSCDCL shall give such new connection to the petitioner within a fortnight from the date of such compliance of formalities. Next para. In the event any obstruction is raised by the private respondents and or their main agents on either of the occasions, comma, holding inspection and or giving connection, comma, it will be open to the WBSCDCL personnel on both such occasions to approach respondent number 4, the inspector in charge of the Baguihati police station, for adequate police assistance. If so approached, comma, respondent number 4 shall act on a server copy of this order and give such assistance at the cost of the petitioner on both the said occasions, comma, if necessary, by removing any padlock or other hindrance if put up by the private respondents. Next para. It is made clear that such connections shall not create any special right or equity in favor of the petitioner which the petitioner otherwise does not have in law. Not less to cause certificate.
Deeply observed.
Next.
Item number 14.
My lord, I am for the petitioner, my lord.
Yes.
But I am for the respondent bank challenging the maintainability and more of the misleading statements.
What is the why maintainability?
Maintainability because they have got the efficacious remedy before the debts recovery tribunal because bank has filed a way before the debts recovery tribunal in the year of 2018 and they have suppressed the material facts. Because
such as
loan has taken for rupees 4 crore 83 lakhs and they are saying only for 36 lakhs the bank has taken property mortgage.
Let me hear him.
Yes.
Yes. Yes, Mr. Gupta, you know what to deal with.
Yes, my
First maintainability, then others.
First of all, my lord, loan has been taken by Sundarban Chashi Bondhu Rice Mill, who is not the petitioner before your lordship, my lord. They took the loan. My lord, the petitioner before his lordship is one of the guarantor, my lord.
What are you challenging, Mr. Gupta?
My challenging is that, my lord, the respondent bank has asked the petitioner to deposit the title deed for the enhancement of loan of 36 lakhs. And my lord, on that basis, my lord, the petitioner before his lordship has deposited.
You are a guarantor.
Yes, my lord.
You deposited the deed.
But as per their instruction, my lord.
Guarantor has to deposit as per.
No, my lord, subsequently, my lord, all other formalities has been complied with, my lord, at the time of taking loan, my lord. It is a subsequent event, my lord.
No, this is dependent on the outcome of that OA filed by them. Go there and implement yourself.
No, my lord, only one thing, your lordship kindly consider, my lord.
Yes.
Deposited the title deed, my lord.
Maybe.
My lord, that has been signed some papers, my lord. But subsequently, they did not enhance the loan. Enhance the loan, my
Why
lord.
should the writ court interfere, Mr. Gupta?
My lord, DRT, my lord, subject to correction, my lord. I am not a party before the DRT, my lord.
Implement yourself. Go and make an addition of party.
They are not returning my title deed, my lord.
No, even that. That is directly related to the loan. Directly related to the loan. You are a guarantor. Whether you give subsequently, whether it covers the loan amount, we don't know. That is a factual dispute, Mr. Gupta. You have to get that thrashed out before the DRT. I'll give you that liberty.
My lord, I have got a copy of the way. My lord, she has implicated as a party. She is a guarantor.
She's a party. Yes, I was thinking so.
Yes. My lord, already fixed on June. My lord, 2024 already fixed on June.
Please give me the number of the OA number.
My lord, OA number 242 of 2018.
I'll put that in my order so that they cannot deny now.
My lord, and my lord, kindly see, this is the last order, my lord, which was paid. They didn't choose to appear before the debts recovery tribunal, and that is the reason for which, my lord, publication was also made in 2020-22.
Can you give a copy of this to Mr. Gupta? Yes. I'll record that in my order that it has been, now they cannot avoid. Oh. Yes, Mr. Gupta, don't avoid, go there.
My lord.
Go there, don't avoid now. I mean, not you, your client.
My lord will not observe anything on merit, my lord.
So I'll say you have nothing. There is nothing in your case, only that. Otherwise, I'll not touch them.
My lord, your lordship can grant liberty to so that I can approach before.
I'll do that. The petitioner has challenged the retention of certain title deeds by the respondent bank, which were allegedly given by the petitioner, a guarantor in a loan taken by a third party, at the instigation of the bank. Whose next para, learned counsel for the bank takes an objection as to maintainability of the writ petition and submits that the writ petitioner is guilty of suppression of several material facts. For example, the bank has already preferred an application before the concerned debts recovery tribunal bearing OA number 242 of 2018, where the petitioner is also a party as the guarantor. Next para, it is further submitted by learned counsel for the bank that the loan is to the tune of about rupees 4 crore 83 lakh, whereas it has been sought to be played down in the present writ petition. Next para, upon hearing learned counsel, it is clear that the bank has already filed an OA before the concerned debts recovery tribunal, impleading the petitioner, who was one of the guarantors in the loan transaction in question. A perusal of the order dated April 11, 2022, a copy of which is handed over in court today by learned counsel for the bank, passed in the said OA, clearly shows that paper publication has also been made in connection with the same, but the petitioner is yet to appear therein. Full stop. Next para. The relief sought in the present writ petition having a direct connection with the subject matter of the OA, comma, since the title deeds were deposited with regard to the loan in question, comma, the writ court ought not to interfere, comma, since the petitioner has an equally efficacious, comma, if not more efficacious, comma, remedy available by canvassing the petitioner's case before the Debts Recovery Tribunal in the pending OA and or any other independent application if the petitioner so chooses to file. Full stop. Accordingly, WPA 13790 of 2024 is disposed of with liberty to the petitioner to approach the concerned Debts Recovery Tribunal in the pending OA and or by an independent application and canvass the case made out in the writ petition before the said tribunal. Full stop. This court has not entered into the merits of the respective contentions of the parties.
Deeply
Rest
august.
sir.
Before my lord rises, my lord, under instruction of my lord Honorable Chief Justice, I am mentioning this matter, my lord. My lord has passed a order on 17th, my lord. My lord, kindly seize the order, my lord.
Yes.
My lord, the contemners are the, my lord, insurance company, my lord. They said they have given the, my lord, cashless, my lord. They have repudiated again. The morning, my lord, at 1:30.
What have they done?
Repudiated again, my lord.
So what can I do like this?
My lord, my
Put
lord,
it by
Chief
way of
Justice,
an application.
my lord, Chief Justice has, my lord, directed me to apprise, my lord, immediately, my lord, and my lord, to revive the, my lord, contempt application, my lord.
I cannot do that. Even if the Chief Justice says, I don't have the power. Till the Chief Justice has said that. I don't have the power.
My lord, then, my lord, can
You have to file a proper application.
my lord, can I file an application by 2 and come back at 2, my lord?
Why? What is the extreme urgency?
My lord, the operation was scheduled tomorrow, my lord. Admission today.
Oh, acha. Say that. That should have been the first thing. Can you give notice to the other side?
Notice, my lord, I can serve notice to the
Counsel who
advocates.
appeared?
Yes, my lord, I can.
Yes, give a notice. I'll take up at 1.
At 1. My
1.
lord, I am immediately
Keep this with
serving
you.
a notice.
Keep this with you. Who was appearing for the.
My lord, my lord, 1.
Tell me the names.
Orobin, Anirban Roy, my lord. Somendranath Ganguly and Vivekananda Das. My lord, Vivekananda Das is the AOR, my lord.
You can also inform Mr. Anirban Rai.
Anirban Rai.
Anirban Rai, so that tell him what has happened, and I've told them to come at 1.
My lord.
Tell them. Submission.
My lord, my lord, this is my chambers matter, my lord. That's why I'm bit now.
Even if it was not your chambers matter, you have a right to say that, because if the operation is scheduled today, we have to take it up.
My lord, scheduled tomorrow. Operation is scheduled
I'm sorry,
and
tomorrow,
admission
yes.
is today, my lord.
Come back at 1. I'll take up.
Item number 15.
For the petitioner, my lord.
Yes,
IPF
what
to
is
the
the
respondent bank, your lordship. Right.
My lord, yeah, the petitioners borrowed some money from the concerned bank
Yes.
in the year 2013. Due to some technical problem, they could not start the plant, and as such, account has been declared NPA. Proceeding initiated on 13/2, 13/4. The petitioners duly contested SRPC application filed before the Debt Recovery Tribunal. Matter settled by an order of the Debt Recovery Tribunal. 2019. 2023, all on a sudden, the local police came to the premises of the petitioner with the order of the district magistrate, saying that order has been passed by the district magistrate for taking possession of the concerned property. Petition was in dark about the possibility because it is already settled. Now they make an application under Section 6 of the Right to Information Act to get what order has been passed. In reply, my lord, the local police station handed over a copy of the concerned order. In order, it appears that
handed a copy of the Section 14 order.
yes, my lord. In order, it appears that the case number mentioned therein is different, not my case. And
So the SA number has also been mentioned there.
no, not mentioned.
The case number.
OA Act 1 OA number has been mentioned. We are not party in that OA application, OA number. So it is we are not aware who filed the OA and who are the party in the said OA.
You are challenging the magistrate's order here.
Lordship. Only point is that, my lord, when it is settled by the competent court, how
Can you please show me the settlement order?
yes, my lord. Kindly see. Page number 69. It starts from 69.
Yes.
No, sorry. 60, 60, my lord. None appears for the applicant. It is case number SA 165 of 2015, dated 7th January 2020. None appears for the applicant, Mr. S. Trivedi. Learned counsel appears for the respondent bank and submits that the matter is settled and prays for dismissal of the SA.
This is the only case relating to you, you say. And where is this impugn order? Let me see that.
69, page 69. It starts from page 16 and page 72 is a type copy. 72 is a type copy.
72 is a type copy. 73, yes.
72 and 73, 2 pages. Here, my lord.
Achha, OA case, very well.
OA case number 114 of 2020.
You have been dispossessed?
Not yet, my
Not
lord.
yet.
Not yet.
Let me hear the bank. Yes, what do you say?
Lordship, the difficulty that took place was that this order, which my learned friend has shown at page 60, is not the correct order. Lordship, in this regard, the bank has come to know from the office of the district magistrate. What had happened was they had filed a SRPC application challenging the 13-2 notice of the bank. An amount of 7 crore and 73 lakhs was due and payable by the borrower.
Yes.
The SRPC application, when it came up for hearing, some advocate appeared for the bank and submitted that the case has been settled. The actual fact is that the submission made was that the OTS proposal is being considered. And your lordship, even now, if the
order has been recalled.
Lordship,
7th of
this
January.
is the application that the bank has filed for recall of this.
How can you evict him before that?
Your lordship, we are not evicting him before that because
I'll set aside the Section 14 order. At this stage, it cannot be passed. How can you pass a Section 14 order and take possession? You must have filed an affidavit. Otherwise, how could this? You must have filed an application prompting the magistrate to pass this order.
Absolutely. The bank had filed an application under Section 14. The Section 14 order, your lordship.
But you should be saddled. Your officer should be saddled with costs. You are harassing a person like this.
No, your lordship.
There is a settlement order. Whatever the perception of your perception of facts may be.
No, your lordship.
Fact remains that there
is
is a
not
settlement.
the order which has been, the complete order has not been placed before your lordship. Your lordship may kindly have a look at this application which is pending before the DRT for correction of the order because your lordship.
No, that application may be Ota Feruddin. There may be a pending application. Pendency of an application at your behest does not mean that an order has been passed on that. This order still remains. That application is for recall of this order.
Yes, your lordship.
So if unless that application is allowed, that may be dismissed also by the tribunal. So how do you have the gumption to evict some? You say there is no settlement, sir. There is a recorded order which has sanctity of law. And your application, you file an application and evict a person. I'll impose exemplary costs on the officers.
The bank was not even aware of this order, your lordship.
Of the Section 14 order?
In fact, this particular Miss S. Trivedi, who has been shown to appear on behalf of the bank, there is no
that
such
is your version, sir. You grew wiser after 4 years. And now you are saying this.
Lordship,
Bank
we
filed
came
the
to
section
learn-
14 application. Where is the section 14 application? Show me the section 14, what you have stated there. I want to see that.
Lordship, the application is not annexed to the writ petition.
You must have a copy of your application.
Lordship,
What have you stated there? You must have suppressed everything.
no, Your Lordship. In the section 14 application, it is stated that an OA is pending before the DRT, and in the OA, the recovery, the amount of 7 crores is due and payable. And Your Lordship, apart from that, there is no other matter pending before the tribunal. The OA is still pending, Your Lordship. The bank is still pursuing the OA before the DRT.
Who is the officer concerned? Who the authorized officer? I'll impose cost on the authorized officer. This is not the way to proceed. Just because law has been given to the hands of the banks, you're flouting law like this.
Not, Your Lordship, may kindly see a copy of the application. The wrong order has
Give me a
been
copy of the
uploaded. Your Lordship, the wrong order has been uploaded on the website of the DRT, and the bank was not even aware of it till 2023.
The copy din amader.
Yeah, দিচ্ছি আপনাকে।
I'm surprised with the magistrate also. How could he pass this order?
Your Lordship, may kindly see.
You have sought
in
for a
this-
recall of an order recording settlement. That
Exactly.
application is pending, and possession is directed
Your
against.
Lordship, this has happened after the order of the district magistrate. When the matter was disposed by the district magistrate, the bank was not even aware of this order of the passed in the SA. The district magistrate was
One
not.
second. If you have filed this application for recall of that order before this, how did you proceed with the section 14 application?
Your Lordship, when the section, Lordship, let me go in a serial wise order. Your Lordship, 13(4) action was taken by the bank. After that, they challenged it before the DRT by filing a SURFACE application. The SURFACE application, when it was taken up in the year 2020, there was no representation made. And Your Lordship, the bank was not even aware of this order because at that point of time,
Chose not to be aware because you were appearing in the proceeding before this date.
Your Lordship, insofar as
You
this
never
order-
appeared. The bank never appeared.
Lordship, may kindly see the next page. Your Lordship, the learned counsel for the applicant is given opportunity to submit reasonable, workable, viable OTS proposal. This is the submission of the bank.
Which next page?
Your Lordship, may see the application. In the application, the impugned order, Annexure A.
Yes.
The second page, Your Lordship. Even now, Your Lordship, if Your Lordship sees the website of the DRT, the order is still available. The second page
This
is
does
the
not show.
actual order.
Does not have any header, any foot.
Your Lordship, this is what is uploaded on the website of the DRT, Your Lordship, and this is the submission made by the Your Lordship. There have been several orders at that particular stage. Your Lordship, this was the submission made by the bank that the
This is the
OTS
format of an
proposal-
order which you know very well.
I
This
agree.
cannot be an order.
Your Lordship, may kindly
In your
see what
dreams,
has
you might
been
have seen this order.
Your Lordship, that is the order which has been uploaded by the Debts Recovery Tribunal, Your Lordship.
The writ petition has been
Today,
preferred.
Your Lordship, this order is available on the website.
The writ petition has been preferred against an order passed by the by a district magistrate, purportedly under section 14 of the Surface Act 2002, whereby possession has been directed to be given to the authorized officer of the respondent bank. The petitioner submits that a settlement was arrived at by the petitioner stroke borrower between the petitioner stroke borrower and the concerned bank as long back as in the year 2020. Learned Counsel places reliance on the order dated January 7, 2020, passed in SA number 165 of 2015 by the Debts Recovery Tribunal Roman 1, Calcutta, annexed at page 60 of the writ petition in support of such contention, where it was recorded that the said essay was dismissed as it has become infructuous in view of the matter being settled between the parties. Next para. It is contended that despite such settlement, the impugned order has been passed apparently for recovery of possession in terms of the self-same loan which was already settled, which is palpably dehodes the law and all principles of natural justice. Next para. Learned Counsel for the bank argues that the order dated January 7, 2020 was recorded behind the back of the bank and the bank had no knowledge whatsoever of the said order.
Lordship, the order is recorded wrongly, Your Lordship. The correct recording is on the next page. The wrong order has been uploaded, Your Lordship. The second page is the correct
It is submitted that the said order annexed at page 60 of the writ petition does not exist. Next para, it is contended that accordingly the bank proceeded with an application under section 14, being unaware of such of existence of any such purported order, and the impugned order was passed on such application. Push up next para. Learned counsel submits that immediately upon learning about the said order, the bank has filed an application for recall of the said order, pointing out that the said order was never passed in reality. Push up the such application is numbered as OA 114 of 2020. Push up next para. Learned counsel for the bank,
Lordship, not OA 114.
not OA. What is this?
Lordship, diary number 95 of 2024, MA, there will be an MA number which will be put.
Please numbered as which has been
diary number 95 of
2020. Such application numbered as secondary. Push up next para. What was the OA which is mentioned in the DRT order?
Lordship, the OA which is pending before the DRT, that is for recovery of dues, that is 330 of 2015.
114 of 2020 mentioned at page 73 by the magistrate. Push up next para. Upon query of court, a copy of the application filed for recall of the said order is handed over in court today. Push up learned counsel for the bank submits that the purported order, the existence of which is denied by the bank, dated January 7, 2020, has been annexed thereto, and in the immediately succeeding page, the actual order which was passed is also annexed. Push up, the bank denies the order dated January 7, 2020, having been passed at all. Push up next para. However, this court is utterly surprised by the high-handed action of the bank. Full stop. As of today, there exists a certified copy of an order dated January 7, 2020, passed in AC number 165 of 2015, which has been annexed to the writ petition as well as to the recall application of the bank before the tribunal, which, in no uncertain terms records that none appeared for the applicant stroke present writ petitioner, but the bank was represented through counsel, who submitted that the matter was settled and prayed for dismissal of the essay as no further cause of action exists in the essay. Next para. In view of such submission of the bank, the said order was passed, recording that in view of the submission made by the respondent bank, that the matter is settled between the parties and there is no due against the applicant, the tribunal was of the view that there was no cause of action further existing in the essay, and accordingly essay 165 of 2015 was dismissed as infructuous. Next para. Even if the bank is of the perception that such order was not passed, till the same is recalled upon the application of the bank in that to that effect being allowed, the order remains on the records and is as valid as can be. Next para. During pendency of the application of the bank for recall of the said order, the bank cannot arbitrarily presume that such application would be allowed and the said order does not exist. Next para. Mere filing of a recall application, on whatever ground, does not automatically efface EFFAC the order of which recall has been sought. Next para. Hence, the impugned order passed by the magistrate, district magistrate, Howrah, under section 14 of the SURFACE Act was obtained by the bank under by gross suppression of material facts and which cannot be said to be less than practicing fraud upon the district magistrate Howrah. Not a single line of the existence of the order dated January 7, 2020 has been mentioned in the said order by the bank, although at the behest of the bank itself, an application is pending for recall of the said order. Full stop. Next para. It is unthinkable that a bank, discharging public functions, resorts to such sharp practice and obtains an order of possession by totally suppressing that an order of settlement exists on record and the bank has merely applied for recall of the same. Full stop. Next para. Strongly deprecating such high-handed action of the bank and the concerned officials of the bank involved therein, WPA 13907 of 2024 is allowed on contest, thereby setting aside the impugned order of the order passed by the District Magistrate Howrah dated May 11, 2023 under Section 14 of the Surface Act 2002 taken out by the bank. Full stop. Next para. Since the very application under Section 14 of the Surface Act 2002 is based on falsehood, the said application stands hereby dismissed. Full stop. Next para. It is, however, made clear that nothing in this order shall prevent the respondent bank from taking out fresh proceedings under Section 14 of the Surface Act or otherwise, in the event the bank succeeds in its order of recall and the order dated January 7, 2020 passed by the Debts Recovery Tribunal 1 in SA number 165 of 2015 is recalled and or held to be null and void subsequently. Full stop. No orders to cause urgency report. I'm keeping on record this because the application for recall filed by the bank handed over in court today be kept on record.
Number 16.
Yes.
I am for the petitioner. The petitioner before my lord is
Use the mic. Use the mic.
the petitioner before my lord is a debt recovery agent of a particular bank.
Yes.
My lord, the respondent authority from time to time issued work order. Accordingly, we gave that service and we issued bills and that bills was paid. Subsequently, my lord, they are not clearing my balance due of 3,17,089. That amount is admittedly due. On the we have filed an section 6 of RTA application also on 31st March 2022. They have not given a satisfactory reply. They just said that you have merely theft and every allegation. But in case of this type of allegation, they could easily file a complaint before the concerned police station, but they have not done so. On the
No, they have said what? They have made certain allegations against
allegation against us that theft of some certain materials and everything. But these allegations, my lord, if that could have been taken place, they could have complained before the concerned police station. They have not done so. My lord, I am merely playing that my demand justice on 19th January 2024.
What is that?
My lord, that is at page number 105 of my lead petition.
Yes, what do you say to this demand justice?
May I have 2 minutes of audio?
Absolutely.
What happens? The bank has an account. Engage a recovery agent, the petitioner here, having certain terms and conditions there. Contractual obligation has to be fulfilled. Unless those contract is incomplete, it is like a function officio by district magistrate in the section 14 order. So unless that contract is complete, we cannot pay a single paisa to him. So we assign an account to him apart from the other accounts. Then what happens? He has taken physical possession of the property and they deployed security guards there at the behest of the bank. During the pendency of physical possession, we have sold out the property. And before purchasing that property, the purchaser has visited the premises and purchased the property. Now, I will appreciate that page 79. Page 79 of the writ petition.
Yes. Yes.
1 second. Give me a second. 79. This is the letter given by the auction purchaser. Kindly see second last paragraph from the bottom. After 1 week, when I purchased the materials and reached the 4th January 2023 to take delivery of materials, I could only find 80 pieces of pipes present.
So there is an allegation of theft.
Allegation of theft. So what
of the movable property.
So instead of making recovery to the bank, this recovery agent is making his own recovery. So Malad have This bank has lodged an FIR against him. He has made a complaint and lodged an FIR against him. The FIR is pending. May I hand over a copy to you?
Yes, please hand over a copy.
Yes, yes. This FIR is pending.
Then
Now, after this all, we have depaneled him. From all the accounts has been withdrawn. So now we have rather a claim against him. So disputed question of fact, my lord. Now facts has to be clear.
Yes.
Yes, what do you say? On the one hand, they are clearing my dues. They are not disputing my dues. They have cleared my dues. On the other hand, they are saying that they are not satisfied.
When have
with
they
my
cleared your dues last?
My lord,
They have cleared up to a point. Must be before this complaint.
No, my lord, they have my lord, I will file a supplement that has not been annexed in the writ petition. My lord, kindly give me liberty.
They are clearing it. Then why have you filed the writ petition if
But
they have?
because they have terminated. My lord, kindly see the page number 112. So they are on by a letter dated 17 June 2023. They are saying that we are not required your service anymore, and they are not clearing my dues also. 17 June
But
2023.
take this, I'll direct affidavits in this matter. Disclose everything so that.
My lord, I am humbly praying that demand justice. If my lord,
Demand justice, they are refusing here and now. If the demand justice is allowed, why should I direct the demand justice? It will be an exercise in futility. Here and now, your learned friend is submitting that they're refusing, and they're giving the grounds also.
Then, my lord,
So if I direct the demand justice, it will be rejected on these grounds only.
then my lord, may I file a supplementary affidavit enclosing this?
Very well.
There is no point keeping this matter pending.
Then you consider the demand justice.
But all this, I have a claim against him.
Disclose the reasons. So
Yes,
that
we'll do that.
Very
We'll do
well.
that.
I'll do that.
We'll do that.
The prayer of the writ petitioner is innocuous. Full stop. The petitioners acted as recovery agents of the respondent bank. Full stop. Initially, the respondent bank has been clearing the dues of the petitioners. Full stop. It is argued that till date such dues are being paid. Full stop. However, the services of the petitioner has been terminated, prompting the petitioners to prefer the present writ petition. Full stop. Despite demand justice having been given by the petitioners, no reply has been given by the bank in that regard. Full stop. Next para. Learned counsel for the bank makes several allegations against the petitioners and hands over a copy of a first information report lodged registered on the complaint of the bank against the petitioner on the allegation of the petitioner having committed a theft of movables on a property recovered by the petitioners as an agent of the bank. Full stop. Next para. It is contended that in view of such allegations, and the counterclaims of the bank against the petitioners, there arises no question of the petitioners' services being continued further. Full stop. Next para. Learned counsel for the petitioners seeks to use a supplemented affidavit inter alia incorporating documents to indicate that contrary to the submissions of the bank, the bank is still going on paying the dues of the petitioners. Full stop. Next para. Since certain disputed questions of facts are involved, and as the bank as yet has not given a proper reply to the demand justice of the petitioner, it would be premature at this juncture to enter into the issues involved. Should I direct demand justice then? Very well. Involved now, full stop. Since the petitioner submits that the petitioner would be satisfied with a reply of the bank to the demand justice of the petitioner at this stage, there is no use in keeping the matter pending further. Full stop. Accordingly, according WPA 14081 of 2024 is disposed of by directing the respondent bank to decide on the representation given by the petitioner as annexed to the writ petition as expeditiously as possible, preferably within 4 weeks from date, upon giving an opportunity of hearing to the petitioner and an opportunity for the petitioner to furnish relevant documents, if any. Full stop. It is made clear that the merits of the allegations and counter allegations have not been gone into by this court at this stage, and it will be open to the bank to decide on the issue independently in accordance with law. Full stop. In the event the petitioners are further aggrieved by the outcome of the same, it will be open to the petitioners to prefer a challenge before the appropriate forum.
Well, may I file the affidavit of service?
Affidavit of service filed today, Captain.
Deeply
I'm grateful.
Item number 17.
Yes. Yes. Respondent. One of the parties must be known to me, Mr. Bhattacharya, so that I can release them. You two are appearing, it will not be over before vacation. And Mr. Shen is also there. Very good. Yes, yes, I'll allow that. Yes.
I would rather say something else. But there is an election. This is the first time your lordship will notice persons who are there, they want an election to be held immediately. 3 times election notices have been given, and 3 times, just 5 days before the election, the person comes to.
You are appearing for which of the parties?
I am for the association, BTTA, Bengal Table Tennis Association.
The internal fight of the society.
Acha, very good. Yes.
Well, there is
No, what is the preliminary objection? Then I'll hear Mr. Bhattacharya. Why not? Association is a.
the members of the society, and there is no involvement of the government. And all the eventualities required to maintain a writ petition is absent. Even not the state is party. That should not have been made party.
Very well. Let me hear Mr. Bhattacharya first on maintainability, and Mr. Bhattacharya, let us hear you on maintainability first.
Now, the first thing is, not for maintaining, I have to give a little bit background. There are Malda Table Tennis Association is the association which really makes us proud. They are producing the national champions.
Yes.
And there's an association in Kolkata which is headed by one Mr. Babun Banerjee, having the essential address of the Chief Minister's house, and he's the brother of the Chief Minister.
I expected this introduction to come.
Prejudicing the court.
Let me
even
he has already prejudiced me.
Yes. Let
So
me,
this is
relevant or not, I shall expose. Allow me to speak.
no because he's the Chief Minister's brother, Mr. Bhattacharya replies. He comes within Article 12.
I'm giving the fact. I have not said
So,
for that.
how is Article 12? I mean,
Yes, I will show you.
yes,
Just
public law element is to be.
give me 5 minutes time to explain.
Absolutely.
And the government of India said that because of one country, one nation, one leader, there should be one association, which should be recognized by the national body. And on the strength of that direction, kindly come to know, this new association was constituted. Therefore, this is the outcome of the government of India's direct intervention. The government of India feels the Khelo India is a project where the sports is also a part of the education. It's a part of the new education policy. Now, kindly turn to the page 43 now. Yes, page 43. There are a number of indications. Page 43.
Yes.
This is the memorandum of association affiliated to Table Tennis Federation of India. Now, kindly notice, this is very peculiar and very important feature at page 44. Page operator. Registered office. The registered office of the BSTTA will be at 20A Baliganj Terrace. Apart from the registered office, there shall be a working head office of BSTTA at Deshbandhu Para, Siliguri. Therefore, this recognizes that these two independent bodies are sought to be amalgamated. Now, kindly turn to page 47. Well, I place this fact, then I shall take you to how the read apply, and it's very clear on this. Now, the names, address, and description of the members of the executive committee, their address and other particulars. Mainak Jalan, Cavender Agro Limited. Now, I am compelled to make a reference, which your lordship will kindly take note of, judicial note of. This Cavender Agro Limited was found to have one of the contributors to the electoral bond, which the Honorable Supreme Court has declared unconstitutional, and this fund went to a particular political party in West Bengal. And number two,
part of the pleading, Mr. Bhattacharya should not make any submission which is not in the part of the pleadings.
Yes.
All are from bar.
Yes, Mr. Bhattacharya.
Number two, Mr. Shopon Banerjee, 30B Horish Chatterjee Street. Social Service Senior Vice President. Now, these are this is the way, my lord, it was sought to be constituted. It was constituted. Now, kindly come to, my lord, the page 51. Office bearers shall include the 1 president, 3 senior vice presidents, 10 vice presidents, 2 joint general secretaries. These are peculiar features.
Are you challenging the formation of this association?
I am showing you the background of it.
No, what are you challenging? Just tell me that, then we'll.
I am challenging, my lord, that the election which has been sought to be, my lord, convened by one of the general secretaries going against the memendas and rules. And
You are a part of this Bengal association.
Lord, there are many proceedings before this court. Lord, just to now show you a lordship, I invite your lordship, orders passed by the court to save the time of the court. Kindly turn to page 131. 131, annexure P5.
Yes.
But here these issues, Lord, came up for consideration. I am taking a lordship. Now kindly come to page 134. The Honorable Court referred the matter to the registrar back and then said, till kindly page down the last paragraph of the said page. It is also made clear that till the time the said reasoned order is communicated to the parties as directed above, it is expected that none of the parties shall take any further steps on the issue. On the above terms and on the basis of the directions made recorded above as prayed for so and so, it wishes.
This was between other parties.
Yes.
You are not a party here.
Yes.
Some Greater Siliguri district table tennis association was a state.
With regard to the same election process of the same society. And that's why I'm showing this.
No, you are Malda Table Tennis
I am
Association.
the Malda Table Tennis Association, which is one of the constituent of the Bengal Table Tennis Association. And this was challenged by the Greater Calcutta Siliguri district.
So why are you placing this order, Mr. Bora? What is the significance of this order?
Because they challenged that when the election notification was made, they said it cannot be done. And the formation of the society in trying to incorporate someone, it could not be done. Therefore, the court felt it should be referred to the registrar for his decision. And till that decision comes, it should not be proceeded with any further. Then the next order of the High Court, the registrar passes an order, which is again in a peculiar order, at page 1.
The registrar under which act?
Under the society.
Association. These are all associations, that's why. Yes.
Kindly come to now page 136. The decision and order, the registrar, in fact, by passing under, wanted to upset the entire society. The matter of the incident lead is of the disagreement among the members of the society who are the members of Greater Siliguri District Table Tennis Association and Bengal State Table Tennis Association situated at so and so. All previous communications of the Registrar of Farms, Societies and Non-Trading Corporations West Bengal read with the provisions of West Bengal societies and rules made thereunder pursued to dispose the matter and concluded that the creation of the post of secretary of the said society. Now he gives a new direction which will goes against the formation of the combination of societies. And then he says how it should be done. It was further challenged before this court. And now page kindly 139. But the president of the society, that Moinak Jalan or something.
But these are not statutory bodies, Mr. Bhattacharya, private
It's
association.
not.
Then why
There
should
is no bar. Even when the
if you challenge an election, I mean.
I am not challenging. I am challenging the election notification issued by a person who is not authorized under the rules. But everybody, is bound to follow the rules.
But the rules do not have a statutory force.
It's a statutory force, it may not be statutory force, and this court
Then
can.
approach the civil court, Mr. Bhattacharya.
Obtain
an injunction.
I take you 5 minutes to convince you. No difficulty doing that. Just place with the orders. Then kindly turn to page 139.
Yes.
This is the order of the court. That the election has been declared by the President of the Bengal State Table Tennis Association, fixing 7th February 2024 for conducting election of office bearers and members of the Executive Council. The dispute, this is the issue then, and now the issue before the auction is the same. The dispute is with regard to the post of General Secretary. The Memorandum of Association of the Bengal State Table Association mentions that the office bearer shall include 2 joint General Secretaries. As the impugned election notice mentions about only 1 General Secretary, the same has been challenged in one of the writ petitions. The jurisdiction of the President of the Association to issue the notice of election has also been challenged. As per the memorandum of association of the notice of election is required to be issued under the name and seal of honorary joint general secretaries. Well, it should be done by the both.
Here also in the present EP notification also one.
The president has done.
No, the election notification says speaks about only one general secretary here also. No. Two
Here
general
there are
secretaries.
two general secretaries.
There that was one of the issues also.
Yes, same
Here
issue.
that is not.
Identical issue here.
No, there the learned coordinate bench held as the impugned election notice mentions about only one general secretary. That is not present here. That
No,
in
that's not present.
but
that
here
was for the
regarding the
purpose-
signatory.
But that was for the purpose of electing one general secretary. The issue is not here, but the issue of, my lord, the power to convene a meeting.
The jurisdiction of the president to issue the notice,
yes.
that
That
is
was-
under challenge here also.
And here the court says,
What
but
was
I
held?
just
Yes.
keep over from the take a lot.
Yes, yes. Show me the finding.
Kindly come to page 141.
Yes.
The memorandum of association, the third paragraph of the same page.
Yes.
As it stands today, mentions about two general secretaries and notice of election to be issued under the name and seal of the honorary joint general secretaries of the association. This is the finding of the court. It has been submitted by the so-and-so that I am not skipping over. Then page 144, whether the president of the association had the power. Sorry, 142. Sorry. 142. I skipped over it.
141 last paragraph.
141, yes, may I please?
Yes, yes.
The memorandum of association, my lord, the penultimate paragraph, as it stands today, mentions about two general secretaries and notice of the election to be issued under the name and seal of the honorary joint general secretary. Of the
So this is which page?
page 141. My lord, it
141 you are continuing, yes.
Yes.
Yes, last paragraph.
My lord, got it,
But
memorandum
then it has been held to be debatable next page.
Yes.
President, whether he has also.
Whether the president of the association power to issue notice of election is debatable,
Yes.
till it is adjudicated and the notice of election was issued by the competent authority, the election cannot proceed.
So this was not adjudicated upon by the.
No. Therefore, then we will kindly come down, little to the message page. The election notice which has been issued by the president of the association directed to be kept in abeyance till 23rd February or until further order, which was earlier. Let it appear in the list once again on 13th February.
Issue of maintainability also kept open.
Then the further order of the court, I just place all facts with lordship. Kindly turn to page 1.
This was on a previous occasion.
Yes, we take the same on previous occasion. Page 149. Now the court records everything.
Mr. Bhattacharya, writ is not maintainable.
That I would.
First of all, detailed questions of facts have to be gone into. Apart from that also, may not be, because you may argue that the memorandum has to be construed. Even then, Mr. Bhattacharya, these are private associations. Yes, sports, but the way you are approaching, I mean, the tussle, I mean, there are so many bodies claiming right. I mean, we cannot say there is a public law element involved here.
Well, I would say yes.
Why do you say that?
Yes.
General interests of sport.
Kindly turn to page 40.
No, you cannot disturb me, sir.
With partition, I'm saying, my lord,
He has not permitted you.
we are all asking for election. Can we appoint somebody elect?
Yes, I agree.
Yes, that is what we have been saying, Lord.
Well, yes.
Let the court issue the notice and the election.
Yes.
be held.
I agree to that.
But election should be held on the same date because there should
Not same day cannot be. No.
Everything
No, my lord.
Why I say this, my lord, because
Well,
the
once you-
entire procedure should not be.
No.
You are challenging the election notice itself.
Yes.
On the ground that president does not have power. You want that to be set aside, fresh notice to be issued,
election be
and election to be held. Please show me, convince me, Mr. Bhattacharya, from the memorandum that president does not have the power.
Yes, kindly turn to the memorandum at page.
Because if I have to do that, then I'll have to be convinced on that.
My lord, may I just interrupt once? Just once. my lord. Why president has taken this emergency power?
Yeah.
It is not in the natural course that he has taken. Two joint secretaries are empowered under the rules to issue jointly.
Yes.
I will show your lordship from time to time, I am writing to the other joint secretary represented by Mr. Bhattacharya's client that let us issue the notice of election. He has declined to issue the notice of election. That is the first.
No.
Bhattacharya's client is one of the
Lordship,
joint.
Lordship, am I audible, Lordship?
Now,
Lordship,
Am I audible, Lordship?
Let us not go into the dispute now. If they are agreeable to hold the election,
There can be two options. One, all of you agree that a fresh election notice will be issued, or on the because this election notice is challenged by. If I have to hear this writ petition, then I cannot direct that because there is no consensus. Or you can, I mean, there can be a consensus between you that they'll sign an election notice will be issued.
yes.
Mr. Bhattacharya, you have a talk. I mean, all of you have a talk. I mean,
Mr. Shen be the special officer. I have
that talk will not result.
Talk will not result.
Then I'll have to decide on merit.
No, why are
If the president does not have the power, I'll set aside and do the same thing.
On the very, the Lordship has to set aside the writ petition should be maintained, not maintained.
Public interest, sport.
No, we are interested in election. Election has to be.
if the election, we all in one that election should be held. Election.
So all of you want election should be held, but differently. So if it's different, then if there's an agreed order, I can pass it. I can sign it.
Informing to Mr. Bhattacharya through my law. The president has only issued the notice that on a particular day election should be held.
Mr. Bose, inform me through Mr. Bhattacharya. That will be the easier course of action. If there's a consensus, there can be a fresh election notice without you considering anything.
They sign that notice. He has got anything else.
Mr. Basu, because all of you are saying that you want election, but if you fight tooth and nail on the maintainability and all the in the same breath you are saying that, and the moment after you are saying no, that is not possible because it's the maintainability. Then I have to hear it on merits, on maintainability also. You will cite 10 judgments, he'll cite 20 judgments, and I'll decide this.
Because my client wants the election.
If both of you want the election, why don't you agree to something?
Returning officer has already been appointed. The Lordship will appoint another returning officer. Let us understand.
They're not agreeable. Mr. Shen and Mr. Basu, this is going nowhere. You, in the same breath, all of you are saying you agree to an election, but you are not agreeing to the modalities of the election. So your agreement to the election, what is the modality? Tell me an agreed, something agreed.
Modality.
You are saying that if the notice remains, returning officer will be changed. Notice remains. He says, no, notice does not remain. So how can there be a reconciliation between the two? This is wastage of court's time, Mr. Shen. Either I hear it on merit and maintainability, or which I cannot do before the vacation.
Lordship, I am for the respondent number 6, Lordship.
Fresh notice in which all of you will sign, they will sign.
Somebody who will issue election notice.
Yes.
I could be utterly divorce the rules. Why should I appoint anybody who will issue the notice?
One day you will be the
Why should there be a court monitored election? No.
ego problem.
Courts are monitoring too many things beyond their business, Mr. Basu. I am not at all interested in the court monitoring an election of the table tennis.
My lord will kindly, I think,
association has already been ruined. Already been ruined by engagement of so senior counsel. All the associations have whatever ruin has to happen, it has happened. The players are suffering, Mr. Basu.
Say, we will jointly issue the notice today. We will sign and they will also sign.
Then the writ petition becomes infructuous.
Have to fix up the program.
My learned friend insists that
Somebody has shown me the where is the room.
joint secretary. Both of us will sign today.
67.
60.
You are one of the secretaries.
Yes.
And Mr. Bhattacharya.
Yes.
Client is one of the secretary and Bhattacharya's client is one of the
The fair proposal would be late this.
Both of you sign, issue an election notice, hold an election.
No, signing, they have to prepare the program of election and sign. They will. Let them do. They will do it and the election be held. Or should kindly appoint a special officer for the purpose
No,
of
Mr. Bhattacharya, that would be premature.
Not conducting.
You have challenged the notice at the notice stage. Why should I oversee the election? I have the election oversee.
I will consider
That would be to bring a Miller to quit us to the situation.
But only
Let someone be appointed Miller for the purpose of the supervising or overseeing.
If the election notice is issued jointly, Mr. Bhattacharya, because at this stage the election has not been held, your allegation is regarding the election notice not being without authority.
Okay, I agree.
So I'll set aside the notice. I'll say, I'll record your agreement that both of you will jointly sign an election notice and issue the same, and elections will be held accordingly. I'll leave it open for all of you to challenge if there is any further.
one prayer.
That will resolve your issue.
I think only one prayer. Kindly on Friday once again.
That is the only thing I wish not to do. If there is one thing I wish not to do, Mr. Shen, that is what.
That is, they will not sign. That is my prayer. Why are you saying, Your Lordship? 158.
They'll not sign you.
Not signed. When I gave them the notice last time,
Well, I'll keep them at a pen.
Milord, Mr. Sen's clients are overcharged.
You are for whom?
I'm with the association. That's what has happened.
Two secretaries are agreeing. They are Mia and Bibi. So you are.
I have no problem.
So I am the literally the Qazi.
158 should not be repeated. Kindly see once. 158. When I gave them this request, they said that you will have to sign an MOU with me. Otherwise, I will not sign the election.
No.
Lordship, may I? I am for the respondent number 6, my lord.
Who are you?
I am for the respondent number 6, Mantu Ghosh.
Yes, only not has his say. Yes.
The proposal was given when the matter was sub judice,
Anyway,
and
do you have any difficulty? Both the joint secretary, both the joint general secretaries agree to issue an election notice.
Not at all. Not at all.
Not at all means I constitute that you have no objection.
No, I don't have any objection, but it has to be in accordance with the constitution.
Immediately after the vacation, I'll record an order that both of you will issue a notice jointly, and if anything untoward happens, Lordship, you're fighting like babies.
The MOA means memorandum association, not more.
I'll direct the state to, because the state is also involved, as Mr. Ghosh is there, and Mr. Bhattacharya argues that he comes within Article 12. No, not among the council. Some Mr. Ghosh is there who comes under Article 12. Mr. Bhattacharya has argued. So I'll direct the state to provide perambulators to your client.
Lordship, one thing, Lordship. Lordship, one thing, Lordship.
There's no difficulty if everybody is sincere. We'll hold the joint meeting, joint secretaries, issue them the program, and the election be held.
Yes. As per the
Yes, no doubt about it.
Election notice will bind the time.
Yes.
Election notice in consonance with.
record the time by
I'll record that both the joint secretaries, Mr. Bhattacharya's client and Mr. Basu's client, agreed to issue a joint election notice in terms of the memorandum of the association and hold elections adhering to that and to the memorandum.
I agree with that.
Then I dispose of the writ petition. And both of you come in contempt, I'll decide in contempt.
Lordship, can it be at the supervision of the court, Lordship? My earnest request, Lordship.
A non-maintainable application should not be kept pending, Mr. Basu. No. And after holding all this, I'll say that the writ petition in any event is not maintainable, so I'll dispose.
after the election is over.
Lordship, one prayer is there. Lordship, one prayer is there. Sorry.
What prayer?
The election should be at the supervision of the court, my lord, because
No.
there are two other writ petition is pending, my lord.
That of this court monitor thing, we monitor everything except the law. No. We are exceeding our business. If there is any difficulty, definitely because I'm keeping the matter pending. As
Any court officer, Lordship, any court officer, Lordship.
Not right now. Then allegations will be suffered by the court officer. Not right now. If necessary, we'll do that. The present challenge has been preferred at the behest of one of the joint general secretaries of the petitioner association. Full stop. Next para. Learned senior counsel for the petitioner assails the impugned election notice issued.
One factual question. Petition is not an association, not the joint general.
Oh, I'm sorry. The petitioner association has challenged an election notice allegedly issued dehors the provisions of the memorandum of the said association at the instance of the president of the association, whereas the memorandum provides that the same has to be issued by the joint general secretaries together. Full stop. Next para. An objection as to maintainability is taken by the respondents at the outset. Full stop. Next para. However, during arguments, it transpires by interference by exercise of good office by learned counsel that a resolution might be arrived at inasmuch as both the joint secretaries of the petitioner association shall sign a fresh election notice, giving a go-by to the impugned election notice. Full stop. It is submitted that such fresh election notice shall be in consonance with the provisions of the memorandum of the petitioner association and pursuant thereto, the elections shall be conducted, also adhering strictly to the provisions of the memorandum of the association. Full stop. Next para. In view of such suggestions having come out, the both the joint general secretaries
of
of the
BSTTA, Joint Secretaries of Bengal State Stability Association. BSTTA.
both the joint general secretaries of the which respondent of respondent number 4, the Bengal State Table Tennis Association shall issue a notice by signing together the same, comma, such full stop, such election notice shall be strictly in consonance with the memorandum of the said association and shall be issued by tomorrow. Full stop. Next para. Pursuant to such notice, comma, the election of the association, said association shall be conducted, comma, also strictly in compliance of the provisions of the memorandum of the association in terms of the schedule specified in the said notice. Full stop. Next para. The writ petition shall be listed for passing further orders on June 17, 2024 to await the outcome of the above efforts of reconciliation. Full stop. Next para. It is made clear, however, that the objection as to maintainability is kept open for being decided at the final hearing of the writ petition, along with the other issues.
One humble shono.
Arekta line আছে, the parties shall act on the server copy of this order without insisting upon prior production of certified copy. Not tomorrow, day after tomorrow, by day after tomorrow. Day after tomorrow.
By day after tomorrow.
Well, by tomorrow বলেছি যেটা tomorrow টা না করে by day after tomorrow within bracket May 24, 2024. Because in any event, I am keeping it after the vacation. So
I'm not the impute notice stands it.
So, no, I've said in that in your submissions that thereby waiving the previous note. I put it somewhere. I'll only have to ensure that waiving the spelling is correct.
Another blood. In the order sheet, Lord, the petitioners association, the petitioner should not be
right. Petitioner association অনেক জায়গায় বলেছি।
Taking maintainability point, that maybe can be.
Petitioner association না বলে the respondent number Bengal Table Tennis Association যেটা বললাম respondent number 4 most of it ওইটা করে দিও, করে একটা বোল্ড যেখানে ডাউট থাকবে বোল্ড লেটার করে দিও, আমি দেখি। আর যেটা লাস্ট লাইন বললাম, লাস্ট লাইনের আগে listed on such and such date along with the connected applications. Yes.
Supplementary list item number 1.
নামটা একটু বলে দাও, প্রিয়া নন্দী ঘোষ।
Cause title Priya Nandi and another versus Sri Anand Rai and others.
My lord, after my lord, I have mentioned they have.
You are appearing why this is happening.
No, my lord. I'm telling.
Yes.
They have now approved, my lord, but they have not approved 5
Must be some mistake or something.
Actually, there was some technical issues, my lord. Other than that, we have categorically stated, and they have also given an approval earlier also. But there may be some technical mistakes, my lord. Actually, we have given the approval, and we received at 12:30.
You will personally appoint to the special officer, otherwise to remain in the hospital and ensure that they get the cashless.
My lord, one thing, my lord, the claim was for 5 lakhs. They have, my lord, sanctioned for, my lord, I think 4 lakh 47, my lord.
That I cannot go.
4 lakh
The writ petition is pending, otherwise pending. It has been disposed.
The writ petition is disposed of. No.
No, give a copy of this to them.
My lord, kindly sees. This is the email, my lord, received by me.
See the copy he's handing over. I'll keep that on record. Email or kaise da.
My lord, I'm reading out. This is the first page.
Do you have an extra copy of this? Give it to your. Yes, please read it.
No, I have to take it.
No, you're taking it away from him. How can he see?
No, given, my lord.
Given.
Kindly sees, my lord.
Initial pre-authorization request. I have a copy of that also.
Yes, my lord. Kindly sees, my lord. 4 lakh 90, 74.
Total approval 4 lakh 74 773.
No.
Initial, my lord, please see.
Initial is 4 lakh 90,000.
Then total initial pre-authorization approved amount is 4 lakh.
Will cover the entire amount. I'll record that submission of yours.
And thereafter that, my lord, please see total initial approved amount. That second one, 474.
Pre-authorization approved amount. No, requested amount is. Acha, very well. The approved pre-authorized approved amount is 474 773.
Our hospitals require 4,90,000.
Very
So we have approved 4,90,000.
Right.
We have given initially 474,770.
The matter was taken up out of turn. The matter is being taken out of turn on being mentioned by the petitioner, whose learned counsel for the petitioner had earlier in the day mentioned that despite the connected contempt application bearing CPA 261 of 2024 having been disposed of by discharging the connected rule on the premise that the alleged contemners have acceded to the claim of the petitioner to grant cashless insurance facility for the petitioner's operation, comma, the alleged contemners have subsequently repudiated such claim again. Full stop. Next para. When the matter is called on for hearing, comma, however, comma, learned counsel for the alleged contemners assures that there was a technical glitch on the part of the alleged contemners office, and the alleged contemners agreed to cover the full amount by cashless facility as required for the operation of the petitioner in terms of the submission made before this court earlier. Full stop. Learned counsel for the alleged contemners also hands over the printout of a document captioned as initial cashless authorization dated May 22, 2024, wherein it is indicated that the total, the initial within bracket pre-authorization requested amount was rupees 4,90,000, and the total initial within bracket pre-authorization approved amount was rupees 4,74,773. Full stop. Next para. It is contended that the said amount as reflected in the document handed over today only reflects the pre-authorized, the initial approved amount, and the alleged contemners shall ensure that the entire coverage for the operation of the petitioner shall be given in the cashless mode by the alleged contemners. Full stop. Thus, comma, there is no, thus, comma, it transpires that the misunderstanding occurred due to certain technical glitches, and the respondents reiterated through counsel that they would abide by the submissions made by them in court earlier. Full stop. Thus, comma, keeping the document handed over in court today on record, comma, the matter is treated to stand disposed of, full stop, in view of the rule having been already discharged and the contempt disposed of, comma, no further order need be passed to that effect. Full stop. However, comma, in the event there is any further complaint regarding non-compliance of the above assurance by the alleged contemners subsequently, comma, it will be open to the petitioner to make a short application and bring the matter to the notice of the court. In that event, please make an application and so that they have a chance to repudiate. Thank you very much. Thank you. Thanks to you to resolve the issue so quick. Yes.
Main list item number 18.
My lord, I am for the petitioners, my lord.
State, yes.
My lord, the petitioners.
You are the state.
My lord, the
Mr. Bosumuli comes under Article 12 now. Yes. Yes, what is the matter?
The petitioners, they are childless spouse, my lord. During their last 17
Assisted Reproductive Technology Act, yes.
My lord, I have taken the respondent.
You are from India? Because I have been dealing with only Bangladeshi petitioners under this act.
Well,
This is a change, yes. So you are overage. One of you is overage.
One of both. No.
Both are overage.
One is, my lord, 50 plus, one is 54 plus.
54 plus is not overage. 55 is the upper.
Yes, my lord. Yes, my lord. And one is overaged. My lord, petitioner.
There are only two people in a couple. You say one is 54 plus, one is 50 plus, and another is overage.
No. My lord, petitioner number one, she is.
These are serious allegations. Yes.
She is overaged, my lord. And
the husband is, what is the age of the husband?
54 plus.
54 plus is within age?
Within age.
And the lady is 50
Lady
plus?
is 50 plus.
Or 50 is the upper age limit. So then how can it proceed?
My lord,
he has to carry the baby, then she cannot give her oocyte.
We approach the respondent number 4. My lord, they give the.
There is no scope of exception in the act.
Mentally and physically.
No, but the act has been made keeping.
Your lordship also in one matter, my lord.
No, I have interpreted the law. I've said that if one of the couples comes under the age limit, then it's all right. But that one person in every case has been the husband.
My lord, here, my lord,
Mr. Boshu Malik, is there any scope? I mean, if
No, my lord, in the lordship has knows
here
this
the
is
husband
21
is underage.
No, the husband is also 55 years. According to his own document.
Which document?
Kindly come to page 36. I do not know. This is the Aadhaar card. My lord, kindly see. Janmo Tarikh 22/7/1969. And the wife, my lord, the two documents he has annexed, my lord, in Aadhaar card 51 years and in Madhyamik certificate 50 years.
He is not yet 55. He has not crossed 50. 55
Now, my lord,
going on.
it's below 55. So for the rule
Oh,
is concerned, my lord,
yes,
kindly seen, my lord, 21G, my lord.
Right.
Below the age of 55 years.
Have you got a copy
Yes,
of
yes,
this?
my lord.
Hey, assisted reproductive. Break that I cannot repay you. We better give a hard copy. Now I cannot repay you. Assisted reproductive technology act ছিল তো আমাদের।
His own admission in paragraph 19, my lord.
What does he admit?
That the petitioner state that unfortunately because of the prescribed age under 21.
Yes, so far petition number 1 is concerned. My lord, admit card, your lordship will find that.
He's running 50. She's running 50. So she should be 50 years. I mean, still below the age of 50. 50 years will happen when she crosses 50 and steps into 51.
My lord,
That liberal interpretation can be given. Sir.
no, lord, so far 50 is concerned 4th of January 74 in one document and another document is, my lord, 73. That's the whole. Kindly see, my lord, both
So
documents.
50 we can.
35 admit card.
35 and 34.
Thank you. এটা ফেরত দিতে ওনাকে ওই মহিলাকে ফেরত মিস্টার বসু
4 and
34 and 35.
34 and 35.
is the
Let us.
admit card.
Yes, calculate what will be the age.
Yeah, 50 years. I've calculated, my lord. 50 plus. January. 7th.
January means yes.
4th January.
51.
That's
So
right.
she does not qualify. And the gentleman?
Gentleman, my lord, kindly see, my lord.
54 plus.
69, my lord, within next 2 months. But I do not know actual age, my lord. If he relied on two documents, then why not his?
No, what about the husband? Which page you cited?
Husband, kindly 36, lord.
36.
Lord.
July 69 date of birth.
Yes, but here, my lord, below 54, below 55.
54.
55.
54 plus, yes.
Unless it becomes 55, it's below 55.
I am not saying anything, but the lady, my lord,
If 55 is continuing, that is also below 50. I'll have to construe that. Bit difficult to construe.
Lord.
Why did you wait for so long?
My lord, there
What,
are
my lord?
two
I am not
times-
responsible.
my lord, 2 times there was. My lord, there was 2 times, my lord, miscarriage, my lord.
I understand. Obviously, there is some agony on your part for you to come up.
And you lordship judgment 1, my lord.
Show me that judgment. And you will be, after the vacation, you will become, soon after the vacation, you will cross 55 also.
My lord. 923.
So what did I say here?
My lord, same thing, my lord. His husband was 59 years, my lord. Wife was 146 years.
That
But one of
wife,
them-
wife was 46. But here, my lord, both of them are, my lord, not come within
only
the
one,
prescribed.
No, the difficulty is assisted reproductive technology. Ultimately, the gamete that has to be, the embryo has to be put back into the wife's womb. So if there's a miscarriage, I mean,
lordship,
and
can you
there
see
has
page-
been a history of miscarriage,
My lord, page
why don't you go
37.
for adoption or some other
My lord,
technology?
page 37, my lord. The Respondent number 4 has given the
It is
date.
risky.
It
It is
preserved, my lord.
risky.
It
This
has
is
been-
for the baby also who will come into this world.
My lord, it has been preserved, my lord.
See, you have a history of miscarriage, right?
Twice, not once, my lord.
Twice. Yes, he's admitting that. But now that embryo has to be placed in your womb ultimately. You are overage. How can I direct? Because if the husband was overage, I could have understood. That is probably a bit difficult.
My lord, it has been, my lord,
It will be
preserved,
stretching
my
the
lord.
act too far.
Lordship, page 37.
Yes, what
The
page 37?
certificate.
The certificate, my lord,
given
what
by the
the certificate cannot improve the.
No. You have your
employees
embryos
have
preserved.
already been preserved.
This is dated 20. When was where the embryos taken?
It was a April, my lord. This certificate has been given. না 16 থেকে ট্রিটমেন্ট হচ্ছে
In also 50 plus.
Yes, I'll. The petitioners are a married couple under the provisions of the assisted reproductive technology within bracket regulation bracket close act 2021 push up the petitioner the date of birth of the petitioner number 1 comma who is the wife comma
page
is
35. Page 35, my lord. 4th January 74.
is January 1 1973 as per her Aadhaar card and as per her
Admit card, lordship.
admit card for the West Bengal Board of Secondary Education Examinations, comma, January 4, 1974. Full stop. Thus, comma, the petitioner number 1 has barely crossed the age of 50 years. Full stop. Next para. On the other hand, comma, the date of birth of the petitioner number 2 husband as per his Aadhaar card is July 22, 1969 and thus, comma, he is running 55 years of age. Push up next para. The couple was refused the services under the 2021 Act on the ground that they are overage. Push up next para. Heard learned counsel for the parties. Full stop. It transpires from section 21 within bracket small g of the said act that the upper age limit of that the said technology services shall be applied to a woman above the age of 21 years and double inverted below the age of 50 years double inverted close, whereas the man has to be above the age of 21 years and double inverted below the age of 55 years double inverted close full stop. Next para. In the present case, comma, learned counsel for the petitioner has placed reliance on a certificate issued by the concerned clinic annexed at page 37 of the writ petition, wherein it has been indicated that 5 embryos of the petitioner number 1 have been preserved in cryolocks, CRYOLOCKS, and she is mentally and physically fit for embryo transfer and to carry on pregnancy for successful outcome. Full stop. The date of the certificate is April 17, 2024. Full stop. Next para. Insofar as the petition number 2 husband is concerned, comma, the question which is to be decided is whether the embargo in section 21 within bracket small g of the act applies to a person or to a man who is running the age of 55 years. Full stop. Next para. The bar is stipulated to be the bar is couched in a language that a person has to be below the age of 55 years at the relevant juncture. Full stop. The said expression can be construed in 2 ways. Hyphen. First, comma, that at the relevant juncture, comma, the petitioner, the man has not yet touched the age of 55 years, and secondly, comma, that the man has not yet completed 55 years of age. Full stop. Next para. Since the object and purpose of the Reproductive Technology Act is to regulate and supervise the booming trend of couples availing of assisted reproductive technology, comma, the interpretation of the concerned section ought to be in a liberal manner, comma, in order to extend the benefit sought to be advanced by the Act to the subjects of the Act and the target groups. Full stop. Next para. In the present case, comma, the petitioners have had 2 miscarriages previously and desperately seek a child for which the services under the 2021 Act has been sought to be availed. Full stop. Thus, comma, only a liberal interpretation ought to be given to section 21 within bracket small g. Full stop. Taking a cue from the above observations, comma, the fact that the petitioner number 2 is has not yet completed the age of 55 years from his date of birth, comma, it has to be construed that he is still below the age of 55 years as required under section 21 within bracket small g within bracket small ii of the 2021 Act. Full stop. Next para. Moreover, comma, since the petitioner number 1 has barely crossed the upper age limit, even going by the Aadhaar card, comma, although even going by the other category, comma, and has 5 embryos already preserved, comma, particularly in view of the certificate given by the concerned clinic that she is otherwise physically and mentally fit for embryo transfer and to carry on pregnancy, comma, I do not find any reason to prevent the petitioners from going for such services. Full stop. Accordingly, comma, in view of the above observations, WPA 14095 of 2024 is disposed of by permitting the petitioners to approach the clinic is also a respondent.
My lords,
No, my lord, so far this clinic is concerned, my lord. So far this
They are also
document-
dubious.
No, my lord, kindly see paragraph 16 once.
What have
they
they-
says, my lord, the petitioner states that when they approach the respondent number 4, the next step of embryo transfer, which is preserved with the respondent number 4 clinic to the petitioner
approach,
number, they are informed, my lord, kindly see, they are informed that because of the ART Regulation Act 2021, the embryo transfer cannot be done unless necessary permission is granted by the
Yes.
appropriate authority.
Exactly. That is why the petition has been. To approach the respondent clinic and or any other clinic providing such services, comma, to have assisted reproductive technology services from the said clinic. Full stop. As and when so approached, comma, the said clinic shall act on the server copy of this order and ensure that the said procedure is the benefit of the said procedure is given to the petitioners at the earliest. Full stop. No orders to cause sudden settlement. Let them have the benefit. Yes.
আমি আবার কি করব? No, but since no affidavit has been exchanged, will kindly add that line also.
You are denying what? Their age?
No, I'm not.
এটা কি আমাদের বই তো? Yes. Sorry for being late. Yes. Call on the list.
Item number 19.
19, my lord, I beg to appear on behalf of the petition.
I am for distribution company, Lordship.
Right.
My lord, the prayer for.
Any other party is there?
Lord, I have.
My private
I have
party
checked
is
that.
there. Respondent number 6.
Private party has been served.
Sir.
So due to their resistance, you are not getting electricity.
My lord.
Yes,
The
Lordship.
observation is that due to pendency of the civil suit
Yes, one of the.
connection, that appears at page 61.
There is no injunction order.
No, my lord.
What is the
Lord, may I see the background?
please check up one item delivered is to sender. Please check up whether this is the private respondent. Dao Aditya.
Lord, I have got the copy, man.
Acha, you have. Please come to page 7. Please check up because
Page 7, my lord.
of your
Item delivered to send.
sender means it has returned.
I am yet to receive.
No, even then, is this the private respondent?
Yes, and
This is the private.
We'll have
actually
to
he
wait
is
for
giving
some.
objection.
The affidavit of service filed today be kept on record. Full stop. Since service has not been duly effected on the private respondent. Wait a minute. These postal entries make no sense. Now I'll take up because item on hold because door locked. So that 10 hours should be. Acta order record karo. Affidavit of service filed today be kept on record. Full stop. Regarding service on the private respondent, it transpires that service could not be effected because the door of the private respondent was found locked, although the address has not been stated in the postal endorsement to be wrong. Full stop. Hence, it is deemed that good service has been effected on the private respondent. Yes, you have held inspection.
Yes, yes.
Inspection held.
Inspection was held and we are restrained actually by the private party.
Very well. Learned counsel for the
Necessary police may be.
Learned counsel for the petitioner submits that due to resistance by the private respondent, the writ petitioner is not getting electricity connection, which stand is corroborated by learned counsel for the WBSCDCL. The report filed by the police be kept on record. Full stop. Since the petitioner being in occupation, is entitled to electricity connection, WPA 14120 of 2024 is allowed, thereby directing the WBSCDCL to give electricity connection to the petitioner within a fortnight from date. Full stop. They have complied with formalities.
No.
As well, subject to compliance with all formalities. Full stop. Next para. In the event any resistance is offered by the private respondent and/or his men and agents, the WBSCDCL personnel shall approach respondent of 5, the officer in charge of the Joynagar police station, who, acting on a server copy of this order and at the cost of the petitioner, grant such assistance to the WBSCDCL personnel, if necessary, by removing any padlock or other hindrance to facilitate the same. Full stop. No arrest to cause urgency. Thank you.
Great.
Item number 20.
Ganguly,
My lord, I am for the petitioner. My lord, my electricity connection was denied by the my lord.
What about service, Mr. Ganguly?
My lord, service, my lord. Here, my lord, there is a private respondent. My lord,
Then?
who is the landlord? My lord, now, my lord, kindly come to the.
You have not implemented the landlord.
Yes, my lord, I have not implemented. My lord.
They are the objectors.
They have filed a written objection saying that eviction suit is pending.
That is not a ground, but
They have to make.
My lord, I have to make it.
the petitioner has filed the writ petition due to the petitioner seeks electricity connection. Full stop. Learned counsel for the distribution license submits that the petitioner could not be given such connection due to resistance by the landlord of the petitioner.
No resistance.
We could not
They
take the
say
inspection even.
no. My lord, kindly come to their letter.
Inspection.
No, बोला मैंने तो letter देख. My lord, kindly come to page 19. My lord, what he says, my lord, your request, my lord, as per report of the tailor, second paragraph, technical personnel, no land ownership papers, legal occupier certificate in the name of the applicant.
Yes, I'll record the submission. uh, due to resistance by the landlord, comma, no connection could be given. Full stop. Next para. Learned counsel for the petitioner points out that in the refusal, comma, annexed at page 19 of the writ petition, comma, the WBSCDCL insisted on production of land ownership papers stroke legal occupier certificate for giving such connection. So be that as it may, comma, since there is resistance from the private landlord, from the landlord, comma, it would be appropriate that the landlord of the petitioner should be implemented as a party. Accordingly, the learned advocate on record for the petitioner is given the liberty to carry out necessary amendment to the cause title, impleading the petitioner's landlord stroke objector. Full stop. A copy of the writ petition shall be served on the added respondent at the earliest, and an affidavit of service to that effect shall be filed on the next returnable date. You are filing an affidavit of service. Yes. The affidavit of service filed today, comma, however, comma, be kept on record. The matter shall next be listed on June 17, 2024 under the same heading.
Deeply appreciated. Our praise affidavit of service code.
Item number 21.
I pay for the
Yes.
petition.
Service?
Yes.
Section 14.
Effective, yes. Pending since September.
You should leave section 14 to your juniors, Ms. Zoja. You are sufficiently competent to move better matters. Anyway, there is no section 17.
So I have ascertained there is no pending.
Learned counsel for the petitioner stroke financial institution submits that the petitioner's application under section 14 of the Surface Act 2002 has been kept pending inordinately beyond the statutory outer limit. Next para, on query of court, comma, learned counsel further submits that there is no pending application under section 17 of the Surface Act 2002 regarding the property, regarding the secured asset. Affidavit of service filed today be kept on record. Despite service, none appears for the respondents. Para. Accordingly, WPA 14186 of 2024 is allowed, directing the respondent number 2, that is the district magistrate Paschim Bardhaman, to dispose of the petitioner's application under section 14 of the Surface Act 2002 as expeditiously as possible, positively within 4 weeks from the date of communication of this order to the said respondent. No arrest to cost adjustment.
Item number 22.
Similar.
Yes, Your Lordship. The private respondents, the envelopes for them has the postal, the
What
report says
endorsement?
that left without instructions.
Then
But the state has been served, Your Lordship. In any way, there is no application pending. The
same
address
order.
is correct, Your Lordship.
Bucket is same. Yes. Both are Paschim Bardhaman.
Item number 23.
For the petitioner. There is affidavit of service.
There is a private respondents.
But at top, my lord, up to 20 till date, my lord, it shows that it is dispatched
When did you send?
on 17th, my lord. The first
17th.
the fast track report is for the private.
17th. So today we are on.
This is
Well, they have strong objection. At least, my lord, the objection petition, they have signed at least, my lord, more than 100 people.
well, the private
So, my lord,
respondent is an
their presence is required.
Come back after the vacation. Since service, affidavit of service filed to be kept on record, since service has not yet been effected on the private respondent, let the matter stand over till after the oncoming summer vacation.
well,
When it comes back, just file another.
Item number 24.
I appear for the state respondent in this matter.
14.
Yes, Your Lordship.
14
It is pending from September
There are private
21.
respondents.
Service on private respondents.
Your Lordship, some postal track says that it has been returned with remarks left. But there is no, I have ascertained from the bank, there is no pending surface application.
The petition affidavit of service filed to be kept on record. The petitioner's grievance is that the petitioner's application under section 14 of the Surface Act has been kept pending inordinately. Push up. It is further submitted by learned counsel for the bank financial institution stroke petitioner that there is no pending proceeding under section 17 of the 2002 Act of the Surface Act 2002. Accordingly, WPA 14200 of 2024 is disposed of by directing the respondent number 2, that is the District Magistrate Paschim Bardhaman, to dispose of the petitioner's application under section 14 of the Surface Act 2002 as expeditiously as possible, positively within 4 weeks from the date of communication of this order to the said respondent. No order is to cause urgency.
Item number 25.
Lordship, I am for the petitioner, Lordship. Lordship, one thing is, Lordship, the private respondent has not been served.
Not been
Lordship.
served. Since service has not yet been
I have served
completed.
the state, Lordship.
Well, since service has not yet been completed on the private respondent, as it transpires from the affidavit of service filed in court today, let the matter stand adjourned till after the oncoming summons.
Lordship.
Thanks. Yes. You are for the private respondent?
No, I'm for the state.
Doesn't help. Yes.
Item number 26.
I am for the petitioner, my lord. The electric new connection.
Service affected?
My
Oh,
I am for the distribution license.
But I am for the private.
private respondent, yes.
I do not know what is the number of the private respondent because I have not received the copy of the petition, but I have received the
Instruction.
notice by the ACDCL. Well,
I
on the
will
date of inspection,
recorded honor, my lord. I am page 20.
You are recorded on they're obstructing.
Yes, no, my lord. Yes, my page 17, my lord. I am recorded honor, and 18 is also recorded honor, and 20, my lord. Kindly see that 20. The person already enjoying electricity from that post upon the point which has been fixed on Panchayat Road. And my also electricity connection from that post, but he's physically obstructed. He is my neighbor, he is my cousin. He also same plot in my enjoy electricity, my lord.
What do you say, Mr. Bandyopadhyay, first?
My lord, as per my lord, our agency went there. My lord, here is a my lord, handwritten, hand-drawn sketch, my lord. The lords will find, my lord, 3 poles are required to be, my lord, erected there. My lord, these houses, my lord, other side of the pond. My lord, he has mentioned about the Barampot. That is the, my lord, other side of the pond. My lord, 3 poles are to be, my lord, erected. My lord, a small passage, my lord, 2-3 feet wide. And my lord, there is a land dispute. My lord, only because of the obstruction of the private respondent, it could not be effected.
Physically obstructed.
No, how is the private respondent? How are you enjoying electricity?
Enjoying electricity.
the way he is asking to get electricity, madam. That passage, madam, 2-3 feet wide passage, though I don't have the copy of the petition, but only from the instruction from the private respondent, madam, I do not know the numbers of the private respondent. Madam, that portion that has been given by both the private respondent, as I am.
You must be enjoying electricity connection.
But I am enjoying.
3 private respondents. Three numbers of private respondents are there.
Madam, from our portion of land, we leave that portion 1.5 feet each, and on that portion, my lord, he.
So, Bandyopadhyay, file a report. Hold an inspection, file a report.
Yes, yes.
On notice.
But kindly direct him to.
Please give a copy to her.
Right.
Extra copy. She'll pay for the Xerox.
My lord, get it. I am giving.
Learned counsel, the dispute which is arisen in the present case
There is no written objection. Only
yes, written objection is there.
revolves around the petitioner's application for new electricity connection. Push up, due to resistance of the private respondents, the WBACDCL could not give such connection. Push up, learned counsel for the WBACDCL submits that there is a narrow passage over which 3 poles have to be erected to give connection to the petitioner. Push up, next para. Learned counsel for the private respondent submits that it would not be possible to give such connection over the said passage due to the narrow width of the same. Push up, next para. Be that as it may, since the petitioner, as an occupier, has a right to get electricity, it is for the WBACDCL to ascertain as to what is the best route to give such connection. Push up, for such purpose, the WBACDCL shall hold an inspection upon prior notice to the petitioner and the private respondents for the purpose of ascertaining the best route to give electricity connection to the petitioner by hampering the interest of as less people as possible. Push up, a report in that regard shall be filed upon such inspection on June 17, 2024, when the matter shall next be listed comma, upon service of advanced copies of the same on the learned advocates for the petitioner as well as the private respondent.
Will
Great.
it be permitted to file an affidavit?
No, no. No, if the report goes against you, then I'll give you liberty to file exception, both of you.
Same passage, they are enjoying it, same passage. They are enjoying electricity, madam.
When the WBSCDCL personnel visit, you can show that, your client can show that they are already enjoying from that.
No, 1 second, a joint inspection will be held, but it has already been
In that
held.
inspection, do it with the motive of giving connection. I mean, if some
So
possible,
far, I have taken inspection, there is no alternative route. That is the only way.
then you ascertain whether they are taking, others are taking connection over there.
Petitioners are claiming that their grandfather has donated that land, the Barampot.
Yes.
They are claiming that they have landed property in that.
They have landed property, but how others are enjoying in the area, you also have to ascertain.
Yes.
Same plot, madam. Both the same plot. They cannot obstruct. File a gate floor.
And item number 27.
You're plotting against each other. Yes. Who is appearing?
But I'm for the respondents.
Respondent.
Yes. Right.
Not required. None appears for the petitioner, although the respondents are represented through counsel. Let the matter stand over till after the oncoming summer vacation.
Item number 28.
But I am for the petitioner, my lord. My lord, after vacation, my lord, I have sent the
Not service. Learned counsel for
to appear,
oh,
but I have not received. Private respondent also appear.
learned counsel for the petitioner submits that service has not been completed on the respondents who serve. Even learned counsel for the WBSCDCL is not equipped with a copy of the writ petition. Who serve accordingly on the prayer of counsel. Let the matter be adjourned and be listed in the monthly list of June 2024.
Item number 29.
I am for the petitioner, man.
Yes.
But I appear, but service is not complete because the answering respondent, our local office heard from the entire material will come. Not, he has not received it today.
Tax report not available. I'll take it up after vacation. Service is not yet complete. Let the matter stand adjourned and be listed in the monthly list of June 2020.
Obliged to Lordship.
Item number 30.
My lord, I am appearing on behalf of the petitioner, my lord. Petitioner, my lord, install.
All have been served?
Yes, my lord.
There is no private respondent?
No.
Acha, what is the matter?
The petitioner installed a submersible pump in his own land, my lord. Petitioner applied for application.
Why are you not giving?
9-6.
Your
Your lordship,
such. There is no meter room, my lord. This is
Meter room? What else? No, there is a submersible pump there.
Yes, my lord, but no meter room is there, my lord.
Give them liberty. What is
I
that?
applied for one application and quotation is
Keep it with you.
quotation.
They are not
I
disputing that.
requested
You have to
for
install the meter room. I'll give you that liberty. Install the meter room within a week. Keep it with you. Install the meter room within a week. They'll give connection after that. Learned counsel for the petitioner submits that the petitioner applied for electricity connection to operate his submersible pump and complied with formalities, but such connection has not been given. Who's of learned counsel for the WBSCDCL submits on instruction that the petitioner is required to construct a meter room for the connection to be given. Who's of next para, accordingly, WPA 14291 of 2024 is disposed of by directing the petitioner to construct a meter room at the locale where the electricity connection has been sought. Immediately upon such construction being made, the petitioner shall intimate in writing to the WBSCDCL about such construction. The WBSCDCL, upon receipt of such intimation, give a new electricity connection to the petitioner subject to compliance of formalities otherwise by the petitioner, within a fortnight thereafter. No rest to cause urgent ceremony. Thank you.
Item number 31.
31, my lord, I am the petitioner, my lord.
Same.
Same.
Everything same, yes.
There is no pump set and no.
My lord,
My lord.
kindly my lord, petitioner apply for paragraph.
No, there is no pump set.
No, my lord, kindly see page 3. I apply for application.
What is that?
My lord, I have stated in paragraph 2.
You install the pump set. I'll give you some time. They'll hold inspection.
Install a pump set, my lord.
Learned counsel for the petitioner submits that the petitioner applied for electricity connection to operate his submersible pump, but was not given the same. Stop. Learned counsel for the WBSCDCL hands over a black and white picture, black and white photograph indicating that there is no pump set installed, nor is there any meter room on the locale. Full stop. Next para. In order to enable the petitioner to install a pump set and a meter room, comma, the matter is adjourned till June 17, 2024. Full stop. The petitioner shall immediately install a pump set and a meter room and thereafter intimate in writing to the WBSCDCL about the same. Full stop. Upon such communication by the petitioner, comma, the WBSCDCL shall hold an inspection and file and intimate the court on the next returnable date as to whether all compliances have been made by the petitioner for passing further orders. June 17, intimate to them, you just inspect after that. You need not file a report, intimate, take instruction, intimate. Yes.
Item number 32.
My lord, I am for the petition led by Subramanian. My lord, service has not completed, my lord.
Service is not yet complete. Let the matter be listed in the monthly list of June.
Item number 33.
May I please, your lordship? Lordship, my section 14 application remains pending till 29th of November 2022.
Service on private list.
Lordship, this is the photocopy. I shall give to your lordship's officer in course of the day.
No, private.
Yes, it has been served.
Any section 17?
Yes, section 7 is pending, but there is no stay. Kindly come to. Yes, section 14 is pending. If your lordship kindly come to section 17. Kindly.
19 to 22, my lord. He made an application before the district magistrate.
You are for the private respondent?
No, state. I am appearing on behalf of the state.
You have disclosed in your section.
Yes. Lordship, kindly come to page number 6, paragraph number, first paragraph, last line. In the middle portion, page number 6, middle portion of your lordship's place.
This on the prayer of learned counsel for the petitioner, comma, who submits that due service has been effected on all the respondents, comma, leave is granted to the petitioner to file affidavit of service during the course of the day. Full stop. Subject to such filing, comma, the writ petition is taken up for hearing. Full stop. The innocuous prayer of the petitioner is that the petitioner's application under section 14 of the Service Act has been kept pending inordinately beyond the statutory outer limit. Full stop. Next para. In the application under section 14 and in the writ petition, comma, it has been disclosed by the petitioner bank that although there is a pending application under section 17 within bracket 1 of the 2002 Act, comma, no interim stay order has been passed therein. Full stop. Thus, comma, there cannot be any impediment for the district magistrate not to dispose of the petitioner's application under section 14. Full stop. Accordingly, WPA 14345 of 2024 is disposed of by directing the district magistrate within comma Hooghly within bracket respondent number 2 bracket closed to dispose of the petitioner's application under section 14 of the Service Act as expeditiously as possible, comma, positively within 4 weeks from the date of communication of this order to the said respondent. No orders to cause urgency.
Grateful, lordship.
You have got it.
Lordship, with regard to the next item, affidavit of service is with me.
আচ্ছা এটা রেখে দাও এর মধ্যে, but please ensure that this
Yes,
is
lordship, may I take it back and hand it over? ওটা দিয়ে দিন, আমি
ওটা
original
দিয়ে দিলে একটু নাম্বারটা দিকে ঢুকিয়ে দিন। Similar,
but affidavit of service is with me. Original.
Item number 34.
Lordship, here also section 40, section 17 is pending, but there is no stay. I've indicated in paragraph number 6. Page 6, lordship. Page 6, middle portion.
previous one was also
Yes.
district magistrate Hooghly.
Yes, same district magistrate.
Exactly same order.
But
শুধু একটা জিনিস affidavit of service এর জায়গাটা প্রথম লাইন affidavit of service file to be kept on record তারপর যা আছে exactly same. Thank you.
Similar order may be passed for the next item.
Item 35, I'm appearing on behalf of State Lordship.
Item number 35.
No difference.
No difference.
Hooghly.
Yes.
Should report from Chinchura PS.
পরেরটা একই অর্ডার হবে, শুধু একটা লাইন অ্যাড করে দিও প্রথমে, the report filed by learned counsel for the state be kept on record.
I'm grateful,
My
lordship.
I am for the respondent number 6 and 7 for item number 35.
35.
35 you are appearing?
Yes.
তাহলে দাও ওটা আলাদা অর্ডার। Yes, you have filed a section 17 but there is no stay order.
But there is actually till now I have not yet filed Wakalatnama. Yesterday I have just received copy. So
You won't get any time to file Wakalatnama.
taking for filing the Wakalatnama.
By today?
By next Friday.
Acha, very well. Affidavit of service filed to be kept on record. Full stop. Learned counsel having instruction to appear for the private respondents seeks leave to file his Wakalatnama by May 24, 2024, which liberty is granted to the said learned advocate. Full stop. The grievance of the petitioner is that the petitioner's application under section 14 has been kept pending beyond the statutory outer limit inordinately. Full stop. Next para. Although there is a pending application under section 17 within bracket 1 of the Surface Act 2002, there is no subsisting interim order passed therein.
Yeah, please.
Yes, quick.
My lord, I used to file. Please direct me to file a affidavit.
Next para, such contention is not disputed by the private respondent who seeks to file an affidavit in opposition to the writ petition. Full stop. However, there is no scope of granting such opportunity to file an affidavit, since there is no disputed question of fact involved. Full stop. The prayer for affidavit in opposition is obviously a ploy of the private respondents to further delay the disposal of the application under section 14. Full stop. Hence, such prayer is refused. Stop. WPA 14349 of 2024 is disposed of by directing the district
Respondent number 2, district magistrate
the district magistrate Hooghly within bracket respondent number 2 to dispose of the petitioner's application under section 14 of the Surface Act as expeditiously as possible, positively within 4 weeks from the date of communication of this order to the district magistrate. The report filed by the state be kept on record. No orders to cause urgency.
Lordship, affidavit of service may be kept on record.
First line.
I'm grateful, Lordship.
Item number 36.
Grateful Lordship.
My lord, I prefer respondent 1 and 2.
Yes. Respondents,
My lord.
Mr. Bandhavadi, are you trying to come here for this matter? No. None appears for the petitioner, although the respondent numbers 1 and 2 are represented through counsel. Let the matter stand over till after the oncoming summer vacation.
36, I am appearing, my lord. After,
Where were you?
my lord, I was in code number 11, my lord, 2 p.m.
What is the matter? That is your order ticket. Yes, what is that?
I am grateful, my lord. My lord, this matter, my lord, a letter of intent, this pertains to, my lord, issuance of distributorship at Barakpur Kollani Expressway. I applied for
distributorship for what?
Distributorship LPG. I applied for distributorship. Interview was taken. My name was included in the panel as the second best candidate. Now, thereafter, my lord, the first candidate's name was deleted because he furnished a false sales experience certificate. Letter of intent was issued in my favor in 2013. That is, my lord, at page 18. Thereafter, a revised letter of intent was issued on 8th March 2013, which is at page 21. Thereafter, my lord, this first previously whose candidature was cancelled, he preferred a writ petition before this honorable court, which was disposed of. It continued till 2019, and it was disposed of on August 2019, directing the authorities to consider both the cases and pass a reasoned order. Now, they have passed a reasoned order in my favor. They have said that the candidature, that the distributorship, LPG distributorship should be issued in our favor, in my favor. Now, thereafter, the problem arises. Now, there are various, my lord, formalities which I required to be completed, which are required to be complied. One of them was furnishing an affidavit, and thereafter a minutes of the proceeding was held. My contention before your lordship is twofold. One is they are showing a unified guidelines of 2022 in respect of my letter of intent of 2013. That is one of my contentions, because that cannot be, guidelines cannot have a retrospective effect, because it is not even a piece of subordinate legislation. And number two is that my candidature, my distributorship has been intended to be transferred to a Gramin area. Whereas I have stated in paragraph 6 of my writ petition that my distributorship falls in a mixed population area, which is 500 feet from Barakpur municipality. So it cannot be a Gramin area.
Even I have made respondent number 3, who is the Register and Census Commissioner a party. My lord may be aware that a particular area, whether it is a rural or urban area, can be decided only by the central government, and the authority is the Register and Census Commissioner.
Which respondent is the census?
Respondent number 3. Indian Oil cannot usurp the jurisdiction and say that no, it's not an urban area, it's a rural area. You have to be your distributorship should fall within Gramin Vitarak area. These are my 2 points, my lord.
Under which provision does the census commissioner have that right? I'm not aware.
My lord, the provision, they're an independent authority under the central government.
Let me hear you, Leonard Friend. Yes.
My lord.
My lord, he's agreed by the classification of market, my lord. Now he was selected under the selection process which was initiated in 2007. Now we are in 2023. Now, my lord, still the dispute by the other candidate is going on, my lord. That writ petition is still pending before the Group 8 matter, my lord.
No, writ petition, he said it was disposed of with the direction.
There is another challenge to his candidature, my lord.
Again,
my lord.
This reason order has also been challenged by the same person.
My lord. So that
if there is no interim order there, then
no, that matter is still pending, my lord. Affidavits are exchanged, coming for final hearing, my lord. Now, my lord, here he is agreed by the classification of market. Now, after, my lord, 2022, the markets have been classified, my lord, as per the guidelines, into, my lord, urban. First is, my lord, rural market. Then, my lord, rural, which is urban and rural mixed, my lord. And then, my lord, there is an urban market. And there is another fourth market, is, my lord, Durgam Khetri market, which is, my lord, hill stations. Now, my lord, if my lord sees the brochure.
No, show me that is retrospective.
My lord, whether it is no, my lord.
Yes, because his process started in 2013. Letter of intent was issued.
No, letter.
But that has been set aside.
Letter of
no. Letter of intent was not set aside.
Yeah.
Well, those documents are required to be brought on record, my lord. Unless, my lord, the affidavits are
direct affidavit. The petitioner raises an arguable issue as to whether the respondents were justified in classifying the distributorship of LPG, which was
Barakpur Kollani
applied for by the petitioner.
If, my lord, kindly peruses this, my lord, once.
As a rural area instead of an urban area, push up next para. It is contended that the respondent authorities seek to rely on 2022 guidelines, which are not applicable since the petitioner was granted the letter of intent for distributorship initially in the year 2013. Push up next para. Learned counsel for the respondents controverts such submissions and seeks to place reliance on certain documents which are germane for the adjudication of the dispute. So accordingly, the respondents are directed to file.
May I make one
affidavit in opposition within what time?
3 weeks after vacation.
2 weeks after vacation. Within June 21, 2024, reply finish shall be filed by June 28, 2024. The matter shall be listed for hearing in the monthly list of July 2024.
My lord, may I make one prayer? Let the respondent number 3 also file an affidavit. File a report.
Have directed.
File a report because they are the authority. Indian Oil is not the authority to.
All the respondents have directed affidavits. If they choose not to file, what can be done?
My lord.
You can communicate this order to the absentee respondent.
I am grateful, my lord.
Thank you.
Yeah. Item number 37.
I am for the petition.
Service.
Yes.
I appear on
Item number 36, I am for Union of India. I should give the name.
Union of India is also there.
Yes, Union of India.
Previous matter.
In item number 36.
36, Ministry of Petroleum is a party.
Yes, please give your name. I have directed affidavits.
I appear on behalf of WBACTC.
Lordship, submersible pump connection applied, quotation deposited, Lordship, connection has not been given.
No submersible pump or what?
No, my lord. I have taken instruction. My department needs around 14 days time to implement it. If my lord may kindly give me 3 weeks. Because there is cultivation going on.
That counsel for the petitioner submits that the petitioner applied for electricity connection to operate his submersible pump, which has not been given, necessitating the filing of the present writ petition. Stop. Learned counsel for the WBACDCL submits that the said licensee could not give the connection due to ongoing cultivation and requires 3 weeks time to give such connection to the petitioner. Full stop. Accordingly, WPF 14433 of 2024 is disposed of by directing the WBACDCL to give the electricity connection as applied for by the petitioner within 3 weeks from date. Full stop. No orders to cause urgent settlement.
Grateful.
প্রথমে affidavit of service filed today be given.
I'm grateful, man.
Grateful.
Item number 38.
I am for the petitioner. Service is not ready, my lord.
Service is not yet complete as per learned counsel for the petitioner. Let the matter be listed in the monthly list of June. You are for the respondent.
This one number 7 was. I'm grateful.
Please give your name. Ask a junior. Name has to be recorded. You are appearing. Yes. Next.
Item number 39.
Madhababu,
For the petition matter. Here is my service.
all have been served.
Yes. Told it has been served.
Right. What is the matter?
My petition.
No, one is item dispatched. One is item dispatched.
I could not go through it because my
No. Private respondents are there.
no private respondents. As per quotation, I have deposited the money.
Acha.
1st of February 2024. Page 9. As per quotation, I have deposited the 82,000 for commercial connection to the
This
machine.
matter probably is against the WBACDCL. My lord, I have just been instructed that a copy
Yes.
has not yet been. Let a copy be served and the matter be kept after vacation.
Affidavit of service filed today be kept on record. Full stop. Learned counsel for the WBACDCL submits that he is not equipped with a copy of the writ petition, comma, although it is indicated from the affidavit of service that copies have been served. Full stop. Learned counsel for the petition is requested to hand over another copy of the writ petition to his counterpart for the WBACDCL during the course of the day.
I'm giving here it now. Subject to
The matter shall be taken up next on May 24.
We will take it up after vacation. I have to take it.
That's a very well. The matter shall next be listed in the monthly list of June 2020.
I'm grateful.
As per quotation, I have deposited the money.
He has to take instruction why he is not giving. I want to bind him by an order. I can brush aside anything, but then another objection will be taken after I dispose of the matter. You'll have to come with a fresh writ
But I
petition.
think there is
No, it will be taken up after.
I'm
Right.
grateful.
on
Item number 40.
My lord, I am appearing for the petitioner through virtual mode.
after vacation, your also
Yes.
Your also kindly fix
Immediately after the vacation. Yes, Mr. Sinha.
My lord, sir, this is a writ petition for acceptance of my application for grant of citizenship. My lord, which I am intent to filing by way of online module of Online Citizenship of India Act website, my lord. As
But
per
sir, you also have to file your online affidavit of service.
my lord, affidavit of service, I will physically, my lord, file.
I have to have it before passing any order.
My lord, affidavit of service, I am, my lord, may kindly
Come back after the vacation, Mr. Saxena.
grateful, man.
The affidavit of service is not yet ready. Let the matter stand urgent till after the oncoming summer vacation.
petitioner. I didn't make a research against it.
Item number 40. 41, sorry.
Surprise.
My Lord, 41, I am appearing for the petitioner, my lord. I am under a compelling circumstances. I am before your lordship, my lord. Lord, this is a writ petition.
I will affidavit of service first. Yes. This is a writ petition. I'm sorry. Continue.
I'm opposing, my lord.
Obviously.
My lord, the compelling
least I
situation
didn't-
is that
One saving grace is I didn't make him research for this matter against himself yesterday.
Lord, the compelling circumstances is, my lord, on 15th of April, we were served with a possession notice. My lord, this possession notice is in respect of an immovable property which is situated at Ental.
15th of February, you said?
15th of April, my lord, 15th of May. I'm sorry, my lord, 15th of May, 2024. My lord, which it's the annexure is at page 114.
Yes.
My lord, from where we come to learn that the respondent bank, my lord, has initiated SURFACE action against me, has issued a section 13.2 notice, 13.4 notice, and thereafter, my lord, moved before the magistrate for an order under section 14. The learned magistrate at Alipur, my lord, passed an order, my lord, directing me to...
So I'll not record your name.
Yes, Lord.
I'll not record your name. You should not appear in this.
Should not appear. Please argue.
Even not even his name. Somebody, neither of, not any of your names. Somebody more junior. Yes, what is the matter?
Lord,
so that possession notice, after that, what did you do?
Lord, possession notice, thereafter we was, my lord, along...
No, please.
That along with
Just joke.
my lord, along with the notice dated 15th of May 2024, we were served with an order passed by the learned Chief Judicial Magistrate Alipur saying that
What are you challenging here?
my lord, challenging that particular order, my lord, against which I have already proceeded before the DRT, my lord. We have filed it today. My lord, till the time the matter has been listed, my lord, I'm seeking for a limited protection, my lord, so that the banks, my lord, is restrained from taking any possession against me. My lord, I have 2 points of arguments, my lord. One is that the 13-2 notice was never served upon me. And there's an issue of jurisdiction, my lord, because the magistrate, my lord, this property is situated at Entally. The learned Chief Judicial Magistrate could not have assumed jurisdiction because the property is outside the jurisdiction of Alipur Court, my lord. Lord, the section 14 also, my lord, states that it is the Chief Metropolitan Magistrate or the District Magistrate, my lord, who will be taking, my lord, will be entitled or empowered to pass this particular order. Lord, in Alipur, my lord, your lordships will find from the provision that it is the District Magistrate, my lord, who had the jurisdiction to pass this order.
Yes, what
Lord,
do you say, Mr. Chaudhary? Justify your business.
Very difficult to. I tried to find out, my lord, whether we could agree. But my lord, it's
Agreement.
very difficult, my lord.
I'll put it, make it an order of the court. I'll give
My lord, protection till
7 days. And
no,
Lord, the vacation.
only problem is, my lord, I wanted to, my lord, but this order is dated, section 14 orders of 2023.
2023.
My lord, not served upon me because I was not a party, my lord. My lord, it was served
That's why,
upon
my lord, such virulent opposition
my lord,
from my right.
it was served upon me on 15th of
Lord,
May 2020.
Section 13.2 is 14th of October 2019. 13.4 is to 23rd of June 22. And my lord, 14 is 19th of August
no,
23.
Mr. Chaudhary, he says that service has been effected only on 15.
Because your lordships will, my lord, appreciate, my lord, that
Section 14 order, my lord.
I'm not a party to the section 14 application.
Never a party.
Anywhere. So he learned from the 15.5.
Yes, but now, my lord, the difficulty is he has absolutely no case to maintain a writ petition. And my lord, the matter will go over till after vacation and he'll show this order and he'll continue the interim order for the next 5 years.
Your lordships will make
I'll make that clear. I'll give you only 7 days.
But the vacation is, my lord, commencing, my lord.
DRT is closing when?
My lord,
Today
virulent
is the last
objection
date,
on my rights.
From
No, my lord, may I say this?
But 7 days from
closed from which
reopening,
day?
if your lordships can, my lord, kindly grant me that.
No. My lord, no. This is, my lord, the only problem is, my lord, I don't mind, my lord, not doing anything for 7 days. In fact, my lord, please don't record it. I can give your lordship an assurance nothing will be done for 7 days. Let him withdraw the writ petition. My lord, my advocate on record is here. We will not do anything for 7 days. But if you...
But I'll have to record that.
No, please don't record it. If, my lord, anything is done, let him mention that. Keep it pending for 7 days. Nothing will be done. But then you have to get your order.
The vacations are commencing, my lord. That's the only difficulty.
Then in every matter, everybody will do so.
Yes.
But it's a compelling
Item is
situation. I'll
set up by
demonstrate. I
somebody.
can also demonstrate, my lord, that we were only served on 15th of May, my lord. But we immediately
another
took steps.
property.
See, you are served on 15th of May. You have filed this writ petition. What prevented you from filing a section 17?
We are filing it today, my lord. But
Instead of the writ, if you could file the writ petition, you could file that also.
It takes time because of the technical reason. It takes some time. We have to, my lord, hand
When did you
service.
present it? When did you present it? You have not yet presented it because you are going to file it today.
But I appreciate this.
My lord, I am being instructed it is already filed, perhaps, my lord, today.
When?
My lord, today, my lord. But I'm only seeking, my
Why need to file it on 16th itself?
Lord,
Or 17th?
we had filed both the petition. My
When
lord,
did you file the
abandoned
writ
caution,
petition?
my lord, I had done this, my
When
lord.
did you file the writ petition?
No recording in the order.
Friday, we had filed the writ petition.
My lord, may I humbly submit this? My lord, please keep this matter on the reopening date to, my lord, assess our conduct. I assure your lordship, for, my lord, 10 days, nothing will be done. But please don't pass an order because then they're going to show this order and get an extension. For the next 5 years, this order will be extended.
Your lordships can record it in the order, my lord.
No, nothing. I am assuring you because it's my learned friend.
Now, how is he special?
Not my chamber junior.
So what?
I have to agree to something, my lord, and in fairness, my lord, demands. Your lordship said that something. So, my lord, I am giving this assurance. But please don't record it because Axis Bank will, my lord, not appreciate my...
What should I record? Tell me. What will be my order?
My lord, list the matter on 10th of June to assess Vishnu
In view of
Chaudhary's conduct.
this urgency.
There is no urgency.
No, it's a residential
absolutely no
property, my lord. It's a
Whatever it
residential
is, you are
property.
a
Petitioners
defaulter,
are
your
filing.
property will go. You, my lord, they also, my lord, also the mitigating factor is from another, in respect of another property, there was, my lord, essay filed, my lord, a section
But
17
that was in
filed.
respect of the company,
That
my
was
lord.
also
I am a
dismissed.
personal guarantor. That was in respect
No,
of the
no, no, no,
company,
no.
my lord.
No, same. This is Arvind Bhausingka, same petitioner, essay 68 of
I would have
24.
given you 7 days in any event that would not save you. So better rely on your senior's undertaking.
Yes.
I'll not pass any order.
Your lordship will keep it on 10th of
10th of
June.
It will remain in the list.
nothing we will do. Mr. My learned friend, my lord, will ensure that. I have faith in my learned friend.
An objection as to maintainability of the writ petition is taken at the outset. Full stop. Next para. Since learned counsel for the bank seeks to rely on certain documents to indicate the chronology of events of taking steps by the bank in respect of the proceeding measures under section 13 as well as section 14 of the Surface Act, let the matter stand adjourned for a limited period and be listed on June 10, 2024, fairly at the top of the list.
Grateful, my lord. That your lordship will find that nothing will be done.
I will not find, somebody else will find, because I'll be in Port Blair enjoying the pressure there. Now there's pressure in Port Blair also, work pressure.
That is bad.
With the liberty to mention if
Fairly at the top. That will be done before the vacation. They will send the list.
I'm grateful.
Grateful.
Item number 42.
No, Mr. Chaudhary is there. I'm sure he'll
No, I will
definitely
ensure
not
nothing
deny.
happens.
None of them will deny this.
No, not we will.
We will all go to him, my lord, in case if any step.
Before going to him, go to the DRT. Before going to him, go to the DRT first. File it tomorrow. I mean, day after tomorrow.
Grateful.
Yes, what about Mr.
My
Kutubuddin's
lord,
matter?
your
Yes.
lordship, take instruction, my lord, last question. Great time for instruction. I have complied everything.
You know what he will do also. This is a collusive thing. Yes.
May I submit, Lordship? Yes, we have made an inspection. Submersible pump is there, and it is to be electrified. And your Lordship, there is no nearby LTOH, means low tension overhead line. And for this reason, and it requires 200-meter length LT PCC. May I submit the instruction?
How long?
210 meters. How much time it is required? Your Lordship, as per
Not the length of the wire, the length of the time.
I tell you, Lordship, why I have said 210 meter, because there is a specific regulation on that. It is my duty to bring to your Lordship kind notice. Regulation 57. If your Lordship kindly.
What does it say? It cannot be given.
No, it can be given 180 days subject to the cultivation period, your Lordship. Kindly.
Cultivation 180, no. But 180 days are no longer required. Cultivation is going on from long back. Only probably 10 to 1 2 weeks are left.
Lordship, yes. If
I know more about the Bodo cultivation now than you because of this electricity matters.
Lordship, I am not aware about that, but I will go by this regulation, Lordship. This is in the regulation 57, it has been specified.
Yes, Mr. Kutubuddin, what do you say to
Only
that?
2 weeks, my lord, the Bodo season will be over, my lord.
You're saying that? If it is not over, then?
Then we have to face the contempt.
You cultivate in a different field. All of us cultivate in different fields, not in Bodo field. So you have to have, take instruction from your client.
My lord, Bodo season is last.
Lordship, kindly have a regulation 57. It will be very
57 is 180 days. He knows, I know, you know. So what?
3 weeks or 4 weeks, my lord, also, as your lordship desire.
Learned counsel for the petitioner submits that the petitioner applied for electricity connection to operate his submersible pump, but the same has not yet been given. Learned counsel for the WBACDCL argues that
and quotation has already been issued,
due
Lordship.
to the ongoing cultivation season, the connection could not be given since certain installations have to be made over the nearby cultivable land. However, quotation, it is submitted, has already been issued duly by the WBACDCL. Stop. Learned counsel for the WBACDCL also places reliance on regulation 57, which stipulates that in view of ongoing cultivation, up to 180 days can be taken by the licensee to give connection. Next para. However, learned counsel for the petitioner opposes the said prayer and submits that the ongoing Boro cultivation is due to be completed. Boro cultivation season is due to be completed soon, about a fortnight hence. Keeping in view the rival contentions of the parties, WPF 14190 of 2024 is disposed of by directing the WBSCDCL to give electricity connection to the petitioner within 4 weeks from
Great.
date. Full stop. No orders to cause urgency.
I'm great.
And subject to compliance of all formalities, Your Lordship. 4 weeks.
It's a very, comma দিয়ে subject to compliance of all formalities by the petition.
Cholo, cholo, bhai.
Item number 43.
Yes,
To
Mr.
the
Rai
petitions,
Mukherjee.
my lord, yes. My lord, this is the matter, my lord, where I filed this
Yes.
writ petition for non-consideration of my representations by the tender committee in connection with a tender of ESI Maniktola. Now, my lord, on the last occasion, my lord,
State is not there, Mr. Joydeep
Mr.
Kaur is
Tonoy
for-
Chakraborty, yes, sir. State.
Tonan,
represent-
Honorable Rai's name was recorded.
Yes,
I don't know
yes.
whether he was there.
Being me, my lord, today he is absent.
Oh, he was reading you. No, you are there that I can take. No, Joydeep Kaur was for respondent number 9.
Private respondent.
Don't make the collusion evident. Yes, respondent number 9 and you are for respondent number 10. No, independent also I would hear you, Mr. Bandyopadhyay, but should the state be, because they are
My lord,
this
I-
regarding
I have very innocuous prayer, my lord. No
all
one's
your
right,
prayers are very innocuous. Put people into
no
trouble.
one's right has been established. No one will be
What do you want? What is the innocuous prayer?
My lord, I made two representations. Initially, I made a representation by saying that you should invoke clause 39, which is not should not be an ornamental clause. The before tie or draw of lots, this section clause 39 should be invoked in order to ascertain that who is the actual lowest bidder amongst all L1. Now, in connection with other hospital, my lord, they have adopted this procedure and found out that who is the actual bidder.
Let us see clause 39 once
Yes,
more.
yes,
You
my
are-
lord, your lordship, kindly consider my representation at page 256. I have quoted.
No, please show. Oh, actually, you have quoted.
I have quoted, my lord, page 256. My lord, this is dated 12th May 2024. Request to invoke clause 39 of the tender terms and conditions. Now, my lord, it is, my lord, kindly consider the last paragraph. It appears that the tender evaluation committee has not calculated the rates of the overall monthly financial implications for each of the 10 bidders to determine the L1 bidder among them. In this connection, I would like to refer to clause 39 of the tender terms and condition, which is as follows. Then it is under quotation, my lord. Mode of calculation of rates.
What remains to be done in the tender?
My lord, here, they, my lord, initially
Financial bids have been
opened.
opened.
Immediately thereafter, my lord, I made my first representation, which is at page 227, by saying that some of the records submitted by the bidders are incorrect, some calculations are incorrect, therefore that has to be looked into. And second representation that I at page 256, my lord, I have pointed out that clause 39 has not been invoked. Now, your lordship, kindly consider page 259. This is in connection with Shialda ESI under the same directorate. My lord, here also, your lordship will find page 261. They found, not 261, my lord, your lordship, kindly see page 263. After opening the financial bids, there are 9 bidders. Then 264, all were L1. Page 264, all were found L1. Thereafter, my lord, kindly see page 266. They invoked clause 39 and found that my client was the L1. After proper evaluation, page 266, after proper evaluation of technical bid and financial bid,
What have they done here? They have drawn lots.
No. My lord, there was no question of drawing lots because they found that my client was the L1 amongst all L1s. My lord,
How can there be L1
yes,
among
that is the thing. My lord, suppose there are 1,000 patients in a particular hospital. Now, everyone quoted 122 for 4 meals. Tea, breakfast, lunch, dinners. Now, all these 1,000 patients, my lord, do not consume all these 4 meals. Some of them are discharged after having lunch. Some may...
That is clause 39.
That is clause 39. That is why, my lord, before draw
What
of
has
lots,
happened here up to now?
here that clause 39 has not been invoked. That is why I made representation.
How did Mr. Bandyopadhyay's client become successful then?
No, he is only L1.
Oh, he's another L1.
Yes. Now he is not, my lord. I do not know why
What
he
is
is
the
opposing this.
alternative? I mean, what do you apprehend that they will do? Because there are so many
will go
elements.
for the draw of lots. Initially, my lord, they, my lord, sent a notice. Thereafter, after I made this representation, they cancelled everything.
Draw of lot, they cancelled.
Cancelled everything,
Then
postpone it. Now, I do not know, my lord. Earlier also, my lord, in this tender process, I requested them to kindly invoke clause 39, but they, my lord, without.
draw of lots is provided in any of the clauses.
Yes, that is in clause 39.
So show me the interplay between clause
Yes,
39
you are-
itself.
Yes, clause 39.
Show me clause 39.
Yes,
Mr.
my lord, kindly
You
consider.
have selectively quoted that
Yes,
in your
page
representation.
257, my lord.
Page 29 is there.
29 is a part of the tender terms and conditions. Very well. I shall show it from
Show
page
it from 29.
Yes. Page 29, clause 39, my lord. Mode of calculation of rates. I'm sorry.
Yes.
The calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication of supply of all categories of diet. In case of tie, the lots will be drawn under the supervision of the superintendent of the hospital with the help of the tender selection committee. Therefore, my lord, the first sentence shows that it is the duty of the hospital authority, my lord, to find out the overall monthly financial implication. That what will be my monthly financial implication.
Transpires from the language of clause 39, Mr. Roy Mukherjee, that initially the calculation of rates will be on that, and if after that there is a tie, then only.
I'm grateful, my lord.
So you are saying the same thing, that
Yes,
the tie
I'm
cannot be on the face value of the.
Yes.
Let me hear the Mr. Chakraborty and Mr. No, Mr. Chakraborty is silent on this. You always have a right to speak before Mr. Chakraborty, but he must have the final word.
I have taken his permission.
No, literally, he must have the final word.
He told me, I said, yes, obviously, my lord.
He'll have the final word, Mr. Yes, Mr. Bandyopadhyay, what is it?
This tender notice is of 11th of May 2023. At that time, my lord, this petitioner was the existing contractor. Now, it was, my lord, ultimately, he made a representation of 13th of November 2023. That is 268, page 268, on clause 39, that you should follow this. But what happened, all the persons quoted the minimum possible rate. There cannot be anything beyond, my lord, less than that. And that is why all are the rate same. Now, what happens on 13th 11, my lord, he filed a representation saying that you should follow clause 39. His brother was selected. My lord, on 16th, the lottery took place. His brother was selected. My lord, he did not challenge because his brother is continuing. On 24th November, my lord, I filed a writ petition saying that some bidders, not only me, my lord, there are 4 bidders who were rejected on the ground that it was not addressed to MPO cum superintendent. You will also recollect, you will also set aside and said that it will be, my lord, resumed at the stage of technical state. It was not, my lord, complied with by the hospital authority. They did not finalize it. My lord, both the state and that private respondent, my lord, who was selected, my lord, they were allowed to operate on an ad hoc basis. They filed appeal. Appeal got dismissed in 30th April 2024. Then the contempt came before your lordship directed that it should be complied with. But after that, when no avenue, again the grant supply came in the meantime, saying that now these objections I have taken, you should be considered. That was also dismissed by your lordship. Now they are coming on the same plea. They had the, if they were, actually interested in pursuing with this, claim that clause 39 was compliant, was not, they could have done so in the earlier round when it was finalized. They did not do so. Now, what I today said, this representation is itself premature because nothing has been done by the hospital authority as yet. Only the financial bids were opened, all found to be quoted the least possible rate. So if your lordship calculate it as per 39, it is on anticipation that what are the bed numbers and how it will be same because these are the least possible rates. Now, even if, my lord, I would have accepted his submission, this is a tender, my lord, finalizations. My lord, hospital authority has not yet finalized. His cause of actions will arise only when it has been finalized. But even if he said that this particular tender conditions has not been complied with, that stage has not come. This is a premature writ petition only to stall this, my lord, finalization. Because now he is aggrieved because actually, my lord, he is working in the name of his, my lord, brother.
Paternal sort of.
Yes. Now
paternal writ petition.
Now after 2 rounds, 3 rounds, my lord, when they became unsuccessful, now they are filing this writ petition. My lord, I am objecting to it. My lord, this type of
representation is not maintainable in tender matter. It is the tendering authority has a absolute free run. As per CLP constructions, I'll be relying on two paragraphs, 19 and 20. And this is the premature cause of actions. My lord, because hospital authority has not yet finalized, because they have been prevented, my lord, in doing so. I am not actually, my lord, who will be getting, I don't know. I am also L1. There are 10 L1s. Because I pursued the earlier round of litigations, my lord, that is my. Now their only intentions to stall, delay. Even that.
So that his brother can continue.
Because the division bench order, my lord, that also gives them time up to 30th May. Now that will be also over because division bench extended.
Time to conclude the process.
Conclude by 30th May. 1 month time was again.
So, Mr. Bandyopadhyay, we can express an intention that clause 39 will be taken note of by the authorities.
Take note
while
because this will
we can observe that in our order, so that will
not change the nature.
That will prevent them from stalling the matter.
Finalized after taking note of clause 13.
I'll do that. So that takes care of everything.
Don't, my lord, direct the authority consider.
No, further. I'll consider and yes.
16th November, the previous round, the 16th November, the draw of law settlement.
They did not object.
On 17th November.
How many dates are there in total, Mr.? Yes. Take note of clause 39 and complete the. Yes.
There are also other finance which I will be bound by. There are other finance rules. I will kind of keep space for that. Because ultimately the money has to be disbursed to the financial. Because there are finance, there are orders.
And the bids have not been finally selected.
The contempt has fixed before my
Contempt or whatever.
The outer limit, the contempt matter will appear, and we have to complete the process. So that it's absolutely that this is the process. This is a cartel. But we also know that Mr. Mukherjee also is aware this is a cartel. Both the brothers are working basically in
Very small cartel. Does not qualify as a cartel.
Not only this, these
other also.
Appear with Mr. Bhattacharya and Mr. Mukherjee also in this type of matter in 2000. But this has been.
You are part of the cartel then. No, from that end, from your end. That cartel has been included by Mr. Bandyopadhyay. Mr. Bandyopadhyay is also part of the cartel.
There is an oligopoly. Mr. Bandyopadhyay's client created an oligopoly, my lord, for the last 25 years.
Mr. Bandyopadhyay is an oligarch.
Some matters, Mr. Mukherjee must have appeared.
Now I
distribute between yourselves and the others keep looking at you.
Enmity, my lord, between the brothers, my lord, no one knows better than Mr. Bandyopadhyay. This enmity, my learned senior friend is saying this. Between the brothers, the enmity is very well
It's
known.
a two-line order. I'll pass. I'll direct you to conclude the tender process by taking note of 39 as well as all other tender clauses and whatever.
Yes.
Essential rules.
My lord, your lordship,
do not, my lord, give any extended period.
Why should they extend it? No.
Asking for that. My lord, only one thing, my lord. My first representation shows, my lord, I have also annexed documents that there are certain allegations that there are either, my lord, on the apparent on the face of the records, my lord. My lord, that representation.
Tender cannot be stalled like this.
No, I'm not asking for stalling of this.
At every stage, you'll give a representation. Keep your representations to yourself. They'll look at
your lordship, kindly
and this is
consider
premature also. He's right.
Your lordship's order. I pointed out this. Kindly consider page 186.
At that juncture, that was the previous stage.
But today, my lord, the error is apparent, my lord. Kindly see one.
It's premature. How do you know it's apparent?
No, the financial.
They have not yet taken a decision.
Very well.
You're
My
apprehending
representation is pending. My lord, one is
your apprehension is that clause 39 won't be taken care of.
That is
so I'll
one.
put in my order that they'll do that.
That is one. In the first representation, my lord, there is some error apparent on the face of the record. So far, the financial bid of some of the bidders are concerned. My lord, the calculation is wrong. Kindly consider one document, my lord. I shall not waste your lordship's time. Kindly consider page 223.
Yes.
I'm sorry. My first representation is at page 227. My lord, I have the moment, my lord, the financial bids were opened. I made this representation on 8th May. Kindly see. CM Enterprise in the middle serial number 1 quoted his rate in diet schedule at cardiovascular disorder diet, that is diet number 3 at category of lunch item such and such rupees 2.77, whereas other bidder quoted 2.70. Therefore, my lord, he cannot be L1 page. I have annexed this document at
We cannot go
229.
into this.
My lord,
The-
this is, my lord, an error. Kindly see, my lord, 229.
They're all feeble.
My lord, he cannot, my lord, holding the brief of CM Enterprise. I do not think.
Hold. My lord, this is a
No, no.
frivolous.
You can hold.
He can hold, my lord.
My
Therefore,
lord,
the cartel is apparent. My lord, who is asking?
my lord, I'm not CM, I am
Who is-
nobody.
So
I am
kindly,
saying I
kindly.
know that you want to stop.
Therefore, there are very specific allegations against
That
CM.
Mr. Chakraborty will answer.
Ashun, you don't have to answer anything. The petitioner, comma, a participant in the concerned tender process, comma, has made several representation to the tender inviting authorities, comma, inter alia, alleging that there was irregularity in diet schedule given by some of the bidders. Because of that apart, comma, at the financial evaluation stage, comma, since there is a tie, comma, before going into a draw of lots, comma, LOTs, lots, comma, the tender inviting authorities are required to comply with clause 39 of the tender document, which mandates the calculation of rates of acceptable bidders to be on the basis of overall monthly financial implication for supply of all categories of diet. Who's up next para? Learned counsel appearing for respondent number 10 contends that the petitioner's brother is at present doing the work contemplated in the tender. For sub next para, in order to perpetuate such work by the petitioner's family, comma, the petitioner is seeking to stall the tender process by making frivolous representations. Push-up, it is further argued that there have been previous rounds of litigation. Push-up, in the event the petitioner was of the perception that clause 39 is not being complied with, comma, it was open for the petitioner to take such objection at that stage. Full stop, having failed to do so, comma, the same cannot be permitted to be opened at this stage. Full stop, next para, learned counsel for the tender inviting authorities contends that pursuant to orders of this court, comma, the tender process has mandatorily to be concluded at an early date, comma, by June 14, 2024. Full stop, next para, hence, comma, the representations by the petitioners are not only premature, but they would stall the tender process unnecessarily. Full stop, next para, upon considering the contentions of the parties, comma, it appears that the petitioner's apprehensions are premature, comma, since the tender inviting authorities are yet to take a final call on the financial bids which have been merely opened, but no decision has been arrived at as yet in respect of who is the successful bidder entitled to the issuance of work order. Push up next para. It is expected that the tender inviting authorities shall comply with not only clause 39 of the tender document, but also other relevant clauses of the tender, as well as the governing financial rules, while taking a final decision on in the tender process. Push up. Hence, comma, there is no scope of interference at this stage. Push up. Accordingly, WPA 13/777 of 2024 is disposed of in the light of the above observations, comma, making it clear that the merits of the contentions have not been gone into at this stage, and keeping it open for any aggrieved bidder to challenge the tender process in the event it is found that there is any gross illegality or non-adherence to the tender clauses by the tender inviting authorities. No address to cause urgency.
My lord, may I just indicate one thing? My lord, kindly record my submission that I am denying his submission. This is, my lord.
Since no affidavits have been invited, comma, all allegations made by the parties against each other are deemed to stand denied.
I'm grateful.
The only thing Your Lordship has said, the time to completion is 14 June.
He said before 14 June?
No, my lord, as per division bench order, it is 30th May, so don't mention it.
একটা জায়গায় বলেছি 14 before 14 June, before June 14, 2020.
At an early date, Your Lordship completed, that's it.
As per orders, June 14 দিয়ে সার্চ করলে বাইটা কেটে দিন at an early date.
At an early date. Otherwise, my lord, confusion.
Thanks.
Item number 44 and 45.
I appear on behalf of the CSC, my lord.
I am for the petitioner in
Why don't you settle these matters out of court? Why come to court? File the application, then settle it.
private
In front of-
respondents are there, Lordship. That's
the same parties. Oh, you are the
We will
sticking
put in
point.
opposition
affidavit in opposition.
and
Lordship.
we have got a request.
What is this?
Opposition.
Opposition note direction was given.
Yes.
Why?
2 writ petitions. Are
Let
there,
me check up.
Lordship.
Oh, meter board within the bedroom of your client.
আমার নামটা দিয়ে দিও।
Yes, what is your stand in the matter? First, I want to hear that.
But can these be taken up after the vacation?
This is your contention
That's why
on merits.
That's why I said we have a request.
Well, then kindly fix up any particular date, my lord, after coming from my lord, court level, my lord.
No, that will be too far away. Affidavits in opposition and reply filed to be kept on record on the prayer of learned counsel for the CSC Limited.
Everybody.
Oh, acha. On the prayer of learned counsel for the parties, the matter is adjourned till after the oncoming summer vacation.
That part cannot be deleted.
That part cannot be?
Be deleted.
Which part?
The prayer of the parties.
No.
I'm
Why should
getting-
I postpone it otherwise? I'm here taking up the matters, being paid for that.
Well, it would be in the.
Yes, next matter.
I'm grateful. man.
Grateful.
And
Item number 46.
Kindly fix up any date, my lord, my lord.
No. Yes, Mr. Bhattacharya, what is that?
I'm filing my affidavit in reply.
এটা করবি আজকে? এই তো বললি করবি না।
I'm filing my affidavit in reply.
Yes.
We have already put in our.
Right. What is the matter?
Now, my lord, what happened, my lord? This is a marketplace. Now, my lord, on 21st July 2023, there was a, my lord, fire. Now, my lord, thereafter, my lord, the owners of this, they were arrested. After that, they were granted bail. Now, my lord, what happened since the date of fire? My lord, the CESC authorities, my lord, had disconnected electricity. Now, my lord, the present writ petition has been filed for reconnection. Now, my lord, if your lordship would kind enough to see, my lord, the order passed by this honorable court at page, my lord, 29. Kindly, if your lordship would kind enough to come to page 31, the relevant portion, paragraph 4. But this is the order of bail, my lord, of one of the directors of the petitioner who is managing the, my lord, hut. Now, my lord, pending rehabilitation of the remaining, paragraph 4, my lord, pending rehabilitation of the remaining shop owners, we are of the opinion petitioner may be enlarged on interim bail. Accordingly, petitioner is directed to be released on interim bail, which shall continue till 31st December 2023 or until further order, whichever is earlier, upon furnishing a bond of rupees 10,000 with two sureties of like amount, one of whom must be local to the satisfaction of learned Chief Judicial Magistrate Howrah, on condition that he shall meet the investigating officer once in a week until further orders, and this line is very important, and render necessary assistance for progress of investigation, including rehabilitation of shop owners in the market. This was the one of the condition. This is not one, this is the only condition for grant of, my lord, the interim bill. Now, my lord, kindly comes to, my lord, page 33, the next order.
Yes.
Now, my lord, kindly see, my lord, paragraph 2 of that the report was filed on behalf of the state. A more elaborate report to be filed on the adjourned date, identifying the persons whose shops have been burnt down in the carnage. Steps also be taken to repair the shops and rehabilitate them. Petitioner is directed to cooperate with the investigating agency in that ground by supplying necessary information and support. But this was the next order. Though investigation is done by Central Investigation Department for short CID, local police station shall support the investigating agency in the matter of identification and rehabilitation of the victims. Then, my lord, kindly comes to the final order at page 37. Kindly see, my lord, the paragraph 3, in the report, the first paragraph, report is placed on record. From the report, it appears a petitioner has cooperated with the investigating agency and the identity of the other particulars of most of the person who lost their shops due to fire has been made. State is directed to take necessary steps for their rehabilitation in the market. Next, paragraph 3, in the light of the above aforesaid development, and as petitioner has cooperated with the investigation while on interim bail, we confirm the interim bail granted to him by the order dated 9th October 2023 on the same terms and conditions. Therefore, condition remains, I have to go on, my lord, cooperating with the state for the purpose of rehabilitation of the victim. Now, my lord, kindly see. We had made, my lord, several representations at which starts from, my lord, page 39, so that our electricity connection may be restored. My lord, they don't reply to that. Ultimately, my lord, kindly comes to page 43. After a long time, a reply, my lord, had come from, my lord, CSC authorities. Kindly see. You are aware that owing to a fire breakout on 20th July 2023, your caption supply was disconnected, in consequence whereof you were out of supply. In consonance with the direction of the West Bengal Fire and Emergency Services, Police Authority, and also for safety of the premises, we have disconnected all other supplies catering load to the premises commonly known as Mongola Hut and its vicinity. Therefore, disconnection by electricity by CSC is admitted. Then, Miller, kindly see, this is not out of place to state that in plethora of occasions, Miller, we do not know when, because our director was in jail when they have intimated in a plethora of occasions, we do not know. We have apprised your representatives that formalities of the to be complied with for restoration of supply, and we understand from your representatives that you are aware about the assessed claim lying recoverable from the premises in question. In view of the above, this is to place that the caption supply shall be reconnected subject to compliance of the following formalities. 1. Payment of outstanding dues of including reconnection charges. Well, we were not told what are the breakup, what are the particulars. Number 2, settlement of recoverable assessed claim with loss control cell. We do not know, Milord, from what does it mean. Clearance from West Bengal Fire and Emergency Services Limited. Milord, we do not have any statutory obligation under any statute, Milord, to produce this. Paragraph 4, Milord, clearance from the concerned police department, no statutory obligation, Milord. 5, certificate of the licensed electrical contractor kindly comes to, Milord, page 47. We have already deposited this with the CSC authorities.
The certificate.
Milord, the page, yes, Milord, page 47, Milord. And they, in their affidavit in opposition, they say that they are satisfied with this. Now, Milord, kindly, my learned friend has, Milord, filed an affidavit in opposition. Milord, my lord would kind enough to take it. It's affirmed on 10th of May 2024. No. This is my reply, Milord. Affidavit in opposition is
which paragraph?
Yes. Now, Milord, kindly comes to now.
Yes.
Yes. What is their stand, Milord? They have two stands. First, kindly comes to, Milord, paragraph 9, page 9, para K.
Yes.
Kindly see. It is stated that on 3rd October 2023, upon inspection being made by the loss control cell of CSC Limited at the concerned premises, a hooking was detected from nearby pole, and in view of the proceedings, proceedings under section 126 of the Electricity Act 2003 was initiated against Lakshman Kalyani, Pradeep Shaw, and Shahzada Selim of Nityodhan Mukherjee Road, Howrah 71101. Milord, these persons are, Milord, no way connected with the functioning of the hut. Now, my lord, it is stated that provisional order of assessment has been passed and a final order of assessment has also been passed to the tune of rupees 126,128, which is still due and payable. I do further state that till date, there has been no proceedings under section 126 of the Electricity Act against the petitioner herein, and it is obvious that they are unknown about section 126 initiated against Lakhan Kollani and others. Now, my lord, lordship would kind enough to come to my affidavit in reply. I have clarified this.
No, we are not claiming that LCC.
They are saying you don't know about this.
We are not, but this is one of their ground of objection.
I don't know why this was put in, I mean, but they say that
India.
you are unknown about.
We are, because our director, everyone was.
It is also unknown why they put it here. I mean.
If your lordship.
But at that point, my lord, on the last occasion also, when I submitted, my lord, I say that I have to take.
Yes, you can continue. Yes.
Kindly see, my lord.
So what will come to the point? What are you driving at?
Yes. Now, very well. The next point.
What is the cause of action? What are you wanting?
Kindly see, my lord, page 11 of my affidavit in reply. Very well. Very well. Then, my lord, kindly see the next point. What is their next point? Kindly see page 11O. In view of the N and O, it is stated there since investigation is in progress on behalf of the CID West Bengal, it will be just and proper to implement the Department of West Bengal Fire and Emergency Services, the police authority, the CID West Bengal as party respondent in the instant writ petition. In view of the above, it is stated that unless and until the Department of West Bengal Fire and Emergency Services as well as police authority gives clearance for reconnection, it will not be legally correct for the CSC authorities to reconnected the connection of Mongolahat. Further, a piecemeal reconnection bypassing the investigation process, which is still in progress by CID investigation, will also against the law and the law of the land, and will also tantamount to hampering the investigation. Milord, their reconnection of electricity, milord, will hamper investigation of the CID. Milord, lordship will kindly consider whether this can be.
Let them say that the CID investigation is not there.
But that is
I have annexed. I have annexed. If he finishes, then
Honorable Division Bench, while granting bail, milord, has recorded that CID.
That is the condition of the
finish now.
Kindly come to affidavit in opposition.
Mr. Mukherjee, how is the CID investigation relevant?
Kindly come to page.
You won't restore an electricity connection till the CID investigation.
Kindly come to page 16 of my affidavit in opposition.
Yes.
Kindly see, this is the letter from the CID West Bengal.
Yes, so what?
Kindly see the sections.
Whatever section.
Kindly, I may be wrong, kindly give me 2 minutes. Section 11J, 11L and 12 of the West Bengal Fire Services Act. Kindly see section 11, section 12. May I read? No premises in any area where this act is in force shall be used for the purpose of storing or processing at any material point of time hazardous substances beyond such quantity as may be prescribed unless the owner or occupier thereof shall have previously been granted a license by the collector.
What is the hazardous substance?
That we don't know because we are not a party to that investigation.
So how are you bothered even? You have to give reconnection.
Why I tell you,
CID will think about it.
Kindly come to page paragraph 11.
You disconnected, Mr. Mukherjee, because of the fire. Fire is over now.
We have not disconnected.
You have admitted in your
document. Kindly come to paragraph 11. We disconnected on the direction of the West Bengal Fire Services Authority. That has been admitted by the writ petition.
So what? You are to restore. Under which law you have? They have the authority to direct you, Mr. Mukherjee. Please satisfy me on that.
This is in respect of the.
Show me the provision in the Fire Services Authorities Act that they have power to direct you to disconnect.
They have.
Anyway, I am asking you to reconnect. Reconnect.
If it is
no, not as a court. I mean, as a layman. Anybody and everybody will come and say disconnect, and you will disconnect. You will not ascertain independently.
We are only in respect.
If the Fire Service Department has asked you to disconnect, Mr. Mukherjee, it's your onus to approach the Fire Service authorities and ask whether now I can reconnect. Because these people cannot be without electricity forever. They're losing business.
It is their contention, it has been cordoned. Kindly see.
Who has cordoned? Why cordoned? Why do I
see page 28 of the writ petition? It is
who has cordoned?
The CID and the police authorities. Kindly see.
Cordoning has nothing to do with restoring electricity connection.
This cordon, my lord, our people cannot go in, but though it is, my lord, it is in 5th of August 2023.
Mr. Mukherjee, what is the law regarding that? Regarding disconnection, if it's dangerous, you have disconnected.
Yes.
Now, if it is not dangerous any longer,
According to section 11, L, J, and section 12, in read with chapter 3 of the fire safety.
you have got a copy of this act.
They have to get a license, my lord, unless the fire safety authority is, my lord, directed to be present, my lord, we don't know what is the investigation going on. If my lord directs, we will do it. We also don't know whether there is any hazardous substance or not. There is, this is a market, there are two services. One has been totally burnt out.
So which section are you relying on? Read that section.
My lord, they have relied on paragraph section 11J, 11L, and section
Yes.
12.
You are not giving correct connection on which of the provisions?
My lord, kindly see section 12. The owner or occupier thereof shall have previously been granted a license.
Section 12.
Yes. My lord,
West Bengal Fire Services Act,
yes.
1950. Section 12.
Yes.
Barred to use premises for storing or processing.
I don't know whether, my lord, whether
No premises in any area. I don't find anything.
I am continuously saying, my lord, if my lord directs, we will give. But
I'm continuously saying under which provision you are not giving. Why should I direct of my own whim? Show me the law why you are not giving. You disconnected on somebody's behest.
yes, my lord, we have disconnected.
Under which law? Which provision of law did you disconnect?
My lord, in respect of the direction from the fire safety authorities.
Under which provision do they have a right to direct you?
My lord, that, my lord, on the day.
Show me that you have disconnected, not him.
On the day of fire, my lord, they have directed us to disconnect it. We have disconnected.
Mr. Mukherjee, it's one thing saying that there was a fire hazard in your perception and you feeling that there can be a fire hazard because you have a duty under the Electricity Act to ensure safety of your installations.
Yes.
Under that, you can very well disconnect.
Then, my lord, later.
But if you do that at the behest of some other authority, you have to satisfy me that you have they have the right and you have a corresponding obligation to comply.
Well, then, my lord, let us go and
Safety is your lookout
let us
under the Electricity Act.
Well, let us go and see whether it is safe now to give a connection. We will give it.
No, how is section 12 even relevant? I don't understand.
Section 12 was the that is the letter.
Read out section 12.
Kindly see.
Not from the middle. Read out the entirety.
Part to use premises for storing or processing hazardous substance without license. No premises in any area where this act is in force shall be used for the purpose of storing or processing at any material.
This is not German at all. There is no allegation even there having.
I appreciate, my lord. Kindly see why I am saying in respect of page 16 of my affidavit in opposition.
That's what have you said there.
This is the letter and these are the sections which have been imposed.
Has the CID restrained you from giving electricity connection?
My lord, we are not.
CID is also looking into these things nowadays, Electricity Act.
My lord, we are not a party to the investigation. That also we have stated.
If you're not a party, why don't you?
Direct?
I will not direct. It's your statutory mandate, Mr. Mukherjee. Satisfy me. You have disconnected. You have not restored connection. You have to show me. Otherwise, I'll saddle you with costs. Why haven't you restored?
We have.
Show me from the law. Satisfied from the law.
Law, man, there is nothing in respect of.
If there is nothing, how could you disconnect?
We have been.
Show me the safety. Please come to the Electricity Act, Mr. Mukherjee.
The safety aspect is in.
Safety aspect, which section? Give me the section regarding safety.
Well, safety aspect will be in respect of the.
Which section? Which section?
আমার বইটা কোথায়? এটা তো নেই। এটা তো ইন্ডেক্স তো নেই। এটা আমাদের নয়। Section 53.
Come to that. Under the regulations also you have certain
regulations are there, but this is one of section 60, protecting the public, including.
No, this is you may specify suitable measures for.
Yes, this is in a public.
No, there is something else also that you have to take care of your installations. I mean, Mr. Mukherjee, you file a report, you ascertain from the fire services authorities whether there is any impediment. You satisfy the court, your affidavit is not sufficient on that. You merely cite CBI investigation, CID investigation going on.
We will file a report and my lord, we will.
Do that. Learned counsel for the petitioner argues that affidavits in opposition and reply filed, affidavit in reply filed to be kept on record. Learned counsel for the petitioner argues that the CSC Limited had disconnected the power supply of the petitioners due to a massive fire outbreak on the property. Subsequently, some of the directors of the petitioner concern were also arrested, and bail was granted inter alia on the condition that the said directors shall cooperate with the authorities in rehabilitation of the ousted shop owners who were carrying on their business from the said building. Next para, it is argued that despite repeated reminders and representations from the petitioner, the CSC Limited has not been restoring the electricity supply to the petitioner's property. Next para, learned counsel for the CSC Limited cites a pending investigation by the CID within bracket CIT under several provisions of law, including sections 11 capital J, 11 capital L, and 12 of the West Bengal Fire Service Act 1950. Next para, it is further argued that the place has been cordoned off, thus preventing the CSC Limited from restoring electricity supply. That apart, it is argued that the fire services authorities and the Kolkata Municipal Corporation ought to have been implemented in the present writ petition.
No, my lord, the fire service authority is CID. Only CID.
Oh, acha. Kolkata Municipal Corporation. The fire services authority and the CID are required to be implemented in the present writ petition for getting a proper picture of the current status of the building. Next para, however, a perusal of the concerned sections of the 1950 Act show that the same primarily pertain to hazardous materials having been stored in a particular property with which the CSC Limited can have no concern whatsoever. Apparently, the CID initiated the investigation, which is still ongoing, on the allegation that hazardous substances were stored in the property in question. However, the same, even if at the relevant point of time before the fire, such hazardous substances were stored, which led to the fire, the same cannot be a continuing justification for the CSC Limited to refuse to restore electricity supply to the petitioner. Next para, that apart, the CSC Limited fails to satisfy the court as to under which provision of law the CSC Limited acted on the direction of the Fire Services Authority to disconnect the electricity supply, never to restore the same till date. Next para, under the provisions of the Electricity Act 2003, it is undoubtedly the duty and the prerogative of a distribution licensee to ensure safety and security is maintained regarding their own installations and supply lines. However, since the CSC Limited does not cite such provisions, but a directive from the fire services authorities, it is the duty of the CSC Limited, much after the said fire took place, to ascertain from the fire services authorities as to whether the connection can be restored at this point of time. Next para, for such purpose, the fire service authorities or the concerned department of the state government are not required to be implemented as a party to the present writ petition. Next para, insofar as the investigating agency is concerned, they are also neither a necessary nor a proper party to the writ petition, since no relief has been sought against the CID. The pending investigation in respect of the building and the fire which took place there cannot be a justification for the CSC Limited to indefinitely uh, s- indefinitely sustain the disconnection of the electricity supply to the premises. Full stop. In such view of the matter, comma, I do not find any justification uh, for further refusal of the CSC Limited to restore the electricity supply to the premises. Full stop. However, comma, to ensure that proper safety measures are taken, comma, the CSC Limited shall file a report on the next returnable date with an advance copy to the learned advocate for the petitioner as to the current status of the building insofar as the safety aspect of restoring electricity connection to the said building is concerned. Full stop. For such purpose, comma, the CSC Limited will be at liberty to take appropriate uh, reports and or inputs from the fire services authorities as well. Full stop. Such reports shall be filed on June 18, 2024, when the matter shall be placed fairly at the top of the list for passing further orders. Take inputs from whichever authority and
We will file a report.
and independently also assess Mr. Mukherjee. Your own assessment is most vital for the court.
Lord, one small request, may it be marked as what had occurred.
It will be further delayed. I will not be there here on 17th.
Item number 47.
47, my lord, I am appearing on behalf of the
Service has been
petitioner.
affected?
Yes, my lord, I am submitting the affidavit of
Sir,
service.
before my learned senior friend submits, my lord, I have taken instruction that they are entitled to refund of the money that is lying with us, my lord.
That is the subject matter of the dispute?
Yes, my lord. And we are ready to, my lord, make the payments.
What can be fairer?
My lord, the concerned authority was directed to release the withheld amount at the with interest at the rate of 10%, my lord. This is my prayer.
Was directed or you are asking for the direction?
My lord, I let a direction be given upon the respondent authority.
From this is for dues regarding what?
My lord,
Withheld amount, my lord.
withheld amount.
Withheld amount for what? You are entitled to.
Certification of the work, my lord. What, my lord?
They did some work for you.
Yes, my lord. They were the contractor, my lord. They completed the work sometime in the year 2013. Thereafter, my lord, certain rectification work is to be carried out. That is why, my lord, we withheld certain amount. And the amount was, my lord, the
Rectification work means?
rectification work of the, my lord,
they were to rectify their
yes, yes, the work that have completed, my lord. There is a, my lord, clause for the my rectification.
My lord, kindly see the payment receipt.
And thereafter, I'm coming, my lord. And thereafter, my lord, the work has been done. Rectification also done in 2014. And my lord, they did not lay their claim till the year 2020, my lord. And that is admitted position,
Kindly
my
see,
lord,
my
from
lord.
the petition as
Annexer P4. Page 14, my lord. My lord, the petitioner made several representations before the concerned authority for
When was the first representation?
Yes, 2020, my lord. And
Yes,
this is, my lord.
From your first
20.
You can at least be entitled to interest from your first claim.
Yes,
2020.
20.
From then on, you can only claim interest from that date.
No, my lord, say 2013.
Why?
Why, my lord, they had withheld the amount. My lord, kindly see the payment receipt.
Where is
Annexer P2.
Yeah, that was the thing, my lord. We
Withheld amount
my lord,
and net amount paid, my lord. After deducting service tax, my lord, security deposit, everything.
Which page?
10, page number 10. I have completed the work.
Yes, yes. You have to pay from that date.
Yes, my lord.
I can produce the document to show, my lord, the money was withheld for rectification. Then I'll file my
No,
rectification when? When was it complete? 2014?
My lord, the 2014, yes, it is admitted position. Thereafter, they did not claim the amount, my lord. They have to.
They did not claim. It became due.
My lord, thereafter, they have to certain formalities to carry out. They have to claim
Bills,
the amount.
you had already sanctioned the bills.
My lord, kindly see
Yes,
page
my lord.
14.
At that time, my lord, it was not finalized, my lord. That bill was not
Yes,
finalized.
it was.
Annexer
Because
P4.
you see, please come to page 10.
Yes, my lord.
This bill is for the period. This is a payment certificate
Yes,
for
my lord.
1st of April 2013 to 31st of March 2014.
Yes, my lord.
After the date of rectification.
Yes, my lord. Thereafter, they have to claim this amount, my lord. They have to certain formalities are there, my lord. I can show from documents, my lord. That is their responsibility.
No.
In that event, my lord, kindly allow me to file my
Not this is not a blackmail. In that event means
My lord,
What is, tell me one reason why you are not paying this?
well, because they did not claim that amount,
Yes,
my lord.
I'll record that, I'll turn that down. That is not a valid ground.
That is the only reason, my
Well,
lord, because
No.
unless and until, my lord,
They are entitled to this interest at least from April 2014.
my lord, that
It was
is,
up to 31st of March
their first
2014.
representation, my lord, in the year 2020, my lord. In between, my lord, kindly see
You claim interest from which date?
my lord, I am claiming from 2014, my lord.
and kindly see the
In March
representation, my lord. The
2014.
first representation is 2020,
My
my
lord,
lord.
kindly see the another.
At order record code. Learned counsel for the petitioner submits that the petitioner did several works for the respondent authority, but was not paid the full dues. Full stop. Next para. Learned counsel appearing for the FCI submits that subsequent to the completion of the initial work in 2013, comma, there were certain rectification works which were also completed in the year 2014. Full stop. Next para. However, comma, although the claimed sums were due to the petitioner, comma, the petitioner made the first claim only in the year 2020 as apparent from the representations annexed at page 11 onwards of the writ petition. Next para. Hence, comma, it is argued by the FCI that the petitioner is not entitled to interest. If any, comma, the interest should be calculated from after the first claim by the petitioner. Next para. It appears from the annexure at page 10 of the writ petition that the same is a payment certificate issued in favor of the petitioner by the FCI for the period April 1, 2013 to March 31, 2014, comma, covering the period of the rectification work as urged by the respondent authority. Next para. Thus, comma, a payment certificate having been issued by the FCI itself till March 31, 2014, comma, there could not be any valid justification for withholding the claim of the petitioner.
Rectification work was done up thereafter, my lord. I can produce from the record, my lord. The rectification
What
work
was the last date when the rectification work was?
that record is not with me right now, but I am told
You
my
had to have that record.
no, not at the present moment, my lord, but I can produce, my lord. That is why my lord said ki, so far this amount is
আচ্ছা ঠিক
concerned.
আছে, I'll not conclude it. কোথায় ছাড়লাম? Any valid justification for the FCI withholding the amount of the petitioner thereafter? Full stop.
Kindly allow me to find my
Learned
opposition
counsel for the FCI submits at this stage that the rectification work was completed even thereafter, but in the year 2014 you said.
Perhaps, my lord. I am told in the year
No, perhaps.
My lord,
Very well. Pay this amount with interest right now. That will be the interim order and file your opposition after that. Push up next para. Since learned counsel for the FCI intends to use an affidavit in opposition, comma, for the purpose of bringing documents before this court to establish up to which period the rectification work continued, comma, although it was submitted at the inception that the rectification work was concluded in the year 2014, comma, it is evident that the FCI is seeking to protract payment to the petitioner on one ground or the other. Full stop. Next para. I do not find any reason as to why at least the amount disclosed in the payment certificate annexed at page 10 of the writ petition should not be paid to the petitioner immediately, comma, along with interest at the rate of 10% thereon till the date of payment. Push up next para. This is 2,22,000 or
1 lakh, my lord.
1,45,100 rupees.
Therefore,
Withheld amount.
very well. Therefore, the petitioner shall, therefore, the respondent number 1, the respondents shall pay to the petitioner the amount of rupees 1,45,100 oblique dash, comma, which is the admitted amount withheld from the petitioner, along with interest at the rate of 10% till the date of payment of the same said sum to the petitioner, comma, within
2 weeks, my lord.
2 weeks. Very good. Within আজকে তো 22 তো within June 6, 2024. Full stop. Next para, it is made clear that such payment shall be on an ad hoc basis and without prejudice to the rights and contentions of the parties in the main writ petition, comma, subject to the outcome of the main writ petition. Full stop. The respondent shall file their affidavit in opposition within
4 weeks after the vacation. 4 weeks.
4 weeks after the vacation. Don't even think about that. Within June 21, 2024, reply if any by June 28, 2024. The matter shall be listed in the monthly list of July 2024.
The interest is to be calculated from 2020.
Acha, very well. The interest যেখানটা বলছি 10% interest calculated from April 1, 2014 onwards. 2020.
Kindly seize, my lord. They have filed this writ application in 2022. My lord, thereafter also, my lord,
They have
to get it hard.
They have withheld the money.
There were also losses
My lord,
on their part as well.
No, my lord. I have gone several times.
2022. It's a writ petition of 2022.
Yes,
and
my
now, my lord, they are, my lord, pressing for
April 1, 2014 থেকে calculate হবে.
Well, interest is to be calculated from
1st April 2014.
Then, my lord, our justification to file our papers will be, my lord, if we can manage to show, my lord, that the delay was on their part, then, my lord, they will not.
This is an admitted amount. You issued a payment certificate.
Admitted amount for the purpose of, my lord, the amount is
For the purpose of what? For payment?
Yes,
Payment certificate is for the purpose of payment.
They will have to also take certain steps, my lord, for the purpose of release of the amount, my lord.
Satisfy the appellate court.
Grateful, my lord.
For the last part, he need not be. He should be grateful for giving that advice.
Well, 2022 at least interest is to be calculated ad hoc basis. Thereafter, on final adjudication, my lord, if my lord.
There's no reason for that.
Well,
You have to understand that.
If
you give a payment certificate up to a particular date,
you have to
immediately after that,
what is the amount we have kept on hold, my lord? That is the
that you have only that withheld amount I have directed you to pay. There may be other amounts also.
No, there is no other amount. That is
Other
not their claim, my lord. That is not their claim. That is their claim, my lord.
Next.
My lord.
Item number 48.
If we are at fault, my lord, thereafter the amount can be, my lord, on final.
Definitely at fault. You will convince yourself when you have instructions to file the opposition. You will find out that you are definitely at fault. Otherwise, you would have had instruction already. Yes, next.
Well, for the petitioner, my lord.
What is
Lord,
the
here is the final hearing matter, my lord. Before I start that.
Thank you very much.
Lord, yes, my lord.
You are such a sensitive, learned advocate.
I have to say it before I start.
Let us come back after the vacation.
After affidavits, my lord.
Pardon?
Only, my lord, I'll leave, my lord, to file a supplementary affidavit where, my lord, rely upon.
Giving copies to them?
Yes, I've already handed over copies, my lord.
Copy yesterday evening. Only one thing, my lord.
Yes. Use the microphone, Ms. Rao.
Only one thing, my lord, will kindly see the supplementary affidavit. He brings on record the final inspection report. Let me kindly complete. My lord, and why he wants to rely on this has not been given here. He just brings this on record. I mean, even if I have to deal with this, my lord, he has to give the reason.
There's a draft inspection report and thereafter a final inspection report. The final inspection report we received only in the month of January 2024. Only for
what have you challenged in the writ petition? Tell me that.
No, in the writ petition, is a disciplinary committee report is there and a proceedings, my lord, where, my lord, I am an insolvency and bankruptcy proceedings resolution professional, my lord. My license has been cancelled. Now, the purpose of cancellation of my license is that an order of the NCLAT. Now, my lord, an appeal was preferred from the NCLAT order before the Honorable Supreme Court. The Honorable Supreme Court specifically held that IBBI should not rely upon the NCLAT order to start the disciplinary proceedings now. Now, my lord, in the show cause notice, I find that whatever is there in the NCLAT order, it finds the same thing in the show cause notice. On that basis, my lord, they have challenged it. And also, my lord, the disciplinary committee which was constituted, my lord, that also didn't have the jurisdiction to do it. But lord, the IBBI
final action was not taken against you.
Yes, my lord, it was taken. My license was cancelled completely.
Even
previously you had annexed the draft inspection report.
Yes, that time was available. Only draft inspection report
was a premise of your cancellation of license.
No, that is one of that.
One of the premises of cancellation of
because
now you have got the final inspection report.
Yes,
you want to bring it on record.
My lord, why I'm saying, my lord, the draft inspection report gives me a complete clean proceedings that I have not done nothing wrong.
But the final inspection report is
also clean. It's also clean, my lord.
You also bring it on record.
I just bring it on record. Nothing else is there.
It's not challenging.
Because, my lord, I'm not challenging it. It's in my favor it is. And my lord, main thing is that is a quorum non juris completely, my lord. The reason is that disciplinary committee who was constituted did not have the jurisdiction to do it. Under the section completely, it is not a.
Yes.
I'll come back, my lord.
Come back immediately after the vacation. I'll
We have filed a detailed affidavit in opposition. So
You have filed.
Already filed.
already filed.
This
I'm
was
saying it
part-
after.
This was
They have already brought on record your document. I mean, this final inspection report.
very well, my lord.
If you deny the veracity of this document, you can definitely.
I have other documents to show, my lord, why this license has been taken.
Those have been annexed in the application.
all has been annexed.
Learned counsel for the petitioner seeks to bring on record a final inspection report by way of a supplemented affidavit. Full stop, such leave is granted and the same is filed in court today and kept on record. Full stop, next para. Since pleadings have been completed in the present writ petition, let the matter be listed for hearing immediately after the oncoming summer vacation. You have handed over an extra copy. This is an extra copy.
I'm taking extra copy, my lord. Lord, can a date be fixed, so that my lord.
It will be in the
why, my lord? My lord, the cancellation has gone already, my lord. 2 years, my lord. It was parted before a bench, my lord.
I'll not fix the date before the vacation. Let us come back.
After vacation only, my lord.
No, we'll come back and see. Several hearing matters are there. Let us.
May have some precedence, my lord. If my lord.
Even today, if I started, I wouldn't finish it.
Yes, my lord. It's going to take some time, my lord.
Unnecessarily keeping it parted. I don't want to block it. If somebody else comes, suppose.
Yeah.
Yes. Next.
Grateful, my lord.
Thank you.
Item number 49.
I am for the petition.
Yes, please.
Lord, the petitioner applied for foreign liquor shop.
Mr. Banerjee, what about service?
Yes. Foreign liquor shop.
All have been served.
Yes. Initially, he obtained temporary permission.
Yes.
Thereafter,
There's no variety. All these matters are
Yes,
coming
yes.
up regarding.
No,
all these matters
card
regarding
shop.
foreign liquor. That's my.
Card shop.
Now start using doing business in
No,
Desi liquor.
card shop. One demand notice was sent. After, thereafter, they have not given any reply.
You are wanting a license.
Yes, thereafter, my lord.
Yes.
My lord, after filing this,
an option.
He's cutting it short. So let him cut short. Then he'll cut shorter.
After filing this writ application, authority
Decided.
my lord,
Refuse.
No, they have the rules has been changed. A fresh application is necessary.
Very good. Do that.
My humble submission, I will do this. Your lordship, petitioner has deposited huge amount. When he applied for fresh application,
That has to be adjusted with. Yes, Mr. Chakur.
No, that I have to take instruction because this has been done in 16 February 2023.
But
we
you
have
take a decision much later.
No, we have given the letter on 16 February. They have received it. Kindly see, they are sitting for 1 year. But it cannot be a matter of right. 16 now again a separate rule has come in. But if I have to kindly see there.
But can you retain the?
If under the law, it is when they had first got a land, they started the business. Thereafter they wanted to shift. Now
They deposited the amount, you accepted the amount, and now you are not refunding.
No, refund is not a matter. They apply it.
Refund is not a matter of right. Accept
In a excise matter, my lord, when
Yes.
they know this would not be refunded. That's why this is a non-refundable fees. My lord, no.
I am not.
My lord, that I have to take instruction. What he has deposited, how much this part. But we have disposed of his application on 16 February 2023. My lord, today we are after 1 year, my lord, he is asking for this. He has not taken any steps.
When did you file the writ petition?
My lord, writ petition was filed
24th February. Thereafter, no, 16 February.
16th February, you.
Yes, and after.
You rejected on 16th February.
Yes.
You intimated him.
Yes.
On 29th, 24th February.
And without annexing this document.
So,
without annexing this document, he has filed it.
No, my lord,
litigation was continuing. Adjust it.
No, my lord.
15th of March.
This is a very sensitive issue, Mr.
15th of March, my lord.
This has, I have to
March,
take instruction. Take instruction. Come back immediately after. I'll keep the matter pending then.
My lord, on which date?
It will remain in the list. After on the reopening, you can take instruction and come back on 24th. Mr. Chakravarti, can you come back on 24th?
Yes, yes.
24th, my lord.
24th, no. 24th, no. 24th, I'm not there, man.
Reopening, my lord.
So I was doing precisely that. You suggested that. Affidavit of service filed to be kept.
We have communicated this later.
Affidavit of service filed to be kept on record. Full stop. Learned counsel for the parties hand over a communication indicating that the rules regarding grant of foreign liquor license have changed in the meantime, and the petitioner has to apply afresh under the new rules. Full stop. The subject matter of dispute in the writ petition itself is the petitioner's application for foreign liquor license having not been responded to positively. Full stop. Next para. At this juncture, learned counsel for the petitioner submits that the petitioner is agreeable to apply afresh, but the amount deposited as license fees on the last application ought to be adjusted / refunded. Full stop. Next para. Learned counsel for the respondent authorities submits that the communication in that regard was made to the petitioner as long back as on February 16, 2023, and as such, there is no scope of any refund. Full stop. Next para. However, it appears that the writ petition itself was filed in February 2023 itself, therefore, making it clear that a litigation was pending all along, and the petitioner was diligent in his approach to the court. Full stop. Next para. Be that as it may, learned counsel for the respondent authorities seeks some time to take appropriate instructions on the issue of refund / adjustment of the amount already deposited, with the fees payable on a new application, if filed by the petitioner. Full stop. Accordingly, let the matter stand adjourned till after the oncoming summer vacation. Mr. Chakraborty, either refund or adjustment with the new application. Take instruction.
I'll take instruction. Only thing, my lord, the instruction to the
that will be kept on record.
No, my lord,
আমি কি বলেছি kept on record কথা?
No. My lord, 16th February, this letter was sent, and he has filed on 24th February. So his litigation is after this letter, without annexing this letter. Kindly consider. My lord has held the litigation was pending.
The letter on 15th of March.
Litigation was not pending. Litigation is pending from that month itself.
No, I am wrong, my lord. They have received on 4th March.
Immediately they approached court after that.
No, before
Mr. Chakraborty, you are saying that they have sat tight, they're sitting over the matter for so long?
They have not challenged this.
Because you did not say previously. Did you say previously in February itself? You said that new rules are applicable.
Yes.
Anyway, take instruction. Don't have to prolong the yes. Take instruction. Come.
This letter is saying that on 16th.
There's a lilt in that. I mean that yes.
Kindly see, your however may apply afresh for grant of.
Your however.
Your
10 marks deducted. Yes.
Apply afresh for grant.
You take instruction. Come back. Make all your arguments in your. Call karo.
Item number 50.
Huh. Oh, can you call? Yes, you are appearing. I'm inviting applications. Yes. 51. Not today. After vacation go target. It 50 too. 50 record করতে হবে না?
My lord, 50.
Oh, 50. Yes.
My lord, this is my application.
Yes.
For my prayer for release after 21 years has been dismissed. My lord,
dismissed. Show me the dismissal.
Your lordship will page 154, annexure P5.
The usual cryptic order.
My lord.
Must
now
be there.
My lord, 4 persons, they were tried for 302.
Right.
My lord,
no, 21 years is sufficient. I mean, let me see the reasons.
My lord, nothing, my lord.
The state sentence review board has met.
My lord, they say so. They say so, my lord.
I'll do this. I'll direct them to file a report annexing all relevant documents, including the decision of the SSRB.
My lord. Few things below. One, the other troubling issue is, my lord, 4 persons, 3 of them on the same ground have been extended that benefit in 2022. And my application not only rejected, after that also there are applications. I have moved the Honorable Governor, the Chief Minister. Those have been kept pending. Noted, nothing after.
Now, this is for, I'll treat this as a premier. Yes, state sentence review board, they say.
They said already. And
Achha,
I have applied. The office is in receipt of an application submitted by.
No, I'll direct them to produce that the minutes of that. Learned counsel for the petitioner makes out a strong prima facie case for hearing the writ petition on merits, since the writ petition has been preferred against a rejection of the petitioner's prayer, a request for premature release. Whose of the petitioner is in incarceration for more than 21 years, comma, being convicted inter alia under section 302 of the Indian Penal Code, and submits that they were co-accused. Three other co-accused persons on similar footing have already been extended the benefit in the year 2022. Full stop. Next para. From the annexures to the writ petition, comma, it is found that there is no hint in the communication of rejection to the petitioner as to the contents of the minutes of the relevant 64th meeting of the State Sentence Review Board. Full stop. Hence, comma, the respondents are directed to file a report annexing, are directed to produce a copy of the entire minutes of the 64th meeting of the SSRB, comma, particularly the portion thereof which deals with the rejection of the petitioner's request for premature release on the next returnable date, comma, with an advance copy to the learned advocate for the petitioner. Full stop. The learned advocate on record for the petitioner shall communicate the server copy of this order to the respondents at the earliest to ensure due compliance of the same. Full stop. The matters shall be listed on June 19, 2024, June 19, June 12, 2024, under the heading upgraded matters.
One humble indulgence. My lord, I serve on all the respondents. On my lord, my learned senior friend Mr. Somrat Sen had already appeared before Justice Sengupta.
আচ্ছা, যেখানে বললাম সার্ভ কপিজ যেরকম বললাম না, কমা দিয়ে ডাইরেক্টলি and slow or through counsel. 12th June it will appear. This will be the only upgraded matter because I'm not upgrading other matters. But I'll be returning from Andaman on 25th. But let it be in the. Should I keep it after that? But you will wait for some.
I waited for 21 years.
No,
4
then.
months, 17 years. So I can wait.
No, I'll keep it on 26th itself. তাহলে returnable date না June 12th না করে June 26th, 2024. Because I have been dealing with these matters regularly. That's why. So June 26th, 2024. Intimate them as an upgraded matter.